Hey folks, hey folks, hey folks. What's good? What's good? What's good? Woo! Let me see if y'all can hear that fan going in the back, baby. That back count suffering. Right? Listen, I can't run that fan and y'all can hear that fan. Oh Lord, people hear that fan. That's so ghetto. Hold on. Can you hear that fan? I think they can hear me. Okay, yeah, y'all can hear the fan. Woo! I don't want to die. No there. What's up? What's up? Okay, let me make sure. Yeah, that other one, the one I had started out, I said, let me try a restream. And then it seemed as if I it seemed as if it was gonna like do this. I think it runs the same technology as StreamYard when it comes to sharing and stuff like that. So I didn't do that. But I'm waiting for the the um the hearing the download and then I can pop it up. Yeah, I got about 16 more seconds for it to finish downloading. What's good with it? What's good with it? So check this out, y'all. I don't know if Queen Brielle was asking me to follow this Senate hearing or maybe this is the one she was telling me to follow. But this is so crazy. Wait a minute. I think something done dropped back the Kales. Hold on. Hold on. Hold on, y'all. Oh, let me see. Let me. Woo! Something done dropped. Hold on, let me go. Hold on. Ashley, hold on, baby. This is the Kale sector. You gotta wait, sweetie. You gotta wait. Now I got to go back in there and change my damn title. I'm gonna be real mad. Can't tell me nothing. Let me play my song real quick. Y'all gonna get used to this man, cause y'all slept on this man. I swear. I believe that heaven must be like this. Ray of sunshine kissed upon your skin. Just say you love me. Make my day go good. Follow gold at the end of such a way you touch me. Makes this life so much more than survive. False alarm is old shit. Okay. Yeah, that was a false alarm, honey. That was some old shit. A lot of times, what them people name is? Pacer. They'll drop in old like old records or whatever in the system. Hold on, let me bring up the video. But yeah, honey. Now, Ashleigh down there testifying in the Georgia Senate. All I woke up just a few minutes ago and I got the notification from Lee saying that she was down there testifying. Could she be down there burning up Fannie now? Could she? Put the damn video. But yeah. So I thought I just thought it was an interesting angle. I knew that, of course, what Fannie had to say on the stand was going to be, earth shattering. I knew what Nathan had to say on the stand was going to be earth shattering. But when the snitching ass friends, and I still have 2 Chainz video, I'm gonna play 2 Chainz video too. The snitching ass friends, honey, that's the shit. Cause see, here's the thing, right? Let me tell you why we follow the angle of the snitching ass friends. We anticipate us over here in the law. We anticipate how the subject of the matter, how they're going to respond to questions, right? We know which way they're going to go, and especially if they're attorneys, okay? We know how they probably going to respond to answers, how they probably not, how they probably going to hide behind objections, all that type of shit, right? And that's what we do. Well, I ain't never been on the stand to rat out nobody. So that wouldn't be my case. But that's how they do when in the hot seat. But I knew an interesting angle to follow to stay on with them snitching ass friends. And look like to me, if she went down there to that Georgia state to testify about the disqualification hearing, she's going to testify about what she has uncovered. That's what you do. If they calling you as an attorney down there, or if you seen just regular people go down there to testify, right? They're giving their testimony on something they've researched or something that they've uncovered by what have you, right? They offer their opinions, things of that nature, right? That's what they do when they testify in front of the Senate and participate in all types of hearings and shit. Yeah, this is interesting. Here's the damn video. You tell me they working on it. Work harder. Oh, it's still downloading. My bad. It's still downloading. So I'm premature. But yeah, but what's up? Let me see who up in here on the record. Hell, let's see who up in here. Well, Purple. Hey, Karen Johnson. Hey, Cookie. Hey, DB. Hey, Smoothie. Oh, you know about India Marie and Anthony David. Girl, okay. Somebody ain't sleep on my people. Oh, that's smooth. Woo! That smooth voice that man had. Oh, my gosh, honey. And them words, baby. What up, Atmos? Yeah, boy, yo town. You know what? When you be driving home and going to work and whatever, do you see like little fires and stuff? Because I'm trying to tell you, all the darn hearings and all that shit, that is burning Georgia down. Specifically, your territory. Good God. Okay, now I can probably get it now. What up? What up, Levi? Wow, that them people job thinking about Selena, I want to kill myself. Oh, y'all, don't stop me to giggling. Hon, I giggle like I be on that stuff. I can't stop. Oh.
For two other committee members, Senator Hatchett and our minority leader, Gloria Butler. I think they're both en route, but we do have a quorum, so we'll call our meeting to order. The Senate Special Committee issued a subpoena on February 28th, and that was issued to Ms. Ashleigh Merchant, who has been in the news quite a bit lately and had apparently quite a bit of documentation that we thought would be of interest. We all heard the topic this morning as is permitted by our rules. Ms. Merchant responded to the subpoena and as required by Monday at noon. And the Secretary of the Senate, Mr. David Cook, has all of the documents produced, and he will keep those in his safe room, I guess we'll call it, David, his repository. I can see you've got a couple of banker's boxes full of records. These are available for any member. You, at your pleasure, just get with Mr. Cook. We are keeping them under lock and key, so to speak, so they will not be made available to the public until we determine whether any of them involve confidential information or not. So we'll have those available. The minority whip took some time last night, and I think he may have been the first person to really review all of the records and spent a few hours there in the Secretary of the Senate's office to review this information. I'm going to make a determination after we have heard this testimony and heard from Ms. Merchant as to whether or not some or all of those documents will remain confidential. I remind the committee members in our rules, you are bound to confidentiality unless things are publicly disclosed. So for now, we will be reviewing some of the documents during this testimony, but I will ask you, Ms. Merchant, to let us know if anything in your opinion is confidential that you would not like for us to publicly disclose for whatever reason, and then I will review the records as well. There are some personal financial records in there that I'm not comfortable at this time disclosing those publicly, but just to sort of set the ground rules here, I will conduct the interview with you. You will be sworn under oath. Ms. Brenda Elwell is our court reporter. She will be making a said that will take a couple of weeks to prepare that transcript, but this meeting.
Hold on, y'all. I forgot which way it ran smoother. So wait a minute. Hold on. Hold on. Let me see. I think I brought it up. I ain't got time to play these games. I want to see how this chick gonna burn them up. Baby, when I tell you she did her job on Big Terrence, boy, I tell you, I'm like, girl. And Big Terrence should have known better. Hold on.
It's now just a few minutes after 9 o'clock. I was waiting for two other committee members, Senator Hatchett and our minority leader, Gloria Butler. I think they're both en route, but we do have a quorum. So we'll call our meeting to order. This is the Senate Special Committee on Investigations. We have issued a subpoena on February 28th, and that was issued to Miss Ashleigh Merchant, who has been in the news quite a bit lately and had apparently quite a bit of documentation that we thought would be of interest. We also subpoenaed her to testify before the committee this morning, as is permitted by our rules. Ms. Merchant responded to the subpoena and as required by Monday at noon. And the Secretary of the Senate, Mr. David Cook, has all of the documents produced, and he will keep those in his safe room, I guess we'll call it, David, his repository. I can see you've got a couple of banker's boxes full of records. These are available for any committee member to review at your pleasure. Just get with Mr. Cook. We are keeping them under lock and key, so to speak, so they will not be made available to the public until we determine whether any of them involve confidential information or not. So we'll have those available. The minority whip took some time last night, and I think he may have been the first person to really review all of the records and spent a few hours there in the Secretary of the Senate's office to review this information. I'm going to make a determination after we have heard this testimony and heard from Ms. Merchant as to whether or not some or all documents will remain confidential. I remind the committee members in our rules, you are bound to confidentiality unless things are publicly disclosed. So for now, we will be reviewing some of the documents during this testimony, but I will ask you, Ms. Merchant, to let us know if anything in your opinion is confidential that you would not like for us to publicly disclose for whatever reason, and then I will review the records as well. There are some personal financial records in there that I'm not comfortable at this time disclosing those publicly, but just to sort of set the ground rules here, I will conduct the interview with you. You will be sworn under oath. Miss Brenda Elwell is our court reporter. She will be making a transcript of all the proceedings, and that will be publicly disclosed for the press if you want to go back and double check and see exactly what was said. That will take a couple of weeks to prepare that transcript, but this meeting is also being live streamed, so it should be easily accessible to the public and anybody interested in this. I'll begin. Ms. Merchant, you are here under a subpoena to testify. I'd like to go ahead and swear you in. If you will please raise your right hand. Do you swear that the testimony that you will give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
I swear I'm gonna tell on everybody.
So, you will just continue with the transcript as we go. If you get hung up at any time and I fail to hit the right microphone and you can't hear who's seeing anything, let me know. The way our procedures work is that I will be asking the questions and minority party will have an opportunity upon request to ask questions as well. I've discussed this with the minority whip, Senator Jones, and he may or may not ask questions towards the conclusion or maybe even at a break. If you want to, just let me know. Ms. Merchant, would you please just identify yourself and let the committee know? You see all our name tags to see who's on here. You know who we are, but let us know who you are and what your profession is, background, etc.
My name is Ashleigh. Elliott. Last name Merchant, M-E-R.
You'll need to pull that mic a little closer to you.
Thank you. And is it okay? I have a notepad just to get two questions at the same time. I like to make a note to make sure that I remember.
The committee knows the rules. We passed them unanimously. If you want to, it's not like a court proceeding where we're going to be having objections, etc. But since you are an attorney, apparently you're very comfortable responding. Okay, yes. Didn't mean to cut you off. Let's just make sure everybody can hear you there.
Thank you. Yes, I'm a criminal defense attorney. I was sworn in as a member of the bar in 2004. So I've been a criminal defense attorney for 20 years. I started out when I first graduated from law school. I came to Atlanta and I did an externship with the Southern Center for Human Rights. And then once I was sworn in as a member of the bar, I became a public defender in Fulton County. I was there for 4.5 years until I started my private practice, the Merchant Law Firm. We had an office in Fulton County at first. Now we're in Cobb County. I'm in practice with my husband, John Merchant, and we do criminal defense primarily.
And do you have any other roles or affiliations? I've seen just press articles about you.
Yes, yes. So I do. I've been very blessed to have a lot of active roles in the community. I was the former president of the Cobb County Bar Association Criminal Defense Section. I was sworn in January as the president of the Georgia Association of Criminal Defense Lawyers. I've been a member of that for 20 years, member of the Cobb County Bar Association, very active in both of those roles. I've been honored with several different awards. One from the Cobb County Bar Association, Defender of Justice, or Champion of Justice, I'm sorry, a couple years ago. And then, I've been honored with Rising Star Awards, Super Lawyers, and the Daily Report has different awards back when I was younger, 40 under 40. Wouldn't qualify, unfortunately, for that anymore. But, and then recently I was awarded at our annual meeting for the Georgia Association of Criminal Defense Lawyers.
Yes,
I was very honored to receive award about my work defending the Constitution.
Oh, yes, yes.
So you are the current president of the Criminal Defense Lawyers group.
Yes, yes, and it's the Georgia Association of Criminal Defense Lawyers. We go by GACDL. We have about 1,500 members right now. We're aiming to get around 2,000, but we're one of the largest defense bars in the country.
And tell us a little bit about your trial experience over these last 20 years.
So I started doing post-conviction work, which is, after a person is convicted, doing appeals and habeas work. Then I went into misdemeanor trial work at first when I was a public defender. I moved into the complex felony division, which is where the majority of my practice has lied. I do about half of my practice is appeals. Appellate work in the Georgia Supreme Court.
What's your number?
The other half.
Leave, I get a number.
I specialize in complex felonies, so anything that's mostly in Superior Court. Every once in a while, I'll have a client who has a state court case, and so I will end up helping them on that, but primarily complex felonies.
And during the course of your practice here in the Atlanta area, tell us a little bit about your involvement. And I'm just going to refer to these as the election interference cases. I think there's 16 or 17 defendants. You are involved in those cases, I know from seeing the news.
Yes.
Who do you represent?
I represent a gentleman named Michael Roman. I was hired late August, early September, I think it was late August, to represent him. He lives in out of state, does not live in Georgia. But so I've been his defense attorney since the time of indictment.
All right. So late August or September of 2023.
Yes, I began working on his case in late August of 23. I think I looked this morning, I filed my official entry on September 1st of 23. And then I negotiated bond for him, walked through the turn-in process and began negotiations with the prosecutor.
What exactly is he charged with? What's the offense he's been charged with?
He's charged with conspiring to violate the Racketeering Act, so RICO. He's also charged with some of the more specific allegations for him are attempted and conspiracy to file false documents. So essentially, I've classified the indictment. The easiest way for me to classify the indictment is there's the folks that are federal officers, there's the folks that are charged in the alternate elector process, and then there's Coffee County. He's in that middle section.
So that's the alternate elector process.
Yes.
And those are the documents that are deemed to be false. They're
Yes.
returned. Okay.
That's what he's charged with. He's charged with false, filing false documents, false swearing, things like that, forgery.
And to be clear, you do not represent any of these alternate electors.
No, I only represent Michael Roman.
And you don't represent Donald Trump.
No, I do not represent Donald Trump.
Your involvement in the case is just for Michael Roman.
Yes, exclusively Michael Roman, and that's my duty.
You have produced quite a few documents to us. Do you have any concerns as to whether any of those documents are protected by attorney-client privilege?
I don't have any concerns about that. I do have some privacy concerns because you mentioned earlier that there were some financial documents that are not redacted, and so those would need to be redacted. That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably sensitive.
Okay. As far as Mr. Roman is concerned, is he given you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense?
Yes, we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay. Most of the members of this committee are attorneys, but not all.
Okay.
And I recognize that the general public will be hearing some of this or either now or later. Tell me a little bit about when you're talking about state's discovery. What do you mean by that? I know, but everybody else may not.
Yeah, definitely.
Okay, well, Levi, did he say it to you better than I do when I say, they ain't talking to y'all? Did the white man say it to you better? I know what you're talking about when you mean discovery and then protective order and all that, but everybody's not attorneys, so can you explain what you mean by that? Did they say it to you better? Trying to tell you that. Ain't mean no harm. I'm just trying to tell you that. They ain't talking to you. Leave that alone.
So we have a statute in Georgia that allows us to do what's called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using.
So long time ago, I explained y'all what reciprocal discovery is, right? Fed government. Hey, you don't have an opt-in option, okay? In some states, there is an opt-in, whether or not you want to opt in to share your discovery or not, right? But with feds, it's all reciprocal discovery.
Using a trial, they also have to give us copies of anything that would be arguably exculpatory. And so in this case, there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that.
Yeah.
But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents. The documents that I actually received from the state through discovery.
Didn't I tell you they go there and they go there and testify about what they uncovered during their goddamn investigation, and and whatever. So it seems like she finna burn their asses up. Big Terrence. Oh, y'all, we are so smart. We knew to stay on Big Terrence ass. We understood what Fanny and old Nathan was gonna do on the stand. That was typical. We're gonna follow up with 2 Chainz. I got her video too. And that's crazy. Big Terrence and 2 Chainz are the only ones I downloaded. And this happened here just now. Cause they gonna be the ones that bust it wide open. Hey, we don't have a lot of time to be fooling around with the side attractions. We're gonna follow the money. We're gonna follow with the people that's gonna bust it wide open. We don't have a lot of time for no watch hours. We know what they're gonna say. Baby, Terrence, you're gonna have to move out of Georgia. Hey, in the words of Debo, you have to move your mama. Big Terrence, that's a no, baby. You hot mouth.
Through formal discovery, and then documents that I developed on my own.
Okay. And out of these documents that you've obtained from the state through formal discovery, that they're obligated to provide defense attorneys to fairly defend your client. Some of those have been deemed to be sensitive and that are not freely disseminated.
Yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that. And if we dispute that, or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state, and nothing was subject to that protective order. I went through and was very clear on that.
And I'm wanting to make sure of this because this committee has made it clear from the beginning, it is not our intent in any way to interfere with the criminal prosecutions. And so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all, or in your motion to disqualify Ms. Willis.
I appreciate that. And I was very cautious because I certainly don't want to go against a court order protecting. So I did not disclose any of those documents.
So tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury. But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I've access to. So it's my understanding Ms. Willis obtained an order from, at the time it was Chief Judge, I believe it was Judge Brasher, who was the Chief Judge at the time, obtained an order to impanel a special purpose grand jury. And I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury. And so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
I've been practicing here a long time, and I haven't seen.
And y'all know what impanel means. Impanel means this is swearing a jury. Y'all know what impanel means.
A special purpose grand jury to basically advise the DA, apparently, or a subsequent grand jury as to whether there's evidence to prosecute. Is that essentially what it did?
That is exactly what it did, yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and with witnesses that were involved in the special purpose grand jury, but that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It's one of the more difficult aspects of our job. So they used the grand jury process, the special purpose grand jury process, to bring in testimony. And bring in, witnesses from out of state. They issued a lot of target letters to people back and forth. There was a lot of people that worked.
And she's saying a lot of stuff, but most of this y'all already know because we done already talked about this because R. Kelly went through most of this stuff. So y'all know about discovery, y'all know about grand juries. We went all through that a long time ago. But so she keeps hollering about these different types of letters and stuff like that. When you are, and depending on what level it's on, right? When you are the subject of some type of investigation or something like that, you're supposed to get a notification, all right? Different states, have one, but the federal government call them target letters, okay? So that's what, and I want to tell you that just in case she keeps going in and on and on and on about it.
Targets and weren't targets who testified, maybe negotiated some type of immunity, things like that throughout that special purpose grand jury.
Yeah. And is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything recorded. So there's a transcript from the special purpose grand jury. It's my understanding there's a transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were recorded and then maybe a section wasn't recorded and then they went back on the record. But that.
So as I told y'all a long time ago, if anybody gets immunity, it's going to be made known to the defense. Anybody get immunity? That you can't. It's a part of due process because here's the thing, right? You can't. That's an admissible part of a defense. Defense when they defending their person, right? Say, hey, would you offer immunity in your testimony here today? For your testimony here today? Yeah. So yeah. Or or if there's immunity on the record, if the people didn't. Well, here's the thing, right? Nobody gonna take no immunity if they ain't got to testify. Because the whole part of immunity is saving yourself of self-incrimination and going to jail and shit. So if you not gonna testify, immunity, why am I even going through this?
It was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Is the state required to let?
And when I mean testify, you could be either testify or, going on there and talking to them people at the Popo station. Okay, so the whole thing when it comes to immunity, I'm gonna make sure I'm clear. Sorry.
But if they granted immunity to any witnesses that may have been utilized in the special grand jury process or in seeking the indictment?
Yes, they are. And, some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and forth.
See, if I let them speak, they'll say it more fancy. So I'm going to try to stop interrupting and just let them speak. And maybe just say, well, no, I can't do that. But anyway, yeah. So you just heard what he said. Big white dude say that we gonna call him Big White. Big White sitting up there in Georgia where they big and white up there, baby. Big White.
Or if there were a lot of in this, I believe this was all public that some of our state representatives, I think the governor in particular, were subpoenaed and there was back and forth over who could grant immunity, who had the power in that office to grant immunity. And that's something that I reviewed in my work on this motion with the DA's office, because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff. And then ultimately it was Mr. Wade. And there's emails where he said, I'm the only one that can grant immunity. I'm the only one that has the power to do this. I'm in charge.
Was he engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but there is an order, and I can review it. I brought some of the pleadings with me, but it was authorized sometime. So he was appointed, the timeline, he was appointed in November 2021 to work on this case. It was sometime after that Ms. Willis sought the special purpose grand jury and got authority to do that. And then that went through, several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or
Yes.
paneled? Okay. And so he was involved from the very beginning of that process.
Yes, and he was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term? A special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor. I don't believe he goes by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no real term for it. I've heard him go by independent counsel, things like that, but I don't really think independent counsel would be an appropriate term because he's not independent. So I've studied, I did not know this before, but I've studied, the structure of the independent counsel in the federal system. They're actually a separate office. They have their own appropriations to have a separate office, and they are kept separate from the U.S. Attorney's Office. So that would be where you get the independent counsel term from, or independent prosecutor. He goes by special usually, so special prosecutor or special counsel. And I think that's because he's not independent.
Is this commonly used in the state of Georgia? I don't know the scope of your practice. I'm not familiar with DAs doing this often.
No, and so I do practice throughout the state, and I've practiced in almost every county in the state at some point in my career, and it is very rare. I've had instances where there is special counsel, but those are very limited, and I can tell you about those. And then I can also tell you what I did to investigate that, because I had the same question. So first,
just so you'll know why we're asking, the scope of this committee is we heard a lot of the allegations, and you, as a matter of fact, made most of them, or made
Right.
some of these public, and
Big
there's
white.
also public, outrage or uproar or concerns about some of the alleged improprieties that you have brought forth, both within the in the system, kind of what's appropriate conduct,
right.
and also financial improprieties. And we're tasked with investigating and finding the true facts, and not just taking the press at face value. And that's why we're asking you for documents, et cetera, so we can independently verify the various allegations that have been made. But we're also specifically tasked with, if necessary, amending existing statutes,
Right.
or creating new statutes to build guardrails or whatever to essentially restore the public faith in our criminal justice system, and its impartiality and its fairness. And I have looked at some of the existing statutes, but it's very sketchy. What is the real authority? And we wonder if we need statutory authority or statutory limitations. And so I want to explore with you a little bit what the authority is for a special grand jury to be conducting a criminal investigation, and also the use of a special assistant district attorney is what I'm referring
Sorry, yeah.
it to. But so that's the context. You have done that research, so help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to find out, because I wanted to know.
Oh my
I knew
God.
both from my practice that it was
Sure.
a very rare process, but I wanted to know, I wanted the data. I wanted to actually see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from. But I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this. And one of them said they haven't done it in years, but they have done it. And they pay between $40 and $40 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for appointed counsel in most counties. And then the other county that did use them, they use a part-time solicitor. And that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to do, they would hire this part-time solicitor. So it was someone who was already a government employee, and they would pay $45 an hour for this person.
Okay, so not a long time ago, I oftentimes be telling y'all back and forth, right? As an attorney, you can get contracts to do different things, right? And this is pretty much an example of some of the things that you could do. When I showed y'all that $11,025 deposit, yeah, that's contract. I told you. So, but listen. So, she is also demonstrating how much investigative work, even though you might have, staff or whatever to do it or whatever. Sometimes you don't have staff or whatever. Sometimes you just, as a part of your job as a lawyer, it is to turn investigator as well. Okay? Even her being in private practice, she does it. She was also a prosecutor. So it's just in the nature of doing things, right? It's just in the nature of doing things. And she's probably gathering this data about who all these special appointees are. She did a wide cast, right? She said throughout Georgia. Did she, right? I mean, she was very diligent, right? She's probably doing that to show where, to say Nathan and whomever else shouldn't have been hired as special, whatever, however he got the job, right? She's probably trying to show where this didn't need to happen, okay? Where it just could have went just regular, the way they assign cases or whatever, and just run the case on through the court. But no, she's probably trying to show where Fannie gave Nathan some kind of, favorability, right? Show him favor. That's why he got the job. Maybe not on his merits, but through Fannie, because she was having sex or whatever. Child, this is messy as hell. And when you have data like that, you show the numbers where, hey, they don't usually do this, but this was done in this situation. It just lends credibility to her argument that, hey, he only got this job due to favor from Fannie, because Fannie used to knock him off. He used to knock Fannie off, however y'all men say, knock us down.
Person to do work. So those are the only people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research. Nobody does this but Fulton County. And the AG's office does it. And so we got a lot of arguments from the state about, well, the Attorney General's office does it, but that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to because there's a lot of conflict issues. And so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts if there's a conflict. And if there's a conflict, you'd have to hire someone who's outside the office. You couldn't hire someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners, you've got people who are representing, people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area. So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience. They get approval for that. They get approval for the appropriations for it. And it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do know the judicial districts. There would be a district attorney for each of those, and so those are who I sent all of this.
It's over 50.
It's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant, outside counsel.
Yes.
And out of those, only 3 of them have ever done it?
Only 2.
Only 2
had ever done it.
Fulton County is one of them.
Only 2. Well, oh yes, I'm sorry. It's 3 counting Fulton County.
Okay.
I did not send an open records to Fulton County on that because I already knew that they did it.
Is there a statute that authorizes that?
There is a statute, and I cite it, if I may, I cite it in my brief.
Feel free.
Okay, thank you. I don't want to misquote it. Let's see. So it's 15-80-20. And how I came to learn that is I actually contacted the prosecuting attorney's counsel early on in this case, and because I was trying to figure out the legality of this. I did open records and I found out how much money the special counsels in this case were being paid. And there's about 20 different people in Fulton County that are paid under this type of arrangement. It's the largest personnel budget office.
Why wouldn't you just hire more assistant DAs and have them in-house?
That's what I didn't understand, and that's what I mean, in my opinion, obviously, I think that's what should happen. But the reason that it wouldn't happen is because if you're hired as an assistant DA, you can't take private work. So the statutes, and they're all in section 1518, 15-18. The one that gives the authority for this is 20. But all of those, if you read all of them, it makes it very clear that if you're going to hire more assistant DAs, they have to be paid the statutory rate. So you can't just pay an assistant DA anything you want. You could not pay them $300,000.
What is that statutory rate?
I don't know it off the top of my head, but it is in the statute. I know that like District Attorney Willis, for example, I think it's around $200,000. And that's one of the top paid people. So most of the people are paid, somewhere between 100 and 150,000, something like that, depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So to answer your question, why you wouldn't just hire an assistant district attorney? First, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels couldn't make that much money, but they also would be limited in practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special prosecutors?
No, how many assistant district attorneys?
No, I actually opened records that, and it was declined. So we actually have a pending open records lawsuit, which I did bring. I asked for that. I asked for how many were hired, when they were fired. So we ended up filing a lawsuit, and that's still pending.
Which is why I never had to have a practice. Dum-dum. He can't do all that. Okay, you can't be two places at one time. Then the people don't allow all that. You know, God damn. Oh my God. This is like last, I think this morning's lesson, I don't know, because I fell asleep. I was in full intention on, like starting off, ending how I started off, but baby, I fell asleep. And I was like, well, shit, they'll figure it out. Y'all smart enough to figure this shit out here. I'm laying down now, so that's why I'm getting tongue tied. But yeah, let me keep going.
Because it just occurs to me, I think there's certainly dozens of them, maybe 100.
I think 100 would be a fair example, or a fair number based on, just my knowledge of it. But there's quite a few. And, if you had a certain amount of money that, they spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys.
Do you know the process in Fulton County on how you approve the budget for the DA's office? Is that something controlled by the county, or does the DA have total discretion?
It's controlled by the county. And I do know, I actually went back and watched a lot of budget meetings. They have their budget meetings online. I read a lot of the transcripts. And so it's very interesting. It's kind of a long answer though. Depending on who you are in Fulton County, depends on how your budget is approved. So for example, the county attorney, if they want to hire special counsel, okay, and pay them hourly, like in this case, they go and they get that approved at the county level. They actually appear in front of the county board of commissioners and say, we need to hire this person at this rate, and they approve the rate, they monitor the bills, they do all of that stuff. So that's what happens at the county attorney's office.
Okay, county attorney represents the county, is not prosecuting criminals like the DA does.
Correct, it's civil. So the county attorney does all civil things. In this case, they actually did end up representing the DA in some of the open records issues, which is a whole other issue. But so the county attorney, the civil body, they actually go and get county approval from the board of commissioners. And there's actually a resolution. So I think I attached as an example in one of my briefs, a copy of a resolution just to give as an example. I'm pretty sure I did. And it's very transparent. They get it approved. Yeah, here it is. It's called a resolution, and it's a resolution authorizing funding for additional personnel. And basically they go and they say, we need this for this project. We need this budgetary item, and it's approved. It comes out of their budget though. So they're not going and asking for more money for the county attorney's budget. They're just asking to use the county money that they've already been allotted for this special counsel. The district attorney has taken a different position. And I was surprised. So I watched hundreds of hours of Board of County Commissioners meetings just to make sure that I wasn't missing anything, that she never went and asked for approval for any of these special prosecutors.
Budget is granted through the Fulton County.
It is.
It's in part of its budget.
It is. So these special prosecutors have been paid a couple different ways. They were paid with state seizure money. So the first, around $100,000 of Mr. Wade's funding came from state seizure money. It appeared from looking at the budgets for the state seizure that fund ran out. So then it started coming from the general fund. But it was money that, so Ms. Willis had a budget right around the time that she hired Mr. Wade and these other special prosecutors. She went and asked for more money for backlog. And so she was given extra money, and that money's been renewed since. It was given to her to hire 55 additional personnel, and it's actually in the resolution. She went in front of the Board of County Commissioners and asked for it.
When was that? Do you know?
I do actually, because I attached it to my brief. So I know the dates of things. September 15th, 2021 is when she presented her PowerPoint to the Fulton County Board of County Commissioners. And she gave a lot of statistics about all the unindicted homicides. It was mainly about homicides. It is, there was some about sexual offenses, but it was almost all about homicides. She said that, why am I here? The great trifecta, crime is on the rise, historic mismanagement, and then the COVID backlog. And so she asked for quite a bit of money to hire additional personnel. It was, I can tell you, That year it was $780,000.
And that's in the fall of 2021, just before this special grand jury was impounded.
Yes. So that happened. She was awarded that money September 15th, 2021. And she actually did get the resolution and the process that you would normally expect.
How much was that addition or increase to her budget?
Not to exceed $5 million.
Wow.
Whoa.
So she was awarded for the end of 2021, which this is September 15th. She was awarded for September until December 31st, $780,000. It said, and then the next year, not to exceed up to $5 million.
So hang on for 1 minute. My vice chairman here, Chairman Dolezal, is way more high-tech oriented than I am.
Okay.
He has downloaded some of your documents that you produced to us that I had asked him to have available so we could see them here. And I think you have produced to us this PowerPoint presentation that Ms. Willis made to the County Commission in September of 21 to allegedly fund a backlog of murder cases, et cetera.
Yes,
right?
that would be Exhibit A to that motion. Yes, that's it.
And is that what we have on the screen here? Let's see if we can flip this one right.
It is.
Hey, y'all. Hey, Cookie, you see that old black lady back there sitting back there, that old short black lady? That's gonna be Carla back there sitting. Hey, the damn Harriet Tubman and shit, making sure the blacks are done right. She gonna make sure the blacks are done right. Hey, that's gonna be Carla just still holding on, making sure the blacks are done right. Oh shit. Oh, baby, I'm gonna get it. Hey, that lady, yeah, that's Carla back there, baby. The blacks are done right. We're gonna make sure Nathan and Fanny is done right. Oh, don't get me. Oh shit, don't get me.
So this is part of her PowerPoint presentation for additional funding over and above her previously appropriated budget from the county.
Yes. Yes, it is.
Okay. All right. So what were the county procedures for approval of funding for, additional outside counsel, or in this case, it sounded like she was going to hire 55 people in-house to help with the backlog. Does the county have guidelines or rules or regulations as to how you get funding approved for either additional staff to work on her backlog of homicides or for special counsel to assist you?
Yes.
What are those proper procedures?
You have to get approval by the Board of County Commissioners. And the statute, so the statute that I cited originally, 1820, that statute actually is the one that it says that you can hire additional personnel like this, but it has to have county approval. So, I mean, the statute says it already. When you're asking about changing statutes, I mean, it's clear in the statute that it has to be approved by either local law or the governing authority, which would be the county in this place. And in this instance, and it's very specific that it can't be paid with state funds.
Anything in that September 15th, 2021 proposal or request for funding that addressed or contemplated special counsel to pursue indictments against folks for election fraud?
No, not at all. And I watched the video. It's online. Her speech, where she used the PowerPoint in the speech. There's nothing about that at all. And in fact, what was submitted was pretty specific. It was to hire 55 new employees, not contractors, employees, in November 2021 and December 2021. And I did open records based on this, asking who was hired and the dates of hire, because I wanted to be able to track that, and that was denied.
And who made that denial? The DA's office or the county?
The DA's office. And I did bring the open records lawsuit just in case you have any questions about that. So it was the county, and I can tell you when I filed it. Let me see. And we went back and forth, and I requested it several times, but it was Dexter Bond at the DA's office who sent a letter back and said, we don't have that. We don't have to give it to you.
He's like the chief assistant for Fonnie Willis.
He is, and he's also the one who went to the Board of County Commissioners whenever they needed funding. So, you know, if they had some large printing, and they had a big rebranding campaign where they had a lot of money that was spent on this rebranding, like posters and things like that around the office. And he had to go and testify in front of the Board of County Commissioners to get that paid because they were not paying it. So he's sort of the go-between with the Board of County Commissioners. His official title is something like Chief Legal Officer or something like that. But he's an attorney.
So you've gone back and reviewed all of the Fulton County Commission's minutes and records to see what requests were made and if there was a resolution granting the additional funding.
Yes. Oh, yes.
Was there ever a request for additional funding for a special prosecutor to pursue these election cases?
No, there wasn't. And I knew that before we got the district attorney's response, but subsequently we got a response from the district attorney's office that said, we didn't do it. We don't have to do it. I'm a constitutional officer. So their argument was, we don't have to tell officer, so she doesn't have to get county approval. She can spend her budget however she wants.
Then why would she have gotten county approval for the other 55 attorneys?
So what I have surmised is that was because those were staff members, and so she went and asked for additional budgetary money. She needed a higher budget. So for those 55 people, she went and asked for more money because she didn't have enough money. And once she was awarded that, it's her position now that she can spend that money however she wants.
Doesn't have to use it for 55 new staff. She can use it for special attorney general.
Yes.
Not attorney general.
Special
DA.
Right.
Okay,
Yes. Essentially, that is their argument in their reply briefs that they filed in court, that they have inherent authority. They don't have to comply with the county ordinances, don't have to comply with the statute.
So they don't have to statute.
That they have, once they're awarded the budget, they can use that budget. However, I mean, how their motion, and I'm happy to send the motion, it's public record, but how their motion argued it was, if they get $5 million, they can pay that to one person if they want, as long as because the voters authorized her to do that. So the county, their position is the county authorizes a budget, and she can pretty much has inherent authority to do it however.
Even though she specifically asked for the money to prosecute backlogged homicide cases in Atlanta.
Yes.
Okay. What's your opinion on that? You think the statute or county procedures permit that?
No, I do not. And I cited several different county ordinances. So when I read the statute, when I read 15-1820, and it makes sense, it makes sense intuitively. As lawyers, when we bill, someone is reviewing our bills. I mean, that's just, that's the process. If you're in private practice, your client authorizes your bills. If you're doing public defense, which I've done public defense, I've done appointed work, the governing agency approves my bills, and they will cut them. They will regularly cut them if they're too high. And so there's always some type of budgetary authority that's reviewing everything. So I thought it was very strange that in this case there isn't one, and that there's really no oversight because it is public money. So I know that it's an elected official, but it's still public money. And I don't live in Fulton County, so it would probably aggravate me more if I did.
Baby, ain't that some shit?
So we have the code section up that you're referencing for prosecuting attorneys getting additional personnel. That's what Mr. Wade would qualify as, correct?
Yes. So under B, that's the section that authorizes the appointment of special counsel. And it says the manner and amount of compensation to be paid is fixed by either local act or by the district attorney with the approval of the county. And so that's where that's our argument that this was not appropriate expenditure because it did not have county approval.
So our state law requires if a DA is going to go seek outside counsel, I'm going to call them, that must be approved by the county commission.
Yes, without a doubt.
And there are only 3 circuits that have even utilized this procedure.
Yes.
Do you have any idea what rates of pay were approved in those other judicial districts, or whether they went through some type of approval?
So one was $40 and one was $45, and the annual amount that they spent did not exceed $2,000.
And what did Mr. Wade receive?
He's received about $700,000 so far.
And what's he paid per hour?
$250 an hour.
Has Fulton County been given any opportunity to approve or reject those bills, or the fact that he's even hired?
No. So, and that's an interesting point. So one of the things that the district attorney argued in their motions was that they don't have to have the actual bills approved. So she is the one that approves the bills. So essentially what happens was he would submit an invoice and she would sign off on it and send it to purchasing, and then purchasing would pay for it. So their argument in their motion was that the oversight is by purchasing saying a pay, that she would be the one that reviewed the time. So Ms. Willis reviews the time and then it gets submitted to purchasing, and purchasing then pays it. And so that's the oversight in her opinion. In the state's opinion, the oversight is from purchasing, but purchasing just gets a bill and pays it. They don't actually look at it and see if the work's done.
Does Ms. Willis do that? Is she required to approve these bills submitted by the special counsel?
So the contracts indicate that the bills are submitted to her. She doesn't sign off on all of them. A lot of them were signed off on by other people in her office, purchasing people and things like that. So there's no evidence that I was able to find that she actually scrutinized these bills or reviewed them or anything like that, but she may have.
And you mentioned that attorneys that are working for state agencies or whatever, including the special assistant attorney generals, submit bills on an itemized statement on what services they've rendered.
Yes, and the attorney general has very specific guidelines on that. What you can bill for, how you have to bill, and is told to remind. There's a reminder that this is public service. So essentially be judicious in your billing.
Right. You voluntarily get under to be able to help the public.
And a lot of people view it as public service.
Are those bills submitted in tenths of? I do some billing, in my job, and it's usually 1/10 of an hour.
Yes.
Are there rules or guidelines or sort of standards of practice and how you bill?
Yes, and that it appears that most of them are intended above that.
Okay. And on the open records request you made to the other judicial circuits, how did those outside counsel bill?
They were very small bills though. They were making less than $2,000 a year. So they were small bills, and they were project based, which I think is also different. They would be hired to do a certain project.
If Ms. Willis had hired a employee, one of these 55 employees, and tasked them with a job of going through a special grand jury process and helping seek indictments, investigate these allegations, what's the most they could have made?
Well, first, she couldn't have hired Mr. Wade because it violates county policy. So she would not have been able to hire Mr. Wade as an employee.
How does that violate county policy?
They have a lot of policies on nepotism, relationships, personal. There's a lot of guidelines in the county policies. So she would not have been able to hire him. It would not have been approved. And that would be something that actually did have to get approved by the county. And because of their relationship, that wouldn't happen.
So she wouldn't have been allowed to hire him because of violations of other county policies.
Yes.
He couldn't have been a direct employee of the district attorney's office.
Exactly.
This process circumvented those rules and ethical obligations.
Yes, it did. So
let's say it wasn't Mr. Wade.
So if it wasn't Mr. Wade and someone else, I believe most of the other prosecutors on this case make around $175,000 annually.
I interrupted you. I'm sorry.
That's okay. That was the answer. So if she had hired Mr. Wade or somebody else as a salaried employee, they would make around $175,000, most likely.
So using this technique that didn't obtain approval and didn't have to follow the ethical guidelines of her own office, she was able to pay him $700,000 over 2 or 3 years.
Yes. And
way more than he would have made as an employee.
Way more. And also he's able to have a private practice, which is significant because you're not able to have a private practice if you're an employee. So that's a big issue.
Have you reviewed his billings?
Yes, I have.
Senator Gozal, will you give us an example of one? I think we have one we're just going to throw up randomly, kind of. Okay, is that an example of the type of invoices he would submit?
Yes, it is. And so
that's an actual one, isn't it?
That is an actual one. And so there's a couple things on this. You asked earlier about the authorization, that stamp that says okay to pay. I believe that's Dexter Bond's signature. So that was one where, Miss Willis didn't approve it or didn't review it, at least as far as we know from the signatures.
But her chief legal officer did.
Right. So they would do that stamp okay to pay, sign it, and then send it to purchasing. But yes, this is one of the bills. And so he had monthly caps, which went up. There were a couple different contracts that were renewed. So he had one contract that expired, another contract, and the monthly cap was $35,000 a month. So that's where you see the total. But this billing is not something you would normally see.
All right. Well, I'm noticing this the day in just a number of hours. There's no real itemization of exactly how much time you spend doing whatever type of task.
Right. There's none at all. And I tried to I also open records because in Fulton County you have a badge to access everywhere. So I didn't open records for his badge access. I was told he didn't have a badge. I was told by other witnesses that he did. So, I don't know. But you would, if you were doing these things in the office, you would. I used to be a Fulton County employee. You have to scan, and they keep track of all of that. So you have to scan your badge to get in to certain places. So if he's doing this, even as a contractor, contractors at the jail have badges. The medical providers have badges. They all have the badges that they scan. I open records to the sheriff and the DA's office, and both of them told me that he did not have a card, an access card. But in order to do this, I would assume he would have to have one to get into the DA's office. And I have been told that he had one, and those you'd be able to see when he went in and out. But I was done.
Anything unusual or irregular about, this is just an example, Bill, about the way he billed?
Oh, completely. I mean, you would never see this. This is what I would call block billing. So one of them, for example, it's 28 hours over the course of 2 or 3 days, team investigation meeting and drafting. I went back and looked to try and see, a lot of these were like drafting, and at the time, I'm not sure what would have been drafted because most of this was during the special purpose grand jury. So there's not really a whole lot of drafting. And we've obviously never seen anything that he specifically has drafted, but I also calculated these team investigation meetings. So the majority of the billing are things like meeting with team. So if you see here, it's got team investigation meeting, then it's got team meeting and argument prep, and then meeting with team. Most of his billing is meeting with team meeting, team investigation, team brain drain. He called it different things like that. But I went through and that's the majority of the bill.
Ooh, child, honey. Nathan. All right. The secret to this is that 1, do the work. Okay. When you are submitting your invoices, make sure your description is more detailed than this, because this is the shit that will happen. And listen, y'all, I'm going to say some places. I'm not going to say most places, but I'm going to say some places. You submit a pretty much a bare bone bill like this, they're going to send it back and say, we need more detail. Okay. So you detail what it is, everything you're doing, what have you. When you do your day completed, and then when you do your billable hours, whatever, that's where you and I'm not telling nobody how to cheat or whatever, because you should be honest on this, whatever. That's where you kind of, whatever. If you're trying to, okay, I just say it like this because apparently I don't know what the fuck he was doing. You're trying to cover something up, whatever. That's where you cover it up at in the hours bill. Okay. But you're supposed to be honest. And if you got a description that explains, oh my God, who is this? They call me on my real line. Let me cut this phone off. Oh, cool. Okay. Sorry about that. Let me see, y'all. Y'all still hear me? So you don't. Officer A has been revealed. Is that what somebody is? Are you talking about in the in that in some paperwork that was just dropped? But anyway, so and you baby, I don't listen, Georgia. I ain't even getting into Georgia. I told you about my horror stories. Let me keep playing. Oh, Jesus. Nathan.
And this wouldn't be standard from what you see at block bill in 8-hour increments instead of, you said, 6-minute increments, or
No,
more specifically, and does not really give a lot of identification of what's being done.
it gives pretty
Bam.
much zero, in my opinion, identification. I mean, this is not something that we would be able to submit to a client.
Exactly. That's
Ever. I can't imagine. I mean, they would, if I billed them $2,000 for 8 hours of meeting with a team on one day, and just research without what I'm researching. I mean, you have to be detailed in your bills, because that's accountability. I mean, that's
bam. See, if I would just kept playing, she would have said it. You can't submit this to nobody. She said exactly what I said. Most people, they gonna send that back like you, Because you got to think, right? Whether you getting a contract from a private entity or public, they want details and what they are paying you for, because guess what? That money isn't coming really out of their pocket. Most of those firms and places like that, they're in groups. They have to submit that to people that needs explanation. That ain't gonna work out. And all of them even numbers like that, that ain't gonna work out. Come on, Nathan. God damn.
It's the only way as lawyers we can be accountable. Our clients aren't sitting in our office while we're researching, so I have to say what I'm doing.
And somebody has to approve it.
Oh, yeah.
And it's ultimately Bonnie Willis that was approving these, either personally or through her designated assistants.
Yes.
And there was a written contract with Mr. Wade and the Fulton County DA's office.
There was, yes.
All right, let's see if we can pull that up, Senator Dolezal. Am I right that there were, I think I've reviewed your documents, that there were more than one contract?
Yes, there were.
Right. Is this the first one?
Yes, that's the first one.
Right, so that says it shall commence November 1st of 2021 and go through October 31st of 22.
Yes.
Okay, so that contract began before there was even authorization to have a special grand jury, and later in November of 21.
Yes, it did.
Okay. Does it specify that that's what his role was going to be? Or is there any way that's disclosed to the public what he was doing?
No, up at the top, I believe it says, let's see, it just says attorney consultant. This one, so if you look under whereas, the first whereas, it says to provide legal services regarding anti-corruption matters. So the head of the anti-corruption unit is a lady named Sonia Allen, and she was the one that was originally in the email that I talked about earlier, negotiating immunity and things like that. So she's the head of that unit.
So the DA's office has their own special anti-corruption unit already in-house?
They do, and they have a director of that. Sonia Allen is the director, or chief assistant. She heads that unit, and she was the one that was originally on the emails negotiating immunity and things like that. And then it switched over to, there was some issue, I believe it was with Governor Kemp, on him testifying when, all of that stuff. And Mr. Wade took over and said, I'm the only one with authority. And so Miss Allen sort of stopped working on the case, and she hasn't really worked on the case since.
From your experience and your knowledge of Mr. Wade and Sonia Allen, does he have any special unique experience or expertise that would make him better at this anti-corruption work than the head of the anti-corruption department in the Fulton DA's office?
No, but I mean, other than no, he would not. But Sonia Allen also hired Mr. Wade in Cobb County before this contract at I think it's like $550 an hour or something to investigate deaths in the Cobb County Jail. So Sonia Allen was the chief. So when Neil Warren was the sheriff in Cobb County, Sonia Allen was the chief deputy. And so she basically ran the sheriff's office. They had a couple different deaths, and there were some lawsuits over access to that. A lot of the local lawyers wanted access to what was going on with the jail deaths. And Miss Allen hired Nathan Wade to do that work, to do an investigation. And so a lot of this came out because they were ultimately sued. So I reviewed part of what I did in this case was I reviewed all of those documents as well. Mr. Wade had to testify because one of the news organizations sued them and said that essentially Miss Allen hired Mr. Wade to try to get around open records, to say that it was an open investigation so that they didn't have to give the jail recordings to the families about how these inmates died. Mr. Wade was a witness and had to testify, and he had billed a lot of money, which I don't have the figure, but I've got the invoices, but he had billed quite a bit of money to Cobb County, but hadn't produced any documents. And so he had to testify, and his testimony was that everything was in his brain, that he didn't have any written documents from anything. That's where
That was some years before.
that was some years. I think it was in 2020, maybe. It was right before Willis took office. So when Miss Willis took office was the same time that Mr. Warren, who was Miss Allen's boss, was no longer the sheriff in Cobb County. So a new sheriff was elected, Craig Owens, and so he was elected in Cobb County. He took over that office. Miss Allen no longer had a job, and she was hired by Miss Willis to head the anti-corruption unit.
So from you, there were other special counsel that were hired by Ms. Willis?
Yes.
And to work on these specific RICO cases or election fraud cases?
Yes. So there's several. And so that's kind of a longer answer because there's a couple different classifications. Mr. Wade was, at the time that he got this contract, he was law partners with a gentleman named Terrence Bradley and another gentleman named Chris Campbell. So it was a three lawyer firm. Both Mr. Wade and Mr. Campbell had contracts also. They actually had contracts before Mr. Wade. So they both got contracts the month that Miss Willis took office. They got contracts to do what's called taint work, which is essentially if, for anti-corruption, because it's a lot of police brutality cases, if there's things that could be considered privilege. So let's say the police union had a lawyer doing an investigation, they subpoena those records, those are privileged. Somebody has to review those to see what the DA's office can actually see. So it's that wall, that privilege wall sort of. So both of Mr. Wade's law partners had contracts to do that privilege review, that taint review, conflict review.
So you're seeing if there's tainted evidence, something that should not be revealed might damage another case, or it might be privileged and not subject to disclosure.
Right, exactly. And when one of the best examples I could give is, in the Tex MacGyver case, he was a lawyer. They seized a lot of his documents. A lot of them were attorney-client privilege related to other people. The DA's office was not able to just go through all of those. So they had to have a taint team, is what they call it. And so that taint team, and I don't know which cases, but the taint team involved Mr. Bradley and Mr. Campbell, who were Mr. Wade's law partners.
And basically, they're reviewing documents to see whether they should be produced or privileged by attorney-client privilege or something else.
Exactly.
Not exactly prosecuting criminal cases. No.
No, they weren't prosecuting criminal cases. But Mr. Wade testified that they were law partners at the time, so that he would have shared a third of whatever contracts they got. So those contracts he was getting paid essentially from the law firm as well.
Right. So on this case, these RICO cases that you're involved in, one of them, there are other special counsel in addition to Mr. Wade?
Yes. So there's two other on this case particularly. There's a lady named Anna Cross and a gentleman named John Floyd. And John Floyd has worked with the DA's office for many years. I actually was involved in another RICO case year before this one, which luckily my client resolved his case, so I'm no longer involved in. But that case, John Floyd had also helped craft the indictment. And, he's sort of known as a go-to person for racketeering cases. So the district attorney would regularly call on him to help in drafting indictment. Anytime we would file what's called a demur, which is a motion to quash an indictment, he would usually be the one that came and argued it. And then Anna Cross was also hired, and she really focused on the work in federal court. And both of those sort of make sense to me because Fulton County prosecutors they're not necessarily barred in federal court. It's not something that would be required for your job. When I was a public defender in Fulton County, I wasn't barred in federal court. I had no need to. I wouldn't have paid the dues, wouldn't have done that. So, it's not something that would be required for their job, but Ms. Cross is experienced in that. So she was hired sort of as a subject matter expert to litigate some of the federal removal issues in this case.
Did those two individuals have contracts with the DA's office as well?
They have had contracts historically. They do not currently have contracts. It's very odd.
Did you review their billings?
I did. I reviewed their billings. Stark contrast. So Mr. Floyd, for example, he was only paid at a rate of $150 an hour. And same case. And he
more experience and expertise in RICO cases.
I mean, everybody would agree. I think that Don Hoffman is one of the preeminent experts on RICO. I believe he testified in front of the Georgia legislature when RICO was passed.
Did he have to submit itemized invoices?
He did, and his were very different. His were significantly reduced, and the big difference was he billed for the time that he was working on the case, not necessarily like 8 hours for team meetings.
Do you have itemized billings?
Very much so.
And
Yes.
what increments did he bill in?
I might have some of his contracts with me, but it was either 10 or 15-minute increments. And so did Anna Cross. Now, Anna Cross was paid $250 an hour. Anna Cross is very well known, very experienced appellate, federal lawyer, does a lot of complex litigation. She was a DA for many years, handled a lot of high profile cases for the district attorney's office. I mean, I know her back from when, we did death penalty working cubs together 15 years ago. And then she went to DeKalb County and prosecuted a number of high profile cases there, but just very well known. And her bills were also submitted, but they were the same rate. They were $250 an hour, but they were much lower bills, not anywhere near the bills that Mr. Wade did.
Do you know how much Anna Cross has received during the course of this criminal prosecutions or
I'm not sure.
investigations?
I might. Let's see.
Okay. You said Mr. Wade had about 700,000 so far.
Yeah. Oh, Miss Cross was under 100,000, I believe.
So if she's under 100,000, what about Mr. Floyd?
Mr. Floyd, much lower, even lower than Anna Cross. He has not billed in a while. So I was subpoenaed, or not subpoenaed. I did subpoena, but I also did open records for all of his bills. We've not been provided anything recently from him. So I'm not sure if he actually did bill because his contract said you have to submit the bill within a certain amount of time. So I'm not really sure. They stopped responding to my open records requests, but when they did respond, they were very, very limited, very small bills.
Okay. And your open records request was to whom? The Fulton County government, the commission, or the DA's office?
I did them to all of them. And once especially that they stopped responding to them. So they have a portal, and if you go to the DA's office and you click open records, it takes you to the Fulton County portal. So if you try to submit it to the DA's office, it necessarily goes to a portal for the entire county. So you have to submit it through those. So that's where I would submit it. You can designate, I think this is the DA, I think this is budget, things like that. So I would be over inclusive just to make sure that I wasn't missing somebody. But every single time they would route it to the DA's office. So I would get a response that said it's been routed to the DA's office and, we're waiting on the response. There were one or two that I got from the county that didn't appear to be routed to the DA's office.
And so who's refusing to produce these records to you?
The letter came from Dexter Bonds at the DA's office.
And
Dexter
that's
Bonds.
why you filed a lawsuit against the DA's office to force them to comply with open records.
Yes.
Okay. That's still pending.
It is still pending.
Fulton County Superior Court.
It's Fulton County Superior Court. It's assigned to Judge Krause, I believe. And the county attorney contacted us and says they're going to be responding. So the county attorney is actually defending that lawsuit.
And so they're telling you they're going to respond to the case or respond to the request now? You're waiting
I
to
believe
see.
the case. I haven't received any documents. So.
Fairly recent filing you filed there, that lawsuit?
Yeah, so we filed it in January, and then they had a little shutdown in Fulton County where nothing was able to be file stamped. Our process server couldn't serve it until it was file stamped, and the Odyssey, the e-file system in Fulton County was hacked, and so it was shut down for a while. So it took us a little bit of time to get a
Yes,
file
we
stamped
know.
copy back, but it's now been served. But it was filed on January 30th,
Of 2024.
2024, and I have a copy, which
I don't have that. If you would provide us with that, and we'll give it to the Secretary of the Senate as a supplemental response to the subpoena.
I'm happy to. This is a clean copy.
Okay.
Yes, so you all can.
So what's the relevance to you? Why did you seek these billing records of these attorneys?
I wanted to compare the different billing, the different styles of billing. Also, there had been an allegation that I was singling out Mr. Wade. And so I thought it was relevant to see the rates that the other attorneys were paid, their billing, what type of billing, if they billed for everything. Just for example, when we're in court, one of the prosecutors may be arguing, Mr. Floyd and Ms. Cross aren't there billing. But Mr. Wade is always there. So that was one thing that I noticed. And I understand now that their response is that he sort of is like a case manager almost. So I guess that would be why he's always there. But I wanted to compare them and see.
Okay. I think I want to show a couple of things. Senator Dolezal, I want to show some of the other billing records, particularly the ones that show the trips to DC. We hadn't had but a couple of days to review all your documents, and I skimmed these records because I wanted to know exactly what was going on. You'll see highlighted down here at the bottom on November 18th of 22, interview with DC White House, 8 hours. Do you know what that references?
Based on another motion that was filed in our case and the arguments that were made by the DA's office, I believe that was when they met with the Department of Justice. They met with the January 6th committee. So one of the co-defendants filed a motion to try and get some documents, and the state had to respond. It was a motion to compel. I was there for it. I joined it, but I didn't litigate it. And the state said that they had to meet off campus. So because they didn't have a record of it, I guess you have to have a record if you go into the White House. And so they met with the January 6th committee off campus, and they said they had a really hard time getting that meeting. And they had to have someone who had some source or something to get them to agree to the meeting. But that's what, so the motion to compel was based on this entry.
Yeah.
And this entry, in response, they said they were meeting with the DOJ and someone with January 6th.
There's also an entry, May 23rd, 22, travel to Athens conference with, what is that, White House?
Yes. And we've tried to figure out what and who that was, because there was something happening at UGA Law School, and so we just assumed that it was someone that was there, and that's why they met there.
Do you have reason to suspect, or can you confirm whether or not Ms. Willis or Mr. Wade were coordinating with the Biden White House in the course of this investigation and prosecution?
In the discovery, they've got a lot of our discovery involves the January 6th. I mean, a lot of what we have in discovery is the same stuff that other places have. So they had to have gotten it from somewhere. And they also, they read a lot of the testimony. They played testimony in the special purpose grand jury. So, I don't know how they got all of that, but they got it somehow. And then, there's one of the other things I did was I did a open records for the White House access, and we had records that Ms. Willis and the mayor of Atlanta were at meeting with the vice president.
Okay, and so this is the access history. How does that work? The White House keeps records of anybody who comes in has any kind of official meeting for sure.
Yes, and my understanding is it's highly regulated who can access the White House, and so you have to apply in person or apply ahead of time, and then they give you a time when you make the appointment, and they give you a time when you're allowed to be in and when you have to be out by, and they track you. And I mean, that makes sense. They don't want anybody lingering in the White House, but they keep that. And so they're called WAVE records, I believe is what they're called. And I'm not sure what that's an acronym for, but they're publicly available. They're open records.
And this record that's shown on the screen shows Fonnie Willis was a visitor with V. POTUS. I presume that's Vice President of the United States.
Yes, it was.
And what was the date of that back in, was that February sometime of 23?
February 28, 2023.
Is that before the indictment?
Yes.
Okay. Any further explanation of why Ms. Willis was meeting with the Vice President of the United States?
No. I know Dexter Bonds, and I believe that's the same one that Mr. I think it's Dickinson or Dixon, the mayor of Atlanta, was also there.
Okay. I want to take a short break. We've been going at this for a while. Let's take a somewhere between 5 and 10 minute recess, and we'll be back. Thank you. We're in recess.
Ooh, honey. So, she telling all the church's business.
In case
Is for the
billing practices.
Honey, she telling all the business.
One minute. We got a couple of committee members on their way back.
Oh, okay. We do got something to read. We do got some R. Kelly shit to read. It's Officer A shit. Officer. Okay. Robin Chapman. I know you be talking shit about me, but yeah, you came in. I think Shawdad already told me about this, but yeah, we gonna read this. Hold on. Let me save it.
In order. We were reviewing the billing practices, the contracts that the various outside counsel had, and I pulled up here one section of Mr. Wade's bill for the really early on in his involvement in the case. As I recall, it began on November 1st of 21. So this would be out of his first bill. I see on November 5th, prepare case for pretrial, 24 hours on one day. What do you make of that?
I mean, I thought it was astonishing that you didn't sleep for 24 hours. I've been to trial. I'm sorry, I've been to trial and had to work long hours, but 24 straight. But we did question him about that at the hearing, and he said that that's when it was concluded. So how he explained it was November 5th is when the work was concluded. And so he had done that work up until then, and that he only billed when it was concluded. So he said that the 24 hours, who knows when it spanned, but that how he billed
would have had to be between November 3rd and November 5th, though, right? So it had to be on the 4th and the 5th, 12 hours a day.
It had to
at
be.
Least.
And the other thing that I noticed with this is prepared cases for pretrial. At this point, it says anti-corruption unit. His two law partners are the conflict lawyers for the anti-corruption unit. So you've got law. I mean, it's like my husband couldn't represent someone who's adverse to me. Like my husband is my law partner. He can't be doing privilege review on a case I'm prosecuting. So he's consulting on anti-corruption cases for the DA's office, where his two law partners are doing the privilege review at the same time. That's one, that plus the 24 hours are the two things that really struck out to me.
So, but the only role he had was this prosecution of this election fraud.
Yes.
Okay.
Yes. The only role.
Okay. So when it says anti-corruption, that's the corruption we're looking at, election interference.
Yes. He's never in their case.
All right. Let's see that other bill there, Senator Dolezal. All right. So here's another one. If you can see that, okay, this is the one we put up earlier. It looks to be much more specific date-wise anyway than just, those 24-hour chunks like that.
Right. I mean, it's more specific, but it doesn't say what, like, just for example, team meeting and argument prep. Argument prep for what? I mean, normally when we do bills, we would say, argue motion to dismiss or argue whatever the motion is. Research. What are you researching? Researching statutory privilege, whatever it is.
Now, this one, he shows date ranges, it's over multiple days, like down at 426 to 427, 18 hours.
Damn.
I'm reading that right, or 16 hours. But on that previous one, he just has one day, 24 hours.
Yes.
And you say these are approved by Fonnie Willis. By contract, she has to approve these billings.
Yes, she does. And those are approved by her. So if there were any questions, and as a lawyer, when we submit bills to clients, they regularly question, and I know when I've done appointed work, they regularly question that as well. You have to list exactly what you're in court for, exactly what you're drafting. You can't just say prepared cases. You've got to say, what did you prepare? What did you draft? So, I mean, the county in Cobb County, for example, they make you actually attach motions. If you do like an appeal or something and you're billing for that, you have to actually attach it to prove that you did the work. I did go back at the break though, and I have an answer to one of your questions earlier. Just wanted to clear up. You had asked me when the special purpose grand jury had convened. I looked, the state filed a response. So this is DA Willis's response that was filed on February 2nd. They wrote on
this response to your motion to disqualify?
Yes, sir. Response to my motion. On page 13, they wrote, shortly after his appointment in January 2022, District Attorney Willis petitioned the Chief Judge of the Superior Court to convene the Superior Court judges to consider her request for the special purpose grand jury to conduct an investigation into the facts and circumstances relating directly or indirectly to the possible attempts to disrupt the lawful administration of the 2020 elections of the state of Georgia. And they attached that exhibit. So you had asked me earlier when she petitioned. So it was, in their own words, shortly after his appointment.
Okay. So this whole, the cases are about attempts to disrupt, because obviously Georgia certified Biden as a winner. He got inaugurated, that following January. And this is years later, we're having this whole investigation.
Yes, attempts. And my client specifically is charged with attempt and conspiracy. So he's not charged with actually doing a specific act. He's charged with conspiring and or attempt, depending on which section you're talking about in the charges.
Some of these items draft any documents to your knowledge, or
No.
prepare any legal documents at all?
No, not that I'm aware of. And that
Did
would
he
be
sign any pleadings as if he was the drafting attorney?
no, and he's not the one that usually files them. Will Wooten is the one that usually does the filing. There's two other prosecutors that also do it. Alex, and I don't want to butcher his last name, starts with a B, but he does it. And then Grant Rude. Anna Cross has also filed pleadings, but not Mr. Wade.
In your review of all of his billings, did you ever see where any of his time or bills were cut or reduced by whoever was reviewing them and approving them, either Ms. Willis or her deputy?
No, I never saw any questions. And her response or their office's response doesn't indicate that was ever done either.
And your experience when you were doing like your public defender work, that you were reviewed and they cut your time?
Oh my gosh, yes. Yeah, when I first left the public defender, I had a couple clients that were in the appeal process, because I was at that point, I was in the appeals division when I left, and I didn't want their cases to linger, and I didn't want a new lawyer to have to kind of just, pick up right when they were going to the, appellate courts. So I kept some of them. Some of them the judges appointed me, and so I would be paid, think it was $50 an hour, $45 an hour, something like that. And then some I just took pro bono, but I had to get those bills approved. I mean, and they were regularly cut.
On Mr. Wade's contract, $35,000 in any given month.
Yes.
Yeah.
And that was not, so the original contract before the special purpose grand jury was started was a lower cap. This was the cap for the majority of his work during the special purpose grand jury. And then now, so he had a contract November 1st, 2021 up until October 31st, 2021. And the cap was lower for that. Then there was a period of, I think it's 15 or 16 days where he did not have a contract. Which also happened to be one of the times we're out of town. But so they re-upped the contract November 5th. Cap was significantly higher. I mean, like, I don't remember the first cap but it was not 35,000.
Here is a document you produced. I think you prepared this summary that shows all the payments that he received.
Either I did this or this might have come from Fulton County purchasing.
So that
Yes, this was produced from Fulton County. Yes.
and what's the total? Is that just, my eyes aren't so good. What that looks like 22 all the way through 23.
Yes, 22 through 23. So, and so his first bill would have been paid in January of 2022. So he billed for time in November and December. And then you see those two bills. And so those were $15,000. I believe that was the cap. So in January, he was paid for $15,000 for work in November. And then in December, he had work totaling $15,000, and he was paid for both of those in January.
That's why there's those top two invoices for $15,000.
Yes, that's why there's those top two invoices. And they produced some other documents to me as well that showed which funds they came out of. So I was able to track which ones came from state seizure money and then which ones came from county general fund.
And that was all before this grand jury was even approved.
The grand jury was not approved until June of 2022.
Okay, it was requested in January.
It was, and I just looked that up at the break. So it was requested in January. It was approved in June. Shorter, actually. But what happened was they started picking. So it looks like they started picking the grand jurors on May 2nd of 2022, and they actually started hearing evidence June 1st of 2022.
Okay, so lots of this time was way before he would have been having to question any witnesses or attend grand jury hearings or anything.
Yes, he could not have attended a grand jury hearing until at the earliest May 2nd.
You were talking about the experience and expertise of the three outside, I'm gonna call them outside counsel, because they were not direct employees of the DA's office.
Correct.
Had Mr. Wade ever tried a felony case, prosecuted a felony case before this, to your knowledge?
No. That he has never prosecuted a felony case. And I asked his law partner that, who had been his law partner for some time, that he had never prosecuted that. I also did some independent research in the metro areas where I knew that he had worked in Cobb County. So I looked to see if he had ever been filed as a prosecutor in Cobb County for felonies. And he was actually just a solicitor, and solicitors is, because you said not everybody may understand the difference between solicitors and district
We've got an
attorneys.
ex-solicitor on this panel, so don't say anything negative about it.
So he can tell you all about it.
They
But
prosecute misdemeanors,
They
right?
yes, and in Cobb County specifically, they prosecute misdemeanors. Yes.
Okay. It looks like he's pretty much hitting the maximum that he was allowed to under his contract.
Yes, most months he did.
And this is through that block billing that was not specifically itemized exactly what he was doing or how much time on each task.
Always block billed. He never itemized bills. Never was specific.
What were the caps for the other two special counsel? Were they also limited? I assume you've received their contracts, or did they have a written contract?
They did. So they had written contracts, and I do have those, and they did have caps. They were significantly lower than Mr. Wade's. They do not currently have contracts. And I just found that out at a hearing because we had asked for that. We had asked for it in open records, and then I had subpoenaed it as well. Pretty much every subpoena I filed for the hearing, the state filed a motion to quash, including this one. And Ms. Cross was at the hearing, and she said, I can just tell you right now, I don't have a contract. So I had thought, I was under the impression that they just weren't giving me that contract. I had no idea that they just didn't have one. So apparently right now, Mr. Floyd and Ms. Cross don't have contracts.
Do you think that was intentional so that they don't have to disclose how much they're earning?
I think it was sloppy.
Does Mr. Wade have a current contract?
Yes, he does. I also think that, I think it may have been, I don't know if it's disclosure, but I can tell you that they've changed, since I started looking at this, they've changed what they put on the public documents. I used to be able to go to Open Checkbook and see every time he would get a check. And since I filed this, none of them have come out. So I don't know if he's not being paid anymore or if he hasn't filed any invoices, but the invoices are due, I believe, 30 days after. So, you know, they regularly came up, but now all of a sudden they don't.
Okay. So eventually you sought to disqualify Ms. Willis from serving as counsel and prosecuting Mr. Roman's case.
I did.
Okay. Can you pull up that motion? That motion was filed here in January. I think it was January 8th of 2024.
Yes.
What was your motion to disqualify based on?
It was based on a number of things, but it was based on mostly the fact that Miss Willis and Mr. Wade had a romantic relationship and they had been traveling and he had been paying for a lot of that travel. So there were a couple different.
Let me pause this for a minute, right? I don't know how many people want to take a vote at this, because I can stop this now and, you know, pause it for a minute and read the BOP Officer A shit and then get back to this. It all depends on what y'all want to do. Y'all want to hit a R. Kelly shit first or want me to continue into this or whatever. But let me say this, right? At some point, and I don't know how y'all feel, but and I'm beginning to think, and this is no shade to nobody. I promise you this is no shade, but this is just what it is. Okay? I don't know who's the weakest at this point. Women or men. Now, historically, it has been women. All right? And but there have been times where women have been the stronger vessels of the two. And at some point, and when I say this, at some point, I don't care how you like people, how much you don't, whatever. I think you always should tell the truth. All right? As much as you can. If you ain't going to tell the truth, just don't say a goddamn thing. Okay? Which sometimes that makes you guilty by omission. But at least you're not furthering some bullshit that you don't know is the truth or not. And I don't care how much you like people, how much you feel sorry for motherfuckers, how much you dislike this one, like this one, or whatever. Fuck all of that. You motherfuckers don't know each other. We don't, and even if you did, you don't have no goddamn nobody shit out here. And I'm gonna read this BOP Officer A bullshit. But I ain't taking up for nobody. I promise you I'm not whatever. But I'm a motherfucker, a real one. And I'm going to say what I know is real. Now, we sat up here and see these motherfuckers sit up here and try to make like Sylvia was Officer A. Knowing goddamn well this one was no motherfucking Officer A. And if you listen to her the little bond hearing or whatever they had on Zoom, they saying like she stayed in Georgia for, I wasn't 22 years, some kind of, you know, which almost made it impossible for her to be a motherfucking Officer A. And I think most of you motherfuckers knew this shit and still carried on with the bullshit. You motherfuckers can't come out here and talk about nobody. Because you did motherfucking dishonest on the motherfucking record. Running around with bullshit that you know ain't the truth. And that's just one example of other shit. I can't walk. I can't do this. I do all this old stupid ass shit. And there's all other examples of other motherfucking bullshit that I can go on and on and on. But I'm just saying. What are you talking about? Oh, thank you for your payment. Oh, you know, I already took the money out. Ooh. Anyway, so Sorry about that, y'all. But you know, and I'm not gonna sit up and you motherfuckers, y'all say this bullshit. And then when the truth come out, you won't correct yourself. You won't none of that. Cause you some dishonest motherfuckers. And I believe that the womb you come from was dishonest. Yeah, I ain't talking about your mama directly. I'm indirectly talking about her ass. Yeah. Something wrong with you motherfuckers. And I don't know why y'all motherfuckers continue to follow up with the bullshit. Because that makes me think that you're about bullshit. And now I'm looking at you sideways. Yeah, everybody done some bullshit to each other. Granted, yeah. But how far do you go with the bullshit? And do you run around with shit that you know that's false? Who does that? Those type of motherfuckers, I can't fuck with you like that. You know what I'm saying? I can fuck with you, but I can't really fuck with you like that. Because I don't know what kind of shit you be on. I really don't. But it's weird to me. That's some weird ass shit. But I wanna I don't have no vote yet, but I wanna read this motherfucking paperwork. I'm anxious. Hold on. Let me take little hot mouth and ass Ashleigh down. Cause you know she gonna burn up the house of Terrence, Nathan, and goddamn Fanny. So let me put this topic up here. But it's ridiculous. But if y'all don't if I don't see y'all cussing these motherfuckers out or saying something about these motherfuckers that ran with this stupid ass shit because a known goddamn liar started the shit and tried to act like they didn't start it, in another goddamn clout chasing ass liar picked it up, then another ignorant ass motherfucker ran with it and all this other crazy shit. If y'all don't pay, I can't with y'all. I can't. Yeah, don't fuck with me because I wouldn't fuck with you. Let's be honest. That's honest. I can't roll with no motherfuckers like y'all, baby. Nope. Hold on. Did they say? Well, I haven't read the paperwork. I think they said she's been revealed. So I don't want to say revealed until I read it. You know, that's just how careful I am with the record because I don't know. Okay. So let me put that paper. Let me get this paperwork up here. This is crazy shit to me. I mean, baby, it better be Sylvia. It's dumb shit. I mean, oh. And here's the thing, people. I'm gonna say what I want to say. I don't look for people to take up for me and all that stuff like that. That's not what I come out and try to, if I do speak honest on the record. That's just in me. I ain't looking for nobody. Oh, well, Sylvia, take up for me or what? No. That ain't the shit I do. It is what it is with me. Because bullshit is bullshit. Just ridiculous ass shit. Just get the fuck on. I mean, all kind of lives and shit was done with this too. So it better be Sylvia in this motherfucker. That's all I know. When this paperwork come up, and if it's a name, or if it's a description, it better describe a short woman with platinum hair. Well, I'm going to talk about you motherfuckers. You motherfuckers, especially you motherfuckers that let Google be your friend, or any kind of man-made apparatus that pull from Google be your motherfucking friend. Stupid. Hold on, let me see. And I'm going to screen share the paperwork. I ain't been on here a minute, baby. I'm looking like, how to do this, how to do this. You know, I want to do paternity tests. You know how to, because it'd be so dramatic. In the case of such and such, such and such, Johnny, you are not the father. Oh, that's what I want to do. All right. Okay, so it says unopposed motion to amend complaint to name and identify unknown BOP officer A. Okay, maybe it's a revelation. All right, plaintiff Robert S. Kelly, by his undersigned attorney for his complaint against the United States of America, moves this court to amend his complaint to identify and name defendant unknown BOP officer A, whose identity was just revealed by the defendant, United States of America, in their Rule 26A disclosures. On November 13, 2023, plaintiff filed a complaint against the defendant, United States of America, defendant USA, and certain unknown BOP officers, and defendant Keeby for negligence, invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton conduct brought under the Federal Tort Claims Act, FTCA. Plaintiff also brings suit against the unknown defendant, BOP Officer A, for violation of the Computer Fraud and Abuse Act, CFAA. On February the 5th, 2024, defendant USA filed an answer to the complaint. Defendant Keeby was served on January 22nd, 2024. Defendant Keeby has not timely answered and is currently in default. A motion for default is forthcoming. Oh, Lord. Come on, Tasha. On March 4th, 2024, plaintiff and defendant USA exchanged Rule 26A disclosures. Defendant USA disclosed for the first time the identity of defendant, BOP Officer A, who is now known to be Tawana F. Ingram. Oh, Tawana! Lord have mercy, Tawana! In light of this recent disclosure, plaintiff now moves to amend his complaint to identify unknown BOP Officer A's defendant, Tawana F. Ingram, a former BOP officer. The current scheduling order permits plaintiff to amend the complaint, including to add any additional parties until August 5th, 2024. Plaintiff does not seek to add an additional party, but simply to identify unknown BOP Officer A by her true and correct name. Defendant USA has no objection to the filing of this amended complaint. Plaintiff has attached a proposed First Amendment complaint to this motion. Let me see this for reading. Okay, I guess we can. All right. First Amendment complaint. Plaintiff Robert Kelly, by his undersigned attorney for his complaint against the United States of America BOP Officer Tawana F. Ingram, unknown John and Jane Doe BOP officers, collectively BOP defendants, and Latasha Keeby, also known as Tasha K. Introduction. Plaintiff sues the United States of America BOP Officer Ingram, unknown John and Jane Doe, BOP officers, and Latasha Keeby for negligence, invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton conduct brought under the Federal Tort Claims Act, FTCA. Plaintiff also brings suit against defendant Ingram for violation of the Computer Fraud and Abuse Act, CFAA. Plaintiff is a high-profile prisoner of the BOP. He is a Grammy Award recording artist and a nationally recognized celebrity. Okay, so all of this, and basically, if y'all kept up with the other motions and shit that I've read, all you should recognize is that they pretty much replaced her name, as they should, since they have her name now, into the lawsuit. So as much of the read is going to be the same. All we not have now is a name. So they just pretty much took whatever their original filing was, removed unknown officer Bill P, and then put her name in there, and then state the allegations and all of that. As you can see, it's the same thing. It's just a repetitious that they bring in Matt Locke again. The true view information. They talk about jurisdiction and venue. That lets the court know that this is the right place in order to hear and try this case. It's just a repetition. That's just it. Just inserting her name in there. Now, y'all want me to go over what we already know? We can, but I'm just telling you, this is just a repetition. Okay? And just to think, this old space act setup that talking about, he can challenge, he break shit down. Nobody do it better than him in the lead attorney. Ain't nobody in the world believe that shit. Anybody that says the word WANTON pronounces that as wonton, as a wonton that you eat from the goddamn Chinese restaurant. That does not mean that. Dumb. But anyway, so I'm taking a little abbreviation. Let me drop the link if somebody want to come up here and speak on this before we get back to Ashleigh. Burning down in Georgia and taking the niggas with her. But don't worry. We got Carla sitting on the bench making sure that everything goes right for the Negroes. She's sitting over there with Big White. Shit. I still got to pin my link for all these people that want to challenge me on the law. I'll pin this motherfucker up here. Bring your ass on. I'm making time. Don't you know now is perfect time? Oh, hold on, y'all. Y'all let me know if y'all want me to continue to read, because like I said, this is repetitive, but I don't like though. Um, y'all wanna, let's see. This look interesting. Y'all want me to read the facts? Cause they talking about hold on. Okay, well, let's read this. Let's read the facts. Facts. Plaintiff was arrested in the United States District Court, Northern District of Illinois, and on July 11, 2019, in connection with a 13-count indictment, United States versus Kelly. Shortly thereafter, plaintiff was separately indicted in the United States District Court of the Eastern District of New York in connection with the RICO charges brought under the same case number. After his arrest, plaintiff was detained in the Metropolitan Correctional Center in Chicago for nearly 2 years until he was transferred to the Metropolitan Detention Center in Brooklyn to face trial in the EDNY case. And in and around June 21st, 2021, during this period of time, plaintiff was a pretrial detainee. While detained in the MCC and in and around January 2020, plaintiff's longtime girlfriend, Jane Doe, began behaving in a hostile and accusatory fashion toward the plaintiff without explanation. Uh-oh. Hold on. Oh boy. Jane Doe was furious with plaintiff and unexpectedly began causing stress and conflict in the relationship. Oh, wait a minute. I think this some rewords right here. There's some rewording right here, I think. Get it? Get it, Bonjean. Okay. She said these arguments related to money issues, romantic issues, and other highly personal issues. Plaintiff later learned that in and around that time, Jane abruptly began cooperating with the government, which led her to becoming the government's star witness against him in the EDNY prosecution. In and around that time, defendant Kibi, a popular YouTube blogger, began publishing information to her 1.1 million subscribers and other viewers, private information about the plaintiff, to which she should not have had access. Defendant Kibi did not reveal how she received said confidential information. Just by way of example, on November 7, 2019, defendant Kibi posted a video on YouTube titled R. Kelly Can't Control His Girlfriends While Behind Bars. Kibi told viewers that The information came from a phone tap somewhere. Keeby disclosed information that appeared to come from plaintiff prison calls with Jane Doe and his girlfriend, J.S. Keeby appeared to disclose private and personal information about plaintiff's romantic relationship. Defendant Keeby proceeded to divulge to her YouTube viewers the contents of plaintiff prison phone calls with his girlfriend and others, email communications about his private life and legal issues with numerous people, visitor log, and trust account information on numerous other occasions, again without disclosing from where she received the information or how she received the information. Plaintiff was incarcerated and had no ability to watch Keeby's YouTube channel or learn the specific information that was being said by the defendant Keeby. At one point, plaintiff visited with Jane Doe and was shocked and confused when Jane Doe accused him of making certain statements concerning his personal life that were only shared with plaintiff lawyer at the time. Okay. So this is where, okay. Oh, this is a good lesson. Good lesson. Now, this is where she is raising attorney-client, right? And she tried to rope it into, I think, prosecutorial misconduct and a Brady violation and all of that, right? I don't feel like going back over that because that would require me to pull up the paperwork to refresh my memory. But that's the gist of it. Now, because the open airways. Okay, wait a minute. Let me take that back because she might have something. If the information, well, no. Because if he gets a warning or she gets a warning that the information that you're sharing is with a third party, then the question would be, does that nullify attorney-client privilege? Because attorney-client privilege is for information that is meant to be private, but it's nullified if it is done in the view of a third party. Communication, the law defines that as phone calls, emails, personal conversations, face-to-face, right? So, if it's done over the phone, that's what they're saying. From my understanding, there is some type of warning that, hey, you're not on a secured line or whatever. Then I think her attorney-client argument, if that's the way she go, will fall flat. If not, if it does say you're on a secured line, then you got to examine where does that security extend to. You have to do that type of workup with this. So it would be some kind of investigation that you would have to do. Y'all know I'm talking to myself. So, But non-bunging, she's going to have some kind of crafty argument to get over all that shit I just said. She's going to get around it. Okay. But and this is so crazy because you can, tie in 2 lessons into one. Before I passed out earlier, we was talking about the attorney-client privilege that Big Terrence was trying to, and his representatives were trying to raise in court with this Fannie Willis stuff. This is kind of, can be, the same type of scenario, but it just depends on how they classify what was said, to whom it was said, and also her challenge is going to be to prove that it was only said to the lawyer. Now, R. Kelly testimony would be evidence. If he said, I only said this to my attorney, and his, and then that information is deemed to have been attorney-client privilege, then she got some, right? Let's keep reading. Plaintiff had no idea how certain private information was making its way into the public domain. In early 2020, the BOP went on a complete lockdown as a result of the pandemic for a year. Attorney visits was conducted entirely by phone, and eventually Zoom visits and face-to-face visits did not resume until late 2020. It is unclear how many of plaintiff attorney-client communications, see where we're going? Were shared with third parties by defendant Ingram, or why those communications were being recorded at all. Okay, let's stop. Okay, now we're getting into it. If it's leaked to a third party, that changes the whole scope, which I think is where she's going with it. But now, if it's leaked in front of a third party without giving permission, because here's and I don't know, I can't remember whatever, because I don't have a lot of prisoners calling me or whatever. So, if it says on the line, do you give your permission and to be on a third party, whatever, then that is opening it up to a third party by your permission, or by your permission to continue on this call, or by your permission to continue by Zoom or whatever, then that is giving third party information, where it's that now it's no longer attorney-client privilege, right? But if none of that happened, and he did not waive his privilege, so to speak, and it was given by illegal means through to third party, which is Kibi and Jane Doe and the dad and all of those people, then there she might have something. She might have something. Now, can this be? And what you really want to know is, how did this help him get out? I don't see a path forward to where it's helping them get out, because here's the thing, right? You have to make this prosecutorial misconduct, meaning they would have to have been in on it. It's not good enough that they benefit from it. They would have to have been in on it. Let's keep reading. In June 2021, plaintiff was transferred to the MDC in Brooklyn, New York, to stand trial in his RICO prosecution. His federal RICO trial commenced on August 9, 2021. A jury returned a verdict against him on September 27, 2021. Plaintiff current counsel filed an appearance in the EDNY case in October 2021 for the purpose of handling post-trial motions and the eventual appeal. Her role expanded after plaintiff's original trial lawyers withdrew from the EDNY case by January 2022. Undersigned counsel filed appearance in the Northern District case on February 18, 2022, and with her legal team began preparing for a plaintiff Northern District trial scheduled to commence in August. After counsel's legal team received information about the unauthorized and illegal taking and selling of plaintiff private information, counsel sought discovery from the government. On June 14, 2022, attorneys for the government produced to plaintiff counsel an application affidavit for a search warrant under the case caption in the matter of the search of the HP desktop computer bearing serial number the materials did not include plaintiff name or any BOP officer name. Neither plaintiff nor counsel had access to the anonymously filed search warrant application affidavit until it was produced by the government on June 14, 2022. The government refused to provide any additional information despite plaintiff request. According to the materials produced in June 2022, Special Agent of the Department of Justice Inspector Matlock executed an affidavit in support of a search warrant for a computer located in the Northern District of Illinois related to violation of 18 U.S.C. Section 1030A to B. That is unauthorized access of a computer by obtaining information from the Federal Bureau of Prisons. Okay, this is more of the same. True View, Agent Locke, Jane. Okay, let me see. All right, Agent Locke's investigation showed that defendant Ingram had not only made unauthorized access to plaintiff's TrueView records, but stole information from the records, downloaded information, and then divulged that information to YouTube blogger defendant Keeby. Defendant Keeby then revealed that stolen and sensitive information to the general public and to specific third parties, including Jane Doe. On information and belief, defendant Keeby and other unknown individuals bought the information from defendant Ingram. Woo! They said she bought it. The information constituted inter alia, meaning amongst all things, other things, private conversations between plaintiff and Jane Doe and his girlfriend J.S. The communications related to personal and private relationship matters, financial issues, and even attorney-client matters. Although plaintiff did not know at the time how Jane Doe obtained the information, when plaintiff had the opportunity to learn of the contents of Agent Locke's affidavit, he deduced that the information had been stolen by defendant Ingram, referred to as unknown officer A, sold to defendant Keeby, and then exploited for profit when defendant Keeby divulged it to the public and to third parties, including Jane Doe. Defendant Keeby recently admitted on one of her broadcasts that she did obtain the information from defendant Ingram, although she did not refer to her by name, and not only disseminated the information publicly, but provided additional information to Jane Doe and others, including Jane Doe's family members, for the purpose of interfering with plaintiff criminal prosecutions. Woo, girl! Listen, hold on. So let me explain this. Let me explain. Okay. Remember. What up, Karen J? What up? Remember. And hey, Joseph Hayes. Remember what I told y'all on live this morning when I kind of really went in depth about the techniques of a persuasive argument, right? We learn both Aristotle rhetorical principles, as well as we learn the Socratic method, right, in school, right? So I think, and I said this on live several the back of ways, that I think your girl J Bo, she applied those methods very well, right? But you got to, but keep in mind, these are methods. It doesn't mean that what she's saying is actually true. Like it doesn't mean that what the prosecutors say is actually true. They write this stuff, they say this stuff in order to persuade who's ever reading it, who's ever listening, the trier of fact, right? Which can be the judge, the juror. I went into that a little bit in depth this morning. Okay. So now, All of this still has to be proven, just like the government has to disprove her claim. But we see that I don't think some of this stuff was in her initial lawsuit, right? I don't think some of this was in there. So, and you can go back and refine it and make it more believable, if that's the word you want to use. I'm gonna use easy words, But yeah, she getting it. I likes it. Okay. Said the release of this private information on the internet created a feeding frenzy about plaintiff's personal life, his relationship with Jane Doe and JS, and resulted in the termination of certain important relationships that plaintiff enjoyed with other individuals. And here she kind of get into the damages in a way, right? They may be unusual damages, but in this type of claim, it's appropriate damages, okay, from what she's listing, right? Says the unauthorized release of information led to a physical fight between Jane Doe and JS that made national news. The theft of thousands of dollars and chaos and discord in plaintiff's life. Furthermore, because information about plaintiff's visiting list and trust fund balances became public news, plaintiff was no longer able to enjoy certain important and supportive relationships with people. Defendant Keeby released the names of certain individuals who supported plaintiff, publicly shamed those people, calling them enablers, and interfered with those relationships. Understandably, plaintiff's associates did not wish to be harassed or have their employment put in jeopardy because of their illegal conduct of defendant Ingram and Keeby. Let me reread that. Understandably, plaintiff associates did not wish to be harassed or have their employment put in jeopardy because of the illegal conduct of defendant Ingram and Keeby. Plaintiff suffered significant emotional distress as a result of the release of this information, and further word about what other private information was in the hands of third parties. Both before and even after plaintiff learned about Agent Loke's affidavit, plaintiff spent sleepless nights, distressed and confused how his private conversations had been leaked to the public and who was responsible for it. Okay? She's writing her ass off now, baby. She done got a name. She's on it, baby. All right. Importantly, plaintiff suffered emotional distress because he did not feel at liberty to freely speak with his attorneys. So now she is illustrating how R. Kelly was so, on edge and so reserved about speaking openly with his attorneys, which should be private, that he might have not been able to participate. Now I'm helping. I'm adding my 2 cents in there. Participate in his own prosecution as he should have. He might not have he may have not felt free enough to be an active participant, which stifled and crippled their defense of him. I'm just adding. That's what I would have said if I'm going on this goddamn trail, right? So plaintiff learned that his attorney and client communications were not only recorded, but information from those calls were released to Jane Doe and presumably others. Plaintiff did not and still does not know the extent to which his private information has been divulged publicly. Agent Locke's investigation revealed that from the period of July 15th, 2019 through January 8, 2020, 60 different BOP officers accessed plaintiff's TrueView records, including defendant Ingram. Indeed, defendant Ingram engaged in unauthorized access to plaintiff TrueView records a whopping 153 times. To this day, plaintiff still does not know the extent of his damages, injuries, and loss, as the government has refused to disclose the plaintiff information about what investigation revealed and the precise nature of stolen information. Okay, that's repetitive. Okay, this thing. All right, Agent Locke's investigation showed that private and sensitive information from plaintiff TrueView records became part of defendant Kibi's content in her Instagram post on January 12, 2020, and videos on November 7, 2019, November 8, 2019, December 22nd, 2019. The information included private information about plaintiff literacy, his medical issues, private information about his romantic relationships. At no point did defendant Kibi reveal the identity of the person who provided her with the information. Indeed, the identity of the individual who revealed the information to defendant Kibi was only revealed on March 4th, 2024, when the defendant, United States of America, disclosed the name of unknown BOP Officer A in their Rule 26A disclosures. More of the same. More of the same. All right. Even after the BOP discovered these rampant violations of the CFAA, they allowed the behavior to continue. The plaintiff learned that in and around August 4th, 2022, an unknown BOP officer made an unauthorized access to TrueView records and obtained information about plaintiff inmate funds. That unknown BOP officer leaked information about the balance of the funds in his trust account to a journalist for the Washington Post who published an article with the stolen information provided by the defendant, unknown BOP officer. Now listen. She is saying that the BOP officer A leaked the information to the journalists of the Washington whatever. Now, she can be clever and say, even if this didn't happen, like the BOP officer A leaked it to that journalist, she still can say, because the information was leaked, it was leaked to that journalist. Okay? And it does not make her a liar. It does not make what she said here untrue. Let's keep reading. Ooh, child, I don't miss none of this shit. Okay, immediately after the journalist divulged the information, the funds in the plaintiff's trust account were confiscated by the United States Attorney's Office. Plaintiff was forced to hire counsel to litigate whether the United States Attorney's Office had the right to confiscate the funds where no restitution judgment had been entered against plaintiff and was not in arrears for paying any court-ordered fees or costs. Now, the government didn't need information put out to know what was in his account, okay? But this is a clever way of making your lawsuit more juicy and to make whatever point you're trying to make, they have some credence to it, right? Let's keep reading. Plaintiff promptly filed a notice of claim on November 14, 2022, and served his claim to the appropriate federal agency for administrative settlement under the FTCA, requesting $1 million or more. By letter dated June 15, 2023, plaintiff claim was denied in writing by the North Central Regional Office of the Federal Bureau of Prisons, and such denial was sent by certified mail to the plaintiff counsel. This complaint comes less than 6 months after plaintiff claim was denied. Okay, You don't want to get into all this cause of action. Okay, well, yeah. Well, let's read some of this cause of action. I can guess who this is. I knew it. Before I moved the paperwork off my screen.
Oh yeah.
What's up?
Hey, what's up? How you guys doing?
You up here?
Can you hear me?
You up here, sir?
Oh, wait a minute.
I can hear you.
Mic is tripping. Can you?
I can
Let
hear
me
you.
see. Oh, you can't hear me?
I can hear you.
So you okay? You can hear me. Okay, great. Listen, let me say this real quick. I'll be back, but I had to dip in and say this, and this pertains to you and several others.
Oh, God.
Wait a minute now. Miss me, Miss Mo, listen to me. You know,
Oh, my God.
it is interesting to me how the 5+ years of doing this, how people tend to, it's like, I'm not accusing you of this right here, this part. I'm saying people tend to obscure the past and they tend to obscure reality. Let me get right to it, and I'll be back on here in a few. But listen, it's simple, Miss Walker. Right now, if Young Thug is standing trial, he's in the fight of his life. I know for a fact that when an attorney speaks to their client via Zoom or via telephone communications, this is not something I'm guessing at. This is something that I know for a fact. That is done on what is called a secure line. When I speak with my cousin, it's a totally different line that he speaks on when he speaks with his attorneys. Even way back at the MCC, MDC, in 5 years of speaking with him, 5 years plus, there is a disclaimer. There are instructions. This is a federal, you're receiving a call from an institution, this, that, and the third. Y'all have heard the recording. When he speaks with Wacko, when he spoke with Vlad or Storm, the recipient, the person on the other end of that phone call, is given a specific disclaimer, if you want to call it a disclaimer. But there is an announcement. And you are told this call is being recorded, basically. Okay. Now, if you notice, when he's gone to court on Zooms and things of that sort, they let you know in that disclaimer, you are not to record this. You cannot record this. You cannot disseminate this to anyone. You cannot play around with that, which certain people have done anyway, but it's specific. Now, I'm going to cut through the chase. Young Thug's in a fight for his life, and his attorney, Mr. Steele, is a consummate professional. He is a extremely, extremely intelligent attorney. If one, just not two, but one, if one of Mr. Steele, Attorney Steele, and Young Thug, Jeffrey, one phone call was stolen, or should I say leaked, by whoever is in charge of that facility, or those who work as supervisors, or those who oversee these things. One thing we know, that all communications from these facilities, be it federal or state, are recorded. All of them. Everything is recorded. So if Mr. Steele had 100% proof that one of his phone calls was leaked to someone, and that phone call fell in the hands of one of Young Thug's prosecution witnesses, not the day after tomorrow, not next week, but tomorrow, Mr. Steele would be able to stand before the court under the attorney-client privilege law and make a strong petition. This case must be discarded. What I'm saying to y'all is that I don't presume to speak for Ms. Bonjean. From my vantage point, all of this is a means to an end. It is a means to an end. It was very brilliant of her to bring this civil lawsuit to get the answers that she needs. Brilliant move. A master chess piece move, for one. But the one thing that you, Ms. Walker, everyone listening to this, those who try to, I'm not saying you're doing this, but those who try to obscure and delete and omit the past, which is reality, the one thing we all know, when I say all roads lead to one individual, all roads lead to one individual, and that is the Father. All roads lead right to him. You or no one else can deny or refute or even challenge, to think about challenging the fact that Tasha K, in her own admission, and we have it all, we have it. You will not find one conversation that was had between Tasha K and Jane Doe number 5. Not one. You will not find one form of communication, one item of communication between Tasha K and Jane Doe number 5. That's factual. So you being an attorney and a legally minded person, if Ms. Bonjean is making the argument at this present legal juncture that what you just read, the girl cut up, the defendant, my client, was concerned and wondering why, how is it that she knew certain things that were private. If that is the objective, and let me know if my thing is going out. The objective, the spelled objective, is to get down to the bottom of it all. That's common sense. But you know, Ms. Walker, and I know, and we know that you take the case of the World Trade Center. Those airplane flight instructors had no culpability in what happened with the World Trade. They had no, the ones who, when they enrolled in them classes and took training classes to fly planes, had any of those airplane instructors been associated in the past to any of those terrorists, they would be doing life in prison right now. If they had any communications or they knew them, they didn't know them. So because they didn't know them, there was no culpability. They just came here and for a couple of weeks or so, a week or so, and wanted to take flight classes. A couple of the instructors said that they thought it was strange that they were only concerned with how to take off and how to land. However, there was no malfeasance or improprieties on their part. They just gave the classes. But we all being from the hood, those of us who are from the hood, if this person purchased the work from this person, and then that person sold the work to this person, And that person that they sold it to broke it down into sections, stepped on it. You understand? Now it's stepped on, and they breaking it down. Then they sell the portions to these 5 people, and they distribute it and break it down to anyone involved in that chain of culpability is going to be made to answer when the rubber meets the road. So my whole thing is, what are we doing? Why are y'all playing? Why are y'all all of a sudden, a lot of y'all got selective amnesia? Tasha K herself said, keep in mind, she never had any communications with Jane Doe number 5, neither did the BOP officer. If you were to ask them on a stand, have you ever talked to Jane Doe number 5? No, I have not. Have you ever communicated with Jane Doe number 5? No, I have not. Well, if this person got it from the ground, from a street perspective, they got that work from Colombia, and then it was brought to Mexico, and then it ended up in Chicago. The question always, how did this person get this? And how did this person get that? How did this, how are they able to get this? How are they able to get that? You cannot have a discussion about the illegal acquisition of Robert's jail records and how that illegally obtained information fell into the hands of Jane Doe number 5, and not have a discussion about the father who gave it to her. The father who I say solicited for that information. Stay tuned. I ain't said 1% of what's going on. I haven't even scratched the surface. It's a lot going on behind the scenes. But I tell you this, that father was in a race against time. He was in all of this that you just read and all this stuff that we're looking at, as far as his stuff being stolen and all of that, bro, listen. The father was in a race against time because his greatest fear was that young lady, his daughter, would not only testify for the defense, but sit in that New York courtroom and tell the world everything that he did. So poor Tasha K. I listen to Tasha K. I watch all that. I go back and review everything. That poor woman really thought that she was helping a desperate father who wanted his daughter. She didn't even know she was being played. You understand? Everybody, I know, send it to him. I'm saying it, but listen. This is nothing, what I'm saying on here. Excuse me for the cough. The father's about to see it just a minute. Hey, like Denzel Washington said in Training Day, hey, Denzel Washington said, you better walk. He said, you better walk away because I'm about to burn this motherfucker down, Denzel said. And that's where we at. These conversations and legal conversations, fine. That is the legal journey, the legal aspect of what's going on, what you're reading. All of that is fine. But let's not pretend that we ain't all been here from day one, most of us. Let's not pretend that we did not hear that woman, Tasha K herself, say, I gave that to the father. So as he continues to hide in the shadows and pretend that it ain't what it ain't and is what it is, listen, man, I don't have selective amnesia, Ms. Walker. I was born and raised partially up top, born in the city and then partially up top. I look down on stuff. You understand? And the way this thing is moving, remember my words. All roads lead to the Father. Now, I'm about to get off of here, but I'm going to say this also. Whenever you talk about these kinds of situations with that woman's name now being public record, you always have to factor in the terrorists. You watch and see. Can you hear me, Miss Walker? Can you hear me? My whole thing might have went out.
Lord. Okay.
Can you hear me?
Went out.
Don't get shy. Don't get scared now. Can you hear me?
Yeah.
Don't get shy and scared. Don't run. Listen.
No, I want you to finish what you're saying.
I'm about to.
'Cause of course, I got to come behind you and correct the record.
Oh, no, there's no correction here, sweetheart. You can't correct what is. Listen to me. You cannot correct. If you're going to listen, in order to correct, when you correct, I'm about to get off of here.
When you speaking not factually on the record, yes, I can. That's
Did
what I do.
Tasha K say she gave it to the Father? Yes or no?
Yeah.
She did? Yes or no?
You breaking up.
Okay. That's why I'm gonna hit you back. But can you hear me better?
That ain't what I'm talking about.
No. What you talking about, but that's what I'm talking. No, I
can hear
you. What you're talking about. Exactly. Yeah. Can you hear me? Can you hear me?
I can hear you.
Exactly. That's not what you're talking about. That's not what most people want to talk about. I came on saying that. Selective amnesia. Pretending that it didn't happen. Yeah, hell yeah. That's not what most people don't want to talk about. But Levi's talking about it. And Levi's talking about it at a very high level. Now, it is what it is. I'm about to get off of here. But I would hope. Okay. I would hope.
Levi, you don't cut out.
Can you hear me now?
I can hear you now.
I would hope when I get off here and you correct me, I would hope that you refute me first. Refute what I said. To say, well, I'm not talking about the Father. I'm not talking. They ain't got nothing to do with. Okay, with the.
I wasn't talking about that. That is speculation that still has to be proven. I ain't got nothing to do with that. I'm just
it's speculation.
About the legal part of it, honey. I'm not talking.
Okay, but that's. No, I'm asking you a question. Are we speculating when I say that Tasha K?
I'm talking about when I say y'all listen to what I'm saying. It's not all the time I'm going to tell you when I'm speaking just regular and I'm speaking in when it comes to the law, in the terms of the law. When I'm talking about speculation, when I say speculation, everything is speculative and alleged until it's proven. I'm not saying that it didn't happen. I'm saying it's speculation until it's proven. Okay, so I'm speaking in legal terms. That's what I mean. I think you did hear her say she gave it to the dad.
You think? You think?
I don't remember all of that. I
you don't?
I the one that got to run right here and remember that. I think.
Well, you don't remember that, huh? Like that. Wait, hold on. No. We're talking about what you're reading there. We're talking about, well, let me, look, forget about all that. All I'm saying, listen, all I'm saying is stay tuned because all roads lead to that man, that so-called man. And I ain't shy. You heard? I ain't shy. I'm telling y'all, stay tuned because it's about to get real deep, super deep. And that's it. Like I said, now it's speculative and we're speculating and everything is speculative. But but at the end of the day, what you read right there on that screen ain't speculation. When it comes to what her objective is, it is to get down to the truth of exactly what transpired. I think if that woman's name,
I can't assert that everything she's saying in here is true. Can't do that.
okay, well, so when you agree when she said that the prosecution or the other side did not object to her putting the woman's name out there, so was that speculative, or is the woman? Would you say that that's a safe bet that that's the woman's name?
Leave out. But this is what I'm not going to do. I'm not going to go into what how to read a damn document, which parts are speculative and which parts are not. Some are facts, some are speculation. I'm not going to sit here and break down the document like that unless I got to go back. Of course, the lady name and stuff like that was fleshed out through an investigation. That's something totally different. I'm talking about speculation as to what she's alleging. Though when there's an indictment, okay, certain parts of the indictments are facts. We do know that our Kelly name is Robert Sylvester Kelly. That is known. That is not speculation. There's parts on an indictment or any legal document that wants a legal body to do something either in the form of a motion or a pleading. Certain parts of it speculative, certain parts are facts. That's all I'm saying. About the name and shit. Duh. Yeah. Well, that's the letter name. We reckon. I'm not talking about that. I am simply talking about the parts that she has to prove. All right? Just like the parts that the prosecution has to prove. It's all alleged. That's why in most documents you see the word alleged.
I'll say it again.
That's not to say that some areas of these documents does not contain facts. That's not what I'm saying. I'm only speaking in legal process and procedures and jargon. That's it.
However, earlier you said earlier that well, if it's a third party or you were making you were comparing and you were giving certain concessions as you described it. Well, if it's a third party, then if the phone call was this, then, or if let me explain it to you. Whenever an American citizen as a defendant, whenever he or she is conversating with their attorney, if someone plants a bug in the attorney's office, or if someone steals that defendant's records of phone communications while they sit in a state, county, federal jail, that constitutes a violation of that defendant's attorney-client privilege. And now you see Bonjean moving more and more towards that, but she's doing it methodically and strategically, which she should. But at the end of the day, she wants answers, and she's going to get them.
That's not necessarily true. That's not necessarily true. You can't school me on the law, sir. Can't do that. Okay? Can't do that. When
all right, so give me a certain
component.
Say it again.
I just gave it to you. I just gave it to you earlier. I gave it to you earlier when I was breaking it down, and I gave it to them earlier this morning how that works when it was a hot contention in that with that girl actually with those attorneys in there going back and forth what attorney-client privilege is. This is where the education gets, broken down, right? Because when you hear attorney-client, the layperson think, attorney-client, meaning whatever I tell them, whatever, it's covered on the No.
No, it's not. Don't listen, Miss. No. The one thing you cannot tell your attorney is that if you are about to commit a crime, or if you are the commission of a crime, your attorney has a judicial responsibility as an officer of the court. Okay, so why are you throwing?
I have already gone through this. So you're not telling me nothing that I don't already know. I wasn't.
No, but what you're doing right now is using that.
What I'm doing, I am not using shit. What I'm doing is trying to finish what the fuck I was saying that I've already explained this morning. And again, you, sir, cannot tell me shit about this. Because unless you got a client, any one of them have ever had a client that you have been sworn to what attorney-client privilege is, what it covers, and what it means, how it operates and how it functions, unless you got a signed document by a client, then that you can tell me. Other than that, you can't tell me shit. I wasn't finished. Damn. I already know what you was talking about. We talked about that this morning. Catch it on the replay. We broke it down. I'm saying that when it comes to a client, attorney-client privilege, and there are other privileges that can be raised, sir, other than outside of attorney-client, for your knowledge, it depends on the communication, what is said, what the surroundings is in third party. Do you know? Here's the thing. Do you know if that communication is private? Should it be private? Now, again, if they got all of those warnings up there telling you, well, it might not be private, and this, that, and the third, whatever, that you're speaking on open airways, then, hey, although there is no defense for that lady taking his shit, that's definitely against the rules and regulations of the BOP. However, when it comes to defending attorney-client privilege, and this is what the United States would be doing. They would be the defendant in this particular situation. When they go to argue that, they're going to go through all of the ways that attorney-client privilege have been waived, or attorney-client privilege did not exist. They're going to list all these different ways. Well, he was on a line. Well, this, that, and the third, whatever. Then they're going to say, by her stealing it doesn't mean that they're going to say, well, it wasn't attorney-client privilege information. That's how they're going to defend it, probably. Now, if John Bonjean could have them dead to the right, it may be something on there that's saying, hey, these calls are secure and blah, 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 this, that, and the third, whatever. If that is the case, Bonjean has a point. Then her conversation with her client that would be considered privilege would be considered privilege. I don't know how else to explain it, but everything you tell your attorney isn't considered privilege. It goes outside of the privilege. Sometimes, I told you, in certain venues, in certain situations, you waive your privilege. I don't know if the jailhouse is one of them. It shouldn't be, though. I ain't never had to go talk to nobody in no jail because they cut deals. But I'm just saying. So I'm giving y'all the scope of it. I'm not going to narrow it because it's not narrow in scope. That's where the whole shit breaks down. You have, people think that when they hear attorney-client, anything you tell them is privilege. No, it's not anything you tell them. And it all depends on the venue and the circumstances as well. That's usually the defense to attorney-client. And then then there's another, and we saw this morning, which was beautiful, that we lead into this conversation. Then we saw how, and I told y'all before they even said it in court, how then you go outside of attorney-client and then run it through hearsay. So it's all kind of aspects that's built into this bullshit. It can go on and on and on. Now go ahead, counsel. You explain it to them.
There are everything that Ms. Walker just said to y'all, everything, 100% of everything she just said, I would suggest that you place it on a table and listen to the voice of logic and reasoning. Listen, what you say to your attorney is not always attorney-client privilege. What you say to your attorney is not always protected under attorney-client privilege. Let me say this also. As opposed to you speculating, Ms. Walker, wouldn't it be beneficial and advantageous to your argument if you would take 30 minutes and go research it, as I have done for 3 damn months? You can't say, well, I'm an attorney and you're a layperson. No. Okay, now you're going to cut me off.
I'm going to have to mute. I'm going to no, my motherfucking ass. No, my motherfucking ass, because you done muted me several times. He going to tell me to go research it. Huh? Just because he researched it. You had to research it. I was taught it, drilled it, trained it. What the fuck is you talking about? You go research it. I'm telling them, go ask somebody else, y'all. Go ask the lead attorney. Go ask the lawyer you know. Go ask Aisha. Go ask Pam. Go ask all of them. Don't ask this motherfucker, because he got to research it. Who got to research it? You research it. You up here? That's what she telling me to research it before I speak. And when
ladies and gentlemen,
went through the video before they got there. Ain't no ladies and gentlemen.
All right, brother.
Before they even got there, and we went through it. We went through it this morning, and it was, I was like, God damn, before I passed out.
Ladies and gentlemen.
You research shit. You don't know what you're talking about. You never have. Your track record is nil. So I don't know what to tell you. My track record is good out here to catch up. I don't know what to tell you. But you research it.
Ladies and gentlemen of the jury, listen to me, y'all. Those of you with some sense.
There's no jury out here.
There have been several cases, and you all have heard of them, where a person was convicted, and that person, once they got inside the prison and got their paperwork, they discovered not only certain laws were broken or improprieties took place by the prosecution, but they also have discovered errors made by their own attorneys. Y'all can sit here if you want and let Ms. Walker convince y'all that attorneys are infallible if you want. You do that. Y'all do that. Y'all sit here, listen, and let Ms. Walker convince y'all that she's infallible and that how she reads is different than how I read. Go ahead and do that. That's on y'all.
What did I tell y'all earlier? As a matter of fact, what did I tell y'all earlier? I said, as y'all can see, none of them get it right. Even the goddamn judge, which was a perfect lesson how the attorneys was instructing the judge. Nobody gets it right. Everybody got to go back and refer to something, whatever. But when you talking about something as basic as this, and then granted, even attorney-client could get in the weeds for a lay person. When it doesn't get in the weeds, when it gets in the weeds for attorneys, as to when we trying to go around it, okay? That's when it gets in the weeds. We know what it does when we trying to get around it. That's when it gets in the weeds. You get in the weeds of the definition of it.
Oh no, you when you conversate and debate with me, you take people into the weeds as a diversionary tactic. Now let's get back to the nuts and bolts. Let's get back to the real deal, y'all. I would urge each and every one of you during the course of the next couple of weeks, get on the phone, call 5 attorneys each of you, call 5 attorneys and ask them if a federal defendant's private communications between that federal defendant and his attorneys were leaked to an individual, and that individual, as a result of those stolen communications and private conversations, chose to be the star witness or was made the star witness in that federal defendant's case, all 5 of those attorneys would tell each and every one of you, oh, it's a wrap. It's over with. That's attorney-client privilege. And it influenced the star witness. It's a wrap. That's fine, though. Y'all can continue to play selective amnesia games, and I ain't going to keep going back and forth about it, but it is what it is. Shout out to Ms. Bonjean, because she's doing an excellent job as it pertains to the meticulous, methodical way she's going about it. But the answers, all of the answers and all of the truth is going to be made known. Y'all could sit here and try to pretend that the father's not dead in the middle of this. You can pretend and try to obscure and erase history. Do what you do. But at the end of the day, there are some very intelligent minds that's involved in this. And when you speak of me and when you speak to me, remember, I'm one of them. You understand me? I'm nobody's fool. I know exactly what's being done, the plays. I know it all. Trust me. And when it's all said and done, you could take that New York case and flush it down the goddamn toilet stool. That's from Levi. Because what happened was an egregious act of attorney-client privilege violation in the case of R. Kelly. It is what it is. These things take time, but it's going to unfold. But in the process of it unfolding, y'all can go ahead and pretend that all roads don't lead to the Father. He know all roads lead to him. And if he thinks this is a game, stay tuned. Stay tuned. This is about to get heated. This is about to be so big, y'all ain't gonna believe it. Ms. Walker, that's...
Let's
go ahead.
assume all roads lead to the Father, because so we know, I think we all can stipulate his involvement. We got that. How does this overturn R. Kelly's case? Tell me that, counsel.
When you say, first of all, you did it again. You took the people into the weeds. When y'all listening to Ms. Walker, you have to listen to.
I agree with you.
Excuse me. If y'all play it back, this is what she does. She just said cases, plural. But if you go back 2 minutes, you're going to hear Levi say, you can take that New York case, singular, and flush it down the goddamn toilet stool. But she took y'all into the weeds by saying cases. See? Oh, yes, you just did.
He's gonna still be there. So what are you talking about?
Who's gonna still be there? Who's gonna still be there? Who's gonna still be there? Beware. Beware. Wait a minute. Hold on.
I want to know, how do we get rid of these cases?
You didn't say that though. You didn't say that though. You didn't say that. You mischaracterized what I said. Mr. Keller.
I just want to know, how do we get them out?
Excuse me. Well, you got it on the screen. You got part of it on the screen right now. you got part of it on the screen. You got it on the thing right there. Is it a thing? For one. For two, Mr. Keller has always, if y'all noticed for the last year or so, tried to get Levi to move on to Chicago and talk about the cases. Levi was raised up top. I'm focused on New York, and I have not moved away from New York. And what she has on the screen is pertaining to New York. We'll cross the Chicago bridge when we get to it. But this case right here, this New York case, y'all gonna see, you can flush that down the damn toilet stool. And that's a fact. I'm not going to entertain or go back and forth about the Chicago. I'm not dealing with that. I got better sense than to allow Miss Walker.
Go talk about New York.
I just told you how it's going to play out.
Get rid of New York. How we get rid of New York?
It's already done.
Go ahead.
Listen, it's already done. Once the confirmation, 100% confirmation comes in that Robert Kelly's attorney-client privilege, constitutionally granted attorney-client privilege, was violated, you can flush New York down the toilet stool. Flush it down the toilet stool. I don't see nothing other than that. All of the other stuff of attorney-client privilege isn't this. It is really, it's simple. The man was having private conversations with his attorneys, and those private conversations fell into the hands of individuals. Listen, people, don't y'all understand that when people speak with their attorneys over jail phones, that most times they're discussing the case, the strategy, the real deep, intricate parts of how they're going to proceed. And then that information ends up in the hands of the father of the star witness. Listen, there's so much more I could say, but I'm not.
Wait a minute, you got to stipulate that you have to stipulate that they were talking about case and things of that nature, which would be a protected communication, not about your girlfriends and shit like that. Everything isn't protected.
What are you? Well, I don't get what you're saying. What do you mean by? Wait, listen.
You don't get what I'm saying.
No. You don't. I get what you're trying to say, but I don't get what you're trying to convince these people of. I'm going to say it again.
All I'm saying is this: my record is beautiful. Okay, yours not so. So what I'm trying to say, you can't tell me something that I already know something about, that I had to go through a long time ago. But nevertheless, you have to go through it. Now, granted. And this is what you will find. And I'll give anybody this. With the different attorneys that was represented in that court earlier when we watched it, right? This morning. A lot of those attorneys have been on the prosecution side mainly, or some of it be on, some man like good bit have been on the defendant side, whatever. You deal with more attorney-client shit as a defense attorney. Grant you that. So they are more. Listen, they are very good with attorney-client issues when it comes to privilege. Like I said, there's other privileges that can be raised. Don't be surprised that you don't see other privileges that Bonjean may say that her client should have been protected under. So that's what I'm saying. It goes and goes and goes and goes and goes. It's like a roadmap. I'm just trying to simply find out. And he is under the whatever, that anything you say to your attorney is attorney-client privilege. It's not true. In any setting, not true.
Why do you like to? Why do you listen, y'all? Don't listen, man.
I'm telling them the truth. I'm going to tell them the truth.
Listen, what the?
I'm not going to tell them what you think.
That ain't got nothing to do with what I'm talking about.
I'm so tired of arguing with you. I got to find somebody new.
Well, you can't deal with me. And as far as your record being flawless and impeccable, listen,
It is.
Miss Walker and Mr. Keller, listen. Miss Walker and Mr. Keller believes after the fight, going over to the thing, taking the belt and walking around the ring like they won. But the real objective, true people who listen to our exchanges know damn well that's what they hold the belt for. They ain't won shit when it comes to Levi. They ain't won nothing. What you holding the belt? Walking around with the belt and yeah. And the crowd looking like, wait, hold on.
Off your own shit, off my shit.
The crowd is like, what she holding the belt for? About a month or so ago, you guys. Now let's talk about Miss Walker's flawless record. About a month ago, or maybe a month and a half ago, y'all think that Levi talks a lot, but I listen more than I talk. And I know what I'm dealing with, the Robert Kellers of the world, the Angie Walkers of the world. You have to listen attentively. She was reading the jury instructions in the New York case. And as she was reading them, I said, well, let's go to what the instructions were as it pertains to Jane Doe number 5's charges. And she read it. And when she read it, the judge instructed the jury, in order to find R. Kelly guilty of this, you must prove, or you must have believed, or have found that he intentionally took the minor across state lines for the purpose of sex. You must have found that he intentionally took the minor, Jane Doe number 5, across state lines for the purpose of sex. Well, goddamn, we all know that the low-down parents told him that she was 18. We all know that. He was under the impression that she was 18 when she asked in the text messages, he wants to know, can I cross state lines? Can I go out of town with him? Yes, you can. No, we're not strict. And you're 18. Shit. But when I pointed that out, Ms. Walker tried to wrestle with me. Then she had to concede and say, okay, you're right. Keller couldn't take the goddamn defeat and used every trick in the book. No, read this. Read it. Ain't nothing else to read, nigga. Ain't nothing else to talk about. Read what? I just pointed out the shit. So I'll say it again. Ms. Walker asked a minute ago.
I don't remember it happening that way. I remember it happening that
I
way.
know you don't remember nothing when it comes to getting defeated. Shit.
No, I ain't been defeated. That's
how you gonna remember you were knocked out? How you gonna remember you were knocked out cold in the ring? You couldn't remember nothing. You was knocked out cold.
I know how this works. I listen.
Oh, you remember this Wake It Up and shit.
I hold the record. I own the belt. I'm wearing the belt. Okay. You trying to get the belt. Well, let me tell you, the belt don't fit you. Listen, the belt ain't for a size 32 waist. Okay.
38 to be exact. Sometimes 40.
What?
38, 40. 38, 40. I'm a big nigga. I've always been a big nigga. I ain't no little thin ass nigga. I ain't never been no little skinny ass nigga. I'm a heavyweight. Why do people say that? I'm not. No, a lot of people. Listen to me. I'm not no skinny. Would you call LeBron James skinny? Nope. You understand? You wouldn't call LeBron James skinny or Magic Johnson skinny. Okay. You could call. I'm a big dude.
And 42s and stuff like that. That's when you getting a little. People, I done seen you. So why are we having this conversation?
What I'm saying, why do people? A lot of people say that. Listen to me. I am no way skinny. I am a big guy. And I'll say it again. You take Penny Hardaway, right? And LeBron James. Penny Hardaway was skinny, right? LeBron James is not skinny. You feel me? There's different body styles. I've always, You understand? I've always been that body style. I've never been skinny. I'm a big dude.
But
I,
okay, but compared to somebody that's wearing a size 40, 42, 44, you're skinny. If you still saying 30 something, you on the skinny frame. Not you ain't skinny. Well, maybe I used the wrong word. You're not skinny, but you're not what consider no big dude. You're not a big dude. Come on now, stop playing. Show your little arms. Show the people your little arms. Yeah.
I guess I'm big in the sense that I consider myself I'm a big guy. I'm just saying, you take Gene Deal, for instance. Y'all seen Gene Deal. Gene Deal, I've met Gene Deal a few times. Y'all know who Gene Deal is? Puff Daddy's security guard?
Yeah.
Okay.
Yeah.
Right. Gene Deal is
But
a big
nobody
dude.
knows who he is. Yeah,
Say it again.
big.
He's a big guy. Now,
No, go ahead.
I come from that same era when he was running the streets with Puffy. I come from the exact same era. And the few times I've seen Gene Deal, I would never categorize. He's a big guy. But at the same time, now that he's gotten older, when you get older, Big Gene Deal, like, he probably still work out, but when you see him, that he's older now. We're all older now. You feel me? When you saw Robert standing in the courtroom, I mean, once you get past 45 and all that, you go put on a little weight. But I've never been. At one time, I was when I was running 7-8 miles a day. I wasn't skinny then. I never. However, that's neither here nor there. I want to ask you a question though. It's very simple, y'all. The father of Jane Doe number 5. That man knew that there was a hell of a chance. This is what I allege. There was a hell of a chance of his daughter getting on that witness stand and telling it all for the defense. So he was scrambling. And as he, out of desperation, and they'll send it to him, and that's fine because he ain't seen nothing yet. Out of desperation, he, being a convicted ex-federal felon, he understood, if I receive these stolen communications from that federal facility with R. Kelly's voice and all of R. Kelly's information, there's a chance my ass might go to prison. He understood that. But the reward was greater than the fear. So what he did was he took the chance and said, send it to me, give it to me. This is not Levi speculating. The woman herself, Tasha K, says she gave it to him. Okay? And I'm going to stop right there because this is something big. Y'all about to see some big shit. But at the end of the day, as getting back to this legal aspect of it, Ms. Walker will tell you that I've always, she thinks that I want fast results. Ms. Walker thinks that, because we have private conversations, and she thinks that I believe in the Madlock type form of law, like Madlock. Y'all seen Madlock, where you go into the courtroom with the proof and shit here, and shit, the episode ain't but 33 minutes, 34 minutes. So they just, squeeze it into. I understand that there's a process. I understand more than ever now with Robert in this situation that there is a process that must ensue. However, I get ahead of the process I look at the process and say, well, these are the things that we know. Even though you're right, it can be categorized as speculatory. I agree with that. Yeah, speculation. Yeah. Just because Tasha K said she gave it to him.
On both sides.
On both sides, I agree with that. However, what I need for y'all to understand is that when I fight for my cousin, I don't go in with no, ask Larry. Ask Larry. He'll tell you. I don't go in with no doubts. I go in, my mind frame is that I get the evidence, look at this, look at that, I form an opinion, and I go with that. I don't, well, maybe this, or well, maybe that. Well, attorney-client privilege, there are certain stipulations, and you can't, I don't go into, I don't get off, I don't allow that to impede or obstruct the way I think. You understand? So this is where me and Ms. Walker part ways a lot, and it becomes argumentative because while she tries to break down the technicalities of it, you understand? I'm like, okay, that's fine, but all I know is that the damn brand new vehicle ain't starting, so something's wrong. You feel me? The technically this or technically that, who gives a damn? The mechanic is gonna put it on a diagnosis machine, right? But the person who purchased the vehicle is like, my shit ain't starting. so fuck all that. Just what's going on? Start it. Get it going. So yeah, I want y'all to know that Ms. Walker and I would never agree, or should I say, rarely will we agree on things because my approach and her approach is different. I understand, and I go in understanding that. That's why I don't get offended. You understand what I'm saying? I don't even get offended because I understand that's her approach. But my approach, I don't allow her approach to influence my approach. That's all I'm saying. So at the end of the day, y'all, the man's attorney-client privilege constitutional right was violated, or rights were violated, and it's going to play out in the proper form, and more is going to manifest. You feel me? So, that's all I want to say. I'm going to come back on. I should have been off here half an hour ago, but I'm going to come back on and listen to you correct me when I get off of here. And then
that up on the screen is correcting you. I ain't got to do shit. Can you read?
Read it for me real quick.
Oh, let me go. Let me see. Okay, it says, what does attorney not apply to? The privilege extends only to communications that the client intends to be confidential. Communications made in non-private settings or in the presence of third persons, unnecessary to accomplish the purpose for which the attorney was consulted, are not confidential and therefore are not protected by the privilege. So that's what I was trying to tell you. So not everything, and you look, and this is by another attorney from Legal Affairs, John Carroll University, okay? And y'all, when you do y'all Google shit, make sure you get it from a credible source. Now, I'm not saying that every time an attorney posts something that is credible, okay? Because a lot of times sometimes they are posting from their experience. But when it's on general topics like this, you could pretty much bet on it, right? You can pull it from more than one source. But so that's what I'm saying. That's when a lot of people get jammed up. And I'll just give you an example, right? When it comes to attorney-client, right? And you have a client that talks to that attorney. They thinking everything they say is under that privilege. They get caught up in some more crimes that's coming out because sometimes with indictment, they ain't finished investigating your ass. And shit ain't, and depending on what kind of crimes you have, especially on the financial side, they go to popping up just overnight. They just go to popping up in the computer, and now you got to tack on some more charges to your ass, right? Okay, you go talk to your attorney because you, in fact, want the bleeding to stop. You want to take a plea, right? You want to take a plea. You want the bleeding to stop. You tell your attorney all kinds of shit. You thinking that, hey, and that's including some more shit you done. All right? Just say the prosecutor gets a hunch that it's some more shit. It may be just outside of outside of what you're being charged with. They subpoenaed that your attorney. Now your attorney has to tell what you done told his ass, especially if it's in furtherance of a crime, if it's outside of what you've hired him to do, so on and so forth. But that's where we sometimes get confused about things, right? Just by you just think, hey, that privilege, anything I told my attorney in any setting is covered. So what and I don't know if Bonjean will even go down this route, whatever. She may also try to cover, try to aid her client or defend her client's position by raising other privileges.
I'm
I
listening.
don't know. You understand? So it could be other privileges that could cover this particular situation. So, and this is where you have to go and do your research. You have to do your look at other cases, case law, precedents, and things of that nature, which would support her client's position. So, I'm not saying that this cannot aid in him overturning the New York case or whatever. Him getting his ass out. Okay. That's how I look at things. Him getting his ass out. Or him staying his ass in. Okay, but we doing defense work today. So him getting his ass out. That's what I look at. I want to get to that point. I want to do the research to that point. What cases are out there to support Mr. Kelly's position? What happened to him? How did this overturn his sentence? Because true enough, if he wins this case, get a couple of dollars, that's fine. He's still where he is.
I think once again, I don't. Maybe I'm just a genius or something. Maybe my thinking pattern is just a couple of notches above most people. Maybe I'm just endowed with genius. Can y'all understand? Can you please lend me your ear for a second? Do you think this is now I'm speculating. This is from my vantage point. Do you think that this civil case is about a award or some money?
No.
Or do you think that Ms. Bonjean is seeking answers?
She's seeking answers. I've been said that.
Thank you. Okay, stop there. Now, I have not heard anyone comment in the chat, which I was reading earlier. I'm not reading it now. But another area that myself and Ms. Walker, where we veer off, is that I'm an explorer. I explore ideas. Has anyone asked themselves, and I want y'all to ponder this, a lot of y'all gonna wake up in the middle of the night and say, damn, Levi's right. Listen, the question I have for Ms. Walker and y'all, and I want you to think about this, is what changed? How was Miss Bonjean able to obtain that woman's true identity? What would you say, Ms. Walker, if you were a betting woman?
I am betting that, well, she made a request and she kept being persistent with it. But here's the thing, right? I believe they turned it over to her because at this point, I think they realized they probably went back, weighed the cost and like the time that's going to be spent in this bullshit, right? They figured out what she really will want. They know where she's going to go, and I think they gave her up, the lady up, because they know that most likely it's not going to change nothing in the end. If anything, if it, I don't know if they will, if she could be successful in getting a couple of dollars out of it, and I know that's not what she really wants. I mean, of course he can use it, but that's not the main purpose of it, the scope of it. But I believe they just gave it up because they probably did the research and saw, okay, how does this affect his sentence? How does this affect his sentence? And I believe they just went on and gave it on up.
Okay, so you're
What you
telling me,
think? Go ahead.
okay. So I would think that, and you might be spot on, I don't know, but I would think that if they gave that information up, that they are in the process of conceding. I would think that if they gave that information up, that for them, you know, they're good at strong arming and stonewalling. They're good at that. For them to, if they did give that up, then it may be a situation where they're saying, how is it benefiting us to protect? Let me rephrase this because I want to be very clear. I don't want to say the wrong thing. If this defendant and his attorney are on a road trying to get from point A to point W, how is it benefiting us if we really ain't got nothing? All they want to do is get to point, let's just say point F. They want to get to F, right? So how is it benefiting us to prevent them from getting to point F, knowing that she has a larger plan? Let them fight that out over there. Shit, just let this shit. You feel me? You feel me? Now there you go.
What I was saying, yeah, that's what I was pretty much what I was saying. With you, you know, you put it into a more direct scope. But yeah, like, you know, I mean, and this is in the Illinois district. She's fighting and saying it's not in the
right.
And you know, so why even, you know, prolong what
Absolutely.
is going to, and I believe, you know, that the judge would have probably made a decision that she was right based on that earlier motion to compel. I believe that the judge that's hearing this particular suit would have agreed that, hey, she is she's right to have access to this information, to get, you know, because one, this can aid in some other areas.
Absolutely.
With Mr. Kelly's situation he has going on, right?
Absolutely.
You do use the civil process to aid in your criminal process. You know what I'm saying?
Absolutely.
So, and with the, you know, attorneys that rigorously fight criminal cases and are appellate, appeals experts and things of that nature, they explore every avenue.
Absolutely.
Right? I told y'all. All right. You have your statutory law, which your statutory and common law, which deals with both civil and criminal law, but it cannot conflict with constitutional law. That is the umbrella. So if ever you are, if you are oppressed, things of that nature, whatever, you could have killed everybody in Georgia. But if you're being oppressed by the words they've written, you must be relieved of that oppression.
Absolutely. I have a question for you real quick. Is it likely? Is it possible? I'll say possible. I was going to say probable, but that's given your theory. Isn't it possible and somewhat probable that it could be a situation like, look at here. I'm not trying to get no money out of Tasha K. I'm not trying to get no money out of this officer. I'm not trying to get no money out of y'all. I just want the entire file of everything that took place, dates, places, times. That's it. What was transmitted. That's all I want is that. You provide me with that, we'll go on our way, y'all go on your way. Is it possible that that scenario could be playing out right now in front of us?
Yeah, a lot of times you will get on the phone and you do a lot of talking. A lot of stuff that we see that comes out via paperwork is the result of getting on the line with the other side and saying, hey, this, that, and whatever. It's it's
Wouldn't
working
that
together, but it's not working together. You understand what I'm
but,
saying?
but I'm sorry.
Go ahead, you got.
In order to incentivize the other side, wouldn't that be a hell of an incentive to say, look, I'm not trying to get no money from y'all. I'm not trying to sue this lady. I'm not trying to get Tasha K and more debt. Just give me everything that took place. Give me the file of what transpired, and we're going to go on our way. And if that is, in fact, the case, can we look for this lawsuit to be dropped soon?
Yeah. If and I fully believe that her first order is to get the information she needs to continue to fight for her client, right?
That's right.
And I believe if she is satisfied with that, then hey, because here's the thing, right? You have to look at the padding, the way if you can start getting familiar with and how an attorney writes and things of that nature, and you kind of know how they they go at things or whatever, and what their main focus is. You could tell what they really want
Right.
and what secondary.
Yeah.
Now I'm pretty sure R. Kelly ain't gonna be mad at a couple dollars. So me, now I'm doing defense work now, y'all. Don't send me no bunch of emails. I wanted to get a couple dollars, okay? I wanted to get a couple dollars out the deal too, okay? I'm just trying to tell you. I want him to keep his little books together and shit like that, right?
Right. Right.
Okay. So, but that's an afterthought, okay? Don't send me no emails and texts and shit. I don't want to hear nothing about it, okay? Because I'm gonna say what I want to say. But yeah, but she unclosed the information she needs to put an appropriate. And here's the thing, right? When you have a lot of holes in your case, unknown officer hand, this, that, and the third, whatever, it stifles your actual investigation, your research, because you don't know what you're looking for, who you're looking for, or anything like that. So when you start to get an ID on these people, then there you can start nailing down the situation. You can put that situation together, put it in a story, put it in get your defense down pat, and now you are more prepared to fight instead of fighting with your eyes closed and you don't know who the people are, you don't know what they did, where they were, whatever. Now you got to find out, well, was there any money? Did any
Absolutely.
money exchange hands for the information? Now you
Absolutely.
got somewhere to go. Now you got records to uncover. Now you can uncover phone records. Now you can
Absolutely.
uncover this, that, and the third, because you got a name. You got that. That's why it was germane to the case when the people in Kel's case was trying to find out who the girls were or whatever, right? The ladies were, or whatever you want to classify them as.
Yeah, but then
You know?
you get in a very turbulent um, area there, because, like I said, you always have to factor in the terrorist, and you have to factor in, if
Oh
you
Lord.
listen, keep in mind that none of us know any names or faces of those jurors that sat on both cases, and that's for a reason. So I'll say it again. This is me talking. That I've seen certain bloggers put the lady's face up there, and I understand this animal. I understand not an individual, but the animal, the machine of this R. Kelly YouTube cesspool. And I hope and pray that it doesn't lead to this woman being attacked, doxxed, what we've seen for the last 5+
Yeah.
years. However, I got to get out of here, but I'll be back. I want to say this, that if something you read earlier, and I was asking, I'm about to get off, but if you could read it again, it's something that you read that I found was very interesting. The part where Miss Bonjean says, the other side does not object to us placing her name here. And I think that little paragraph right there kind of lends itself to what you're saying, where they may have been the ones who conceded in that area and provided her with that. You feel me? And if that's the case, then it would suggest to
Yeah,
me
you
that,
know, let me see what it was.
that they're on a road to mediation, to mediate it and to more or less resolve this whole lawsuit. That's what I would think.
Right. Let me see. Oh, you said what now? You said I said what? I'm trying to
There's the
find.
part where she was what was it, the first one you read? Yeah, when she was basically saying the name I think it's like page 1 or 2. I think it was page 1 or 2 when you were reading it initially, and she was saying that the amendment, right? She's amending it, and she's saying that they don't object to her placing the name there. I thought that was very interesting, because the BOP's first
Oh, okay.
position. Yes, go ahead.
No, go ahead. Go ahead. I'm still looking
Their
for it.
first, they were leaning very heavily towards anonymity. Anonymity. They were leaning very heavily towards that by not releasing her name, if you recall. You understand? And how she worded it was like, you understand that they, okay, here's her name, da 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 da, and it could even be a situation where now that they've given her the name, where they're all sitting around, or their attorneys are sitting around at a table of mediation and getting this whole thing resolved. You know what I'm saying? It's a great
Right.
possibility. Because really, at the end of the day, the broad scheme of things, they really don't have a dog in the fight, is what I'm saying. BOP, they don't have no dog in this fight. The woman has been reprimanded. Tasha K has
Right.
admitted. Well, you feel me? So it's like, why
Right.
are we wasting resources? We don't even have a dog in this fight. You feel me? So here's everything. Now I got to get off here, and I'm gonna listen to your answer when I get off. I ask you. First of all, y'all have to understand that what me and Ms. Walker just spoke about for the last 10 minutes was due to what exploring things, like exploring it, speculating in a sense, but let's explore this now. We're talking about files, or really, let's just say a file that consists of several files, but there's really one file that details the first time that this person contacted Tasha K, the conversations that were going on between Tasha K and this person from the beginning at its inception to the lawsuit. So that file, which consists of files, if they were to concede and just hand that over to Ms. Bonjean and the lawsuit is dropped, I would ask you to consider, Ms. Walker, what does that file contain? That's all. I want you to think about that. What does
I mean, it contain, it's I mean, as far as like their communications.
Yes, in other words, what if, I'll go further. What if that file, the communications, what if that file and Ms. Bonjean asking in private conversations and in that mediation process, unofficial mediation, I want the whole file. And she gets it, and she discovers that from the time Robert entered into the MCC up until he left, until the time when they shipped him to the MDC, or that's to say from the time that he entered into the MCC all the way until the stolen communications were issued to Tasha K, that it contained all 100% of all of his private phone communications to his attorneys, plural. I'm gonna get off of here, and I'm gonna listen to your answer. but I want to ask you, what could be the legal consequences and outcome of that if the file, we're just theorizing here, we're just speculating, if that file, if Ms. Bonjean was able to come to an agreement and they just handed that over, and in that it confirmed that Tasha K received from that time period, keep in mind it was COVID going on back then too, all of the private telephone communications, conversations between Robert and his attorneys. What could be the legal consequences for that? And I'm about to get off of here and listen to your response offline. Thank you. I'll be back. Thank you.
Oh, okay. All right. So, in order, just say if there was a breach of a violation of the attorney-client privilege, right? Then what happens if there's a conviction, right? There's a conviction. They can overturn your conviction because they'll say that you didn't receive a fair trial, because those communications were meant to be private, right? Privileged information. That could mean that. I mean, that's the honest God truth. That could mean that. That could mean that, hey, they're gonna overturn the conviction based on that. She still has, and listen, I mean, look how time has it. This is she hasn't had the oral argument yet for New York. This is in time for to be added on to the oral argument in New York, or even onto the brief, right? She can make an amendment to the brief and submit this in. So hey, but I'm just saying now. But again, you gotta prove it. And the government has to be able to disprove it. Okay. So wow, it's kind of well, it's without me having the files and the records, to me, it can be a game changer. Okay, because now I'm thinking, this just me. I'm thinking that now they got to go back to the drawing board, not erase it, but now you got another element that you got to tackle. The investigation that she's doing to see what was disclosed. Did any money exchange hands, and what records she can uncover? Is the same kind of investigation that they have to, and the prosecutor has to anticipate she's doing, and do that and find out all the legal rules and laws and case laws and shit like that to stop her from saying that, hey, in the end, her client did not receive a fair trial because of this breach. So that's a little, well, okay, well, listen now. Oh Lord. That's a little a highway to get around making it prosecutorial misconduct. I don't just know why they just don't hire me. Yeah, that's an avenue to get around prosecutorial misconduct. And this is probably what she's thinking. If you go to a attorney-client route and just say they buy into it. Now, I can make a good argument to where my client didn't receive a fair trial. Fair trial is guaranteed under what? Constitution. I just told you. Constitution, your rights trump what? Statutory and common law. If it's ever in conflict, it should favor it should favor the Constitution, right? Oh, oh, she good. Either she good or I'm good. One of us are good. Because if she's already thinking about this, which she probably is, and she's good. Because she saw where, you see, now remember, back in the day when the first motion to compel came out, you see that she was trying to go the route of Brady material, which violation that falls in the arena of prosecutorial misconduct. They stopped her there. She let it go for a minute, come on back through with this lawsuit and say, hey, she's going to more of the attorney-client angle. That being the case, fuck prosecutorial misconduct. Her client didn't get a fair trial. Huh. Look at that. That lady be thinking, baby. And so do I. But listen. But it be taking like conversations like the one I just had with Levi and y'all comments in the chat and all of stuff to make me start thinking and stuff like that. Because what I was really thinking before that was, honey, that I'm hungry. And how can I, if Levi can stay on here a couple more seconds, I can go on there to that microwave, run on down that hallway and put me something on in there real quick. Because, you know, I've been asleep for a long time. The girl's mighty hungry. You know what I'm saying? I don't really want to order nothing, you know. But, yeah. She gets around that prosecutorial misconduct. Huh. Look at that. Let me see something. Okay. So, if I'm talking to myself, y'all. So let's explore all of the ways that he didn't have a fair trial. What are the top ways? Top ways. It could you could say ineffective. Okay, let me see how you can say ineffective. Just by the process itself of his shit being stolen, it was attorney-client, it made the counsel itself ineffective. That's one. What's two? Two would be if and she, and this would be New York, so she could really ride out on ineffective because she wasn't at the table for New York. Oh, okay, so that'll be ineffective. And what's another way? Another way. You can touch prosecutorial misconduct, but you could still build a bridge to that. So we're putting bullets in the chambers. We got, okay, that's 2 bullets. Another bullet. So one I want in between there. What would be in between that we could say? Okay. In between ineffective and prosecutorial. What could we say between what would be another bullet? Not like at least have 3 bullets in the chamber. What would be another bullet? Okay. Ineffective. Just by the very nature of what happened. Correct. That particular, okay, good. Well, they probably wrote, well, no, because if she got on that stand, oh, wait a minute. Maybe her story, okay, well, they got to find another place where her story was inconsistent while she was under oath or under penalty of perjury to make it an avenue to where it would prejudice the jury. And I got a half a bullet in the chamber. There's 2.5 bullets in the chamber. Got to think that through a little bit. Yeah. Oh, I forgot y'all was still here. Yeah. Hold on. Oh Lord, I'm just thinking. Let me see when Evan does it. Right. You well, she already got that bullet in there with the general appeals and everything that's going, looking for the technical violations and things of that nature. So she already got that in there. But I'm just trying to load up that damn gun with many bullets. Whew, child, girl. Got me sweating over here. What the fuck? Go ahead on, Bonjing, baby. I ain't mad at you. You getting somewhere. I see how you know. And listen, y'all. If an attorney can get 3 cases overturned on appeal, honey, they doing all right. Okay, so the fact that they don't get every case overturned, there's no shot to them. Is that with all those roadblocks in place to keep convictions as they are, because that's when you and then at the last ditch you'll hear somebody argue, say, hey, the jury decided it, and if we we reverse the jury decisions, is that's tearing at the very fabric of our democracy and blah 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 blah, the speech they craft that says shit like that, and they will go there to try to. So hey, but yeah, y'all, this is going to be interesting. Now we got to watch the civil suit. I ain't got time for all of this. It's too much. Yeah, this too much. Y'all, we want to see Carla back here on this on the screen, y'all. Y'all want to see Carla? You here? You want to see you on the screen? Let me show you. Ooh, we got to see if they gonna show Carla back there on the screen by old Big White, making sure Nathan and Fanny gets due justice. Yeah, honey, but yeah, that's worth exploring. Man, you know how I'll think about it overnight, and then boom, wake up in the morning. Oh, I done figured it out. I done figured some more shit out. But yeah, because she's going to find some cases and stuff like that. You know what? I never did understood. But we supposed to sign up through the market shit. That when that shit came out, I was working right there. We were so confused. We didn't know what to do. We supposed to go through, do the market share, sign up to and shit. This old broken ass goddamn fucking system and shit, man. Anyway, let's get back to old Ashleigh. Yeah, y'all gonna see old Carla on him, baby, making sure that the Negroes don't get railroaded. Cookie, I want to let you know, Carla. Cookie laughed when I showed him. You back there sitting back there making sure that the Negroes don't get railroaded. Girl, Cookie laugh. I'm trying to tell you. Don't stab me, stab Cookie. Let's get back on the record where Ashleigh, honey, then use poor Terrence, big arm Terrence. And keep these topics straight. I'm gonna run and find me something to eat because this ain't right.
Things. She had not followed the statute. So the statute I referenced earlier, 15-18-20, said that you had to have county approval. She didn't have that. So that was one thing. There were also
You had figured that out through your financial.
There you go.
Yeah.
There go you. Damn.
Through open records, through reviewing all the Board of County Commissioners. And I actually, to that motion, I attached, just on this issue, I actually attached a document showing how independent special counsel would normally be appointed. I'm sorry, special counsel. Because I found one where, and I think it's exhibit, let's see.
You know she from Georgia. She got on pearls.
Exhibit J. I found one where Fulton County had actually been asked to approve a line item for an independent contractor agreement. And so this, I used it as an example of what normally would happen.
Was that for an attorney?
It was for an attorney.
Carl, you see you back there. That's going to be you, baby. You see you back there, honey. You see you right there. That's going to be you, baby, making sure the Negroes is being done fair. That's going to be you, honey, about 40 years. You're going to be sitting right there, making sure everything is going right. You don't want to hear no shit or none of that. You looking right through that white guy, okay? Since you insist on being a 40-year-old Harry Tubman. Hey, you call me the Red Power Ranger shit. Call making sure everything goes fair in Georgia, okay? Oh shit, y'all crazy.
So she's saying in pleadings now that she's not required to get county approval, but in the past, for people other than Wade, she had gotten approval.
This is actually the county attorney. So this document is the county attorney. I do not believe she's ever gotten approval for anybody. And her filing said she's doesn't. I mean, her filing. I at the break I was looking at it. I mean, she said that that I incorrectly contend that the appointment exercised by, and in parentheses, a state constitutional officer must be followed by an approval of the local government's Board of Commissioners. And she says over and over again that I'm just wrong, that she doesn't have to because she's a state constitutional officer. So that was their position, that she doesn't have to.
So is that one of the grounds for your motion to disqualify these, let's just call them financial irregularities, that she had not complied with the state law or county policy of getting prior approval
Yes, that was one of the primary bases. But then I also reviewed case law and saw, the conflict of interest. And, our motion, the theory, basically just to sum up the motion, is that essentially he's getting paid all of this money and they're not going through the proper procedures. And I go through it in the motion. I talk about how he didn't file an oath, which is rare. I'm one of those.
Didn't file a what?
He didn't file an oath of office. And I'm one of those people that I always, when I first start a case, I always make sure that everything is all the I's are dotted and the T's are crossed. So I always pull that. Anytime I've only ever had special counsel twice, and it's been people who were not paid, who were district attorneys in other jurisdictions who took the case on, which is the normal process in the state. But I've always pulled that just to see that they're sworn. That's something that's important to me. And I couldn't find it. So I did open records to the probate court, to the superior court, and there was no oath of office filed.
Sworn for the special assistant district attorney?
Yes. If you're going to be inside of a grand juries are highly regulated. I can't just go in a grand jury. None of us can just go into a grand jury. So you have to be a sworn officer of the state to actually be in there, particularly to present evidence. And so I wanted to see if he had taken an oath. And that's something that, you would file. It should be publicly available, not something that's really, highly contentious or secret. And there wasn't one. So, once I learned that, I was like, why are they not filing an oath? This is odd. There's no public approval of these contracts. There's no oath of office filed. This is different, what's going on. We later found out that he had taken an oath, but nobody had filed it, and the law requires, there's a statute that requires you actually file it.
I have looked at that. So the statute for a district attorney, their oath, when they are sworn in that position, says, I do swear that I will faithfully and impartially and without fear, favor, or affection discharge my duties as district attorney and will only take my lawful compensation.
Yes.
So help me God. Did Ms. Willis sign her oath that swore she would not take any unlawful compensation?
Yes, she did that. And then she also filed some disclosure forms that are required. There's financial disclosure forms that Fulton County requires that you file every year. And you have to disclose if you've received any gift over $100. So from anybody doing business with the county. And Fulton County is I used to be a Fulton County employee. They are very strict on those types of things. So anytime there's anything that could be construed as a gift over $100. And I've gone to lunch with prosecutors before who wouldn't let me pay for lunch because they're like, what if it's over $100? So people do take that pretty seriously.
So that would apply to Ms. Willis would not be allowed to receive gifts from whom?
From anybody who was, and I actually believe I attached it as an exhibit. It's basically anybody who is doing business or seeking to do business with Fulton County. So, and it's one of those. That
would include Mr. Wade, obviously. Then.
Oh, definitely.
Okay.
And that makes sense because that's one of those provisions that's supposed to, be guarding against honest services.
Like anti-kickback statute.
It's exactly right.
Hire somebody as a vendor and they give you gifts in exchange.
Yes. And so they require that you disclose that every year. It's signed under oath. You have to file in the Fulton County.
So how did you learn about this relationship between Mr. Wade? I think this has been acknowledged now by both parties, correct?
It has, yes.
It's a dispute as to when it began, but it's acknowledged that they had I don't know if they still do, but at least had a romantic relationship.
Yes.
How'd you figure that out? How'd you find out?
So at first, I knew Mr. Wade and I knew Miss Willis, and a lot of people in the community were a little surprised to see Nathan and Mr. Wade handling this case. It was just a lot of people said that, and so a lot of people were talking about that, and it was kind of surprising because it's not really, he does a lot of law practice, but this isn't what you would imagine him doing.
Did you ever see him have other billings? How do you have time to represent anybody else when he's billing, 24 hours a day to Fulton County?
He had other people working for him. Like he had a law student working for him for a while, and then he had a first year associate. So I'm assuming that they would probably do whatever other work he had.
Did you ever look at his calendar? Did you have access to that to see if it matched up?
No, I didn't have access to his calendar, and I didn't have access to their like text messages. I mean, I was able to get his geolocation data through subpoena, but the one thing that really struck me is if I was accused of something and I was saying I didn't do it, I would download my phone. They have a system. It's called Celebrate, and Fulton County pays for it. City of Atlanta pays for it. It's literally a system that you can hook your phone into. I have an investigator that has it, and I have my clients do it all the time. You hook your phone up, and it can text. It can find everything. And you can limit it. You can say, I only want texts with this person. So, if I was being accused of having an affair with someone and I said it didn't start until April and someone else said it started in October, the easiest thing to do is to, download that phone. And for privacy concerns, you can file it under seal, but you could easily narrow it down and say, I want this timeline. I want all of our texts from, November 2021, and it would easily tell whether or not they were romantic in nature.
Before I leave the billing issues, did you ever compare Floyd and Cross's bills to Wade's to see if they were billing a meeting together? Like there was that meeting with teams or what? Were they billing for the same meetings as well?
So I looked at that. One thing is we don't have most of Floyd's. So Floyd has not billed in quite some time. So I didn't have his to compare, but I did look at Anna Cross's. The one day that I remember looking at was when they were in federal court to see, because so Miss Cross was the one actually litigating in federal court. But Mr. Wade was sitting there with them at council table, and they both billed for that. I wanted to see if he billed for time that he was sitting in court waiting, because I know in Cobb County, for example, with appointed work, if we're sitting in court waiting, we can't bill unless we're actually doing something. Like they won't pay for two people to sit there. And so I wanted to look at that, but they were both there in court that day.
What about the teams meeting where he billed, or were either of them involved in that team since they're also outside special counsel?
No, they were not. So all of those people were people who would not have itemized that.
Okay.
Employees.
Back to your uncovering the relationship.
Yes,
How did you figure it out?
So Terrence Bradley was Nathan Wade's law partner originally, and he was also his lawyer in the divorce. I did not at the time know that they had filed for divorce. I knew Nathan's wife. I knew both of them historically from Cobb County. I mean, people knew them in Cobb County. Mr. Bradley actually called me after an article. We were looking into the financial irregularities. We're looking into how much money had been paid, because everybody in the case was kind of like, what, why do you have special
on this
counsel?
case?
On this case, yeah. Like,
Was
why are
Bradley still a partner with Wade at that time?
He was not. There was testimony that their partnership ended in summer of 2023. So it had just ended, is my understanding. And it's, it's kind of unclear, like what month. The testimony is very unclear as to when they actually, I have when they dissolved, I think it was September, but it's very unclear as to their partnership. And I will say their partnership was a loose partnership. They had a partnership with the bar, but they all had separate legal entities. So each of them were filed as the law office of Terrence Bradley, law office of Nathan Wade. They had some joint bank accounts, but then they had some separate bank accounts. So I don't really know the exact structure. It was a very loose type of organization, but they were working together. And so Terrence actually called me. He had seen an article where I had done open records with another lawyer, Manny Aurora, and we had uncovered how much money everybody had made. The news had gotten wind of that, and I later learned that the news had open records to get all of my open records. So every time I would get something, the news would get it, because I wondered how that happened. But so that somebody published that, and I had done some work. I did these open records and said, they're looking into us. And he called me because he was worried about it. And so we had a conversation, and he actually asked me, do I need a lawyer? What's going on? What are you investigating? What's the parameters of this? And we had a conversation. And I said, well, my interests are different than yours. I represent Mr. Roman, so I can't advise you. That would be a conflict. He asked if John, my husband, could. And I said, no, that's a conflict too. If you feel like you need somebody, you need to talk to someone else. At the time, that was early in September. I had court in Cobb County, and I ran into Mr. Bradley. I was in Judge Harris's courtroom. I think it was either September 11th or 13th. I checked my calendar a week or so ago, but it was one of those dates. And I was taking a plea in front of Judge Harris, and Mr. Bradley was also there. Another lawyer who ultimately represented Mr. Bradley at our hearing, BC Chopra, he was there in court also. And then a friend of all of ours, who's a district attorney, his name is Bert Cohen, he was taking the plea with me. And Bert and I have known each other for a long time. Terrence, BC, everybody's known each other for a long time. We were all sitting in a conference room attached to that courtroom, waiting for the pleas, chit-chatting, took the plea, went back in, and Mr. Bradley essentially went through the whole thing and said, well, this is what's really happening. I had a notepad, and I took notes on all the things to ask for open records.
So what did he say was really happening when he said, this is what's happening?
He said that they met at a judicial conference before. He was very specific that it was before she became DA, because that was one of the things that he couldn't remember when the judicial conference was, but he knew that it was before she became DA.
When did she become DA?
She became DA in it would have been January 2021.
Okay.
So she became DA January 1st, 2021, but she had a transition team leading up to that. So, and Mr. Wade was in charge of her transition team. So Mr. Bradley told me all of that. We met for about an hour. Said that they had been together. They met at this conference. Nathan was still married. And Mr. Bradley was upset because of what happened in the divorce. He was upset because they were still married, you know, the Wades were still married, and he essentially just left her after meeting Miss Willis and dropping the kids off at college. So,
and Bradley was Wade's attorney in that divorce action you're talking about? Okay.
Yes, I didn't know that at the time.
But they were law partners.
They had been, yes. Okay. And I actually don't know if he was still his attorney when he talked to me. I don't know if he was or not.
All right.
Because at some point Mr. Wade represented himself, and then he hired a different lawyer. So I didn't know anything about the divorce at that time.
So Bradley did not like the way Wade had treated his wife.
He did not.
But he represented him.
He did not like the way he had treated his wife. He didn't like what was happening in the divorce proceeding. Yes.
Okay.
And I mean, I remember specifically him saying, you know, I handle my business, things like that. Like, you know, that I don't leave my wife without alimony, because this, and we talked about it. I mean, Miss Wade had been a stay-at-home mom for, you know, they'd been married almost 30 years. And literally it was right after they dropped their youngest off at college that he said, move out, you know? And so we went through, you know, I was obviously interested in, wait, what's happening? Walk me through this. And so he was telling me about the access cards, you know, that Mr. Wade had access cards, telling me about the contracts, told me about their contract, that they had that Nathan had brought them the contract for the first appearance hearings. They had a contract for that. We didn't talk about that yet. That they had the contract for the taint work, and then ultimately that Nathan was hired as the attorney on this case. That they had been dating before, and
I had to interfere with Ashleigh to bring you some commentary from Angie. Okay, listen here, fat ass nigga, bozo. I ain't never said we was no motherfucking friends, so stop trying to put that shit out here like that. I don't play when it comes to my motherfucking relationships, and that one is a special one. A friend crazy? I know, like you, dislike you, this. No, you do fuck shit. For whatever fucking reason, because you got a fucking problem. Shut the fuck up. And you ain't got to say it's forever stuck. Bitch, it is forever fucking stuck. If I ride through that motherfucker, you gonna know it's stuck. When we stuck up your ass. Fuck you. All right, saying shit about me and fucking with me. The fuck up, so dumb ass. You don't want to say that ignorant ass shit. And as I say, at any motherfucking time, nigga, you want to do the breakdown, the motherfucking debate or whatever, baby, this link is always pinned to the motherfucking top. That would be the one invitation you have. You just come up here and say, yeah, I'm ready to debate. And I'll run your ass up out of here, bitch. Shut the fuck up. Always talking some goddamn shit. Your lying ass. All your buttons over there. The go live button say go live. The like button say click here if you like all these fucking lies with your simple ass. You crazy. Anybody that lie like that? But I want to be fucked up with your ass. Ain't my goddamn fault. Leave the fuck alone. Stupid. You a dumbass. Anybody that says the word WANTON is wonton like you eat out the goddamn Chinese restaurant, who you want to go up against and what? I told you. You better be glad Mr. Blessing in here, because I ain't going to repeat what I said. Because I was going to talk up under your clothes, but you better be glad You better be glad the Southern people up in here, okay? You better be glad, goddamn it, because I can go there. Your black ass. Leave me the fuck alone, weirdo. All you just know this, nigga. Majority, if not all, your relationships, your whatever ships, your situationships, they are based on pity, helping your motherfucking ass, and shit like that is not genuine. Because you ain't a genuine motherfucker. Understand that. Your crazy ass. Leave me the fuck alone, bitch ass nigga. So sick of this shit. I didn't perform something like you ain't walked away from a motherfucking thing. You ain't like my goddamn response, and I stand on them. But you ain't never helped me. What the fuck is you talking about? I don't know you. When I say I don't know you, I don't know you. Show ass out of here. Dumb. Stop throwing that goddamn friend shit out here like you and I was friends. Find it. And I am so anal when it comes to shit like that. I will come out and tell you who's who and what's what. And I will also tell you those that know don't even have to be named. Because they already know. They don't come out here. I never had you on no listen no goddamn friend. Are you crazy? Your ass up. There's a whole bunch of motherfuckers that go on the list for a friend before your motherfucking backstabbing crazy ass. Something wrong with you. Like you can't be a friend of your goddamn self, old fucking weirdo. You done sat there and started this whole shit about that lady was Officer A and shit, and that ain't even the goddamn lady. But now you sit over there in your doodle brown motherfucking outfit and shit, begging and shit, all this old weirdo ass shit. Shut the fuck up, hell. Motherfucking done went motherfucking broke. Goddamn supporting you motherfuckers. Leave me the fuck alone. Shut up.
He told me, they met at hotels. He would go to her place. I remember him saying, you need to find her bestie who they had a falling out. That's the person whose condo it was that they would meet at. And
did you later determine who that bestie was?
Yes.
See, my whisper come right on up in here.
It was very difficult to determine who that was because he did not remember her name.
But he knew her by sight.
He did.
When she knows, my whisper shows right on up like, Lord.
Yes. So I had sent him a couple pictures or showed him a couple pictures of some other folks.
This was in January of.
Hey, but it's so damn funny. I don't mean to stop it, but it's so damn funny that just about everybody that I know, I've been knowing all my life, but damn near that when I go to whatever, they say, Lord, and just throw their head down, including my child. And that's funny that that's why Karen J is like, I think I'm gonna point Karen J as the chief whisperer of the whisperers. Cause she be knowing. She gonna say, Lord. Oh Lord!
Right before your motion.
It was. It may have even been after I filed the motion. It was around the time. It was either before or around the time. It was in January. I had gotten some open records requests from the DA's office. They had a contract. Yep.
We just put on the screen some of the text messages that you produced to us.
Yes.
This is from your phone.
It is, and
you're talking to Terrence Bradley. I see over there on the left.
Yes, and so when you see on the 14th that one that's right in the middle that says file attachment with MIME type, that is a picture of her. So it doesn't show up on this, but it's actually there's a picture.
Ooh, y'all, wait a minute. Hey, these ain't the text messages that we read last night. I don't remember none of this. Let's keep going.
Giving him a picture to see if he can identify Robert Yeardy.
Yes.
Did he identify?
He did. Yes. He said, yes, that's her. That's the East Point. And he thought the apartment was in East Point. I later found out it was in Hapeville, but those are very close in close areas.
So he knew they would meet at that apartment?
He did. Yes. He knew all about it. And it was hard to find Miss Yeardy. What happened, and she was Robin Bryant, and then she got married and was Yeardy. I did an open records request for a contract that the DA's office got. It's called Critical Mention. She has I guess he's an attorney, but he's sort of in charge of communications. His name is Jeff DeSantis. He, right after Ms. Willis had opened the investigation in this case, that same week, he contracted a company called Critical Mention, which is a media monitoring company. They put a dollar figure basically on your media presence, and they give you these analytical reports. And they say, hey, you did great on MSNBC. That's $1 million worth of, stuff for your brand. The Fonnie Willis brand is doing well, or this phrase is doing well, things like that.
She had an employee in her office that was responsible for promoting her image, her publicity.
She had a publicly funded contract for this. So Jeff DeSantis contracted or called this company, and it's in the emails. I think I provided those as well, but contacted Critical Mention and said, we need to hire you to do media monitoring. And it was the same week that she had sent a letter to Raffensperger and Kemp about this case. So we need to have a contract to do media monitoring. Got $10,000 approved, paid $10,000 for a year contract for an annual contract.
Who approved that?
Jeff DeSantis's email said the county approved it, and his emails indicated that it was hard to get approved, that he had to really push, I think is what he said. There's some language to that, but the county paid for it.
Do other DAs do that?
I've never even heard of media monitoring. I didn't even know it existed. No, it was very shocking. But so I got some of the emails about this media monitoring. So I did open records, and again, once I got them, they shut me down and wouldn't give me anything else. But so these emails have attachments, they're PDFs, and you can see in the emails the hyperlinks to them where you can actually see the analytical reports. That's what I wanted to get, and obviously nobody would give those to me. But these emails showed a trail where two people in her office, so Miss Willis, Mr. DeSantis, and then Robin Yeardy, were the ones that had access to these to this Critical Mention profile. It's a platform that you can log into and see, how am I doing in the media.
What was Robin Yeardy's role in the DA's office?
She was a liaison between the news organizations. So she said that when CNN, MSNBC wanted her on, they would call Robin and she would coordinate it. She would do her hair and makeup, and then she would coordinate her interviews. But so how I found Robin was I'm going through these emails, and all of a sudden I see an email from Mr. DeSantis saying, take Robin off of this account. She's no longer with the office. And I was like, oh, I wonder if that's her. And so I found a picture of her and I asked Terrence, is that her? Because I found out she had been fired or been let go or had quit or whatever it was. And so that's how I was able to figure out who Robin Yeardy was. Then we were able to run her, run her information, get an address. And that's how we were able to narrow down where this hateful condo was.
So that's where basically Miss Willis and Mr. Wade would meet for their relationship.
Yes. But Mr. Bradley told me at that first meeting that they would meet at hotels. He told me about a lot of travel. I mean, he detailed, he detailed a lot of stuff. He said that they traveled to Texas, they traveled to Florida, just, a lot of different travel. He said Belize. He specifically said Belize, a cruise, the Bahamas, things like that.
And you were later able to verify that through other subpoenas or open records requests or whatever?
Yes, I was. I was able to, I subpoenaed bank records, I subpoenaed credit card records, and then I actually subpoenaed the travel agencies that Mr. Wade used for some of those trips. He used two of the cruises that they took, he used a travel agency. So there was a cruise to the Bahamas. I got through a travel agency. There was a trip to Aruba that I got through the travel agency. And then there was another cruise, I think that one was to the Bahamas also, that I got through a different travel agency. And then his credit cards are the ones that showed all the Belize trips.
And they showed that he was buying the tickets for both himself and Miss Willis.
Oh, yes, the credit card statements. So because I guess he used a travel agency, his credit card statements actually had her name and seat number and all that on it.
Okay.
So, there was no disputing.
It clear it was paid for by him on his credit cards.
Yes. Oh, yes.
Is this the document you gave us from Capital One there?
It is. Yes. And there you can see. So Clara Bowman is Mr. Wade's mom. So this was the cruise that happened October 31st, around that date. Mr. Wade paid for Miss Willis, Mr. Wade, and then his mother's plane tickets. And then also the cruise receipt. I think that one was Royal Caribbean.
Okay. So your summary here showing the trips, we know that in late October, they took a cruise to the Bahamas, and this is from his financial records. He paid for this for both tickets.
Yes, this is from his financial records. And I tried to be, there were a lot of Ubers and things like that. I did not include things like that,
Yeah.
I wasn't positive. I wanted to be under-inclusive, not over-inclusive.
And then you show the trip to Aruba, another one to Bahamas, one to Belize, one to Napa Valley, California.
Yes.
These are all from October 22 up till May of 23.
Yes.
Okay. This is a document you produced us.
Yes.
This summary, is this something we prepared?
No, it's a summary.
Okay. And so you discovered that and verified its accuracy through these credit card receipts, et cetera.
Yes.
Okay. Do either of them deny?
No, not at all.
And so is this the impropriety, the financial impropriety of getting financial benefit from the job that he's paying for her way on these trips with money
Yes.
that she's paying him and approving?
This is what I would call undisputed. Some of the other stuff on his credit cards, it looks like trips to Charlotte and Florida and other things like that. But this is what we could undisputed say was with Miss Willis.
So back to you're a good investigative reporter here. So you have heard these rumors, and now Mr. Bradley, just by almost happenstance, you're with him in court, and he spills the beans to prove it's accurate.
Yes.
And you identify year to get him to say, yeah, that's the woman whose condominium they would go to.
Yes.
Okay.
And I developed it. You joke about my investigator skills. I've done public defense most of my at some point or another pro bono. It's hard to get money for investigators, so I've learned how to do a lot of it on my own. I dig a lot on things. But what I did was I compiled all of the information Mr. Bradley gave me, and then I did various open records requests based on it. And then, once I would get something, I would reach out to him to verify, because I wanted to make sure that I wasn't tracking anything that was wrong.
Yeah.
I didn't want to make any allegations that didn't have support. So I would regularly verify with him, and I'd see him in court. We talked on the phone several times. I wasn't the only person that he told about this. There was another attorney on the case, Manny Aurora, who his client ultimately pled out, so he didn't continue this investigation, but he was involved in the investigation early on. And Mr. Bradley told him some of the same things that he told me. So I was able to independently verify a lot of things, which to me, investigating is important. That the East Point location, that it was in Hateville. Robin Yeardy actually did quit. Mr. Bradley had told
Was
me.
she forced to quit, or what? How'd that come
No,
about?
I don't believe she was forced to quit. That was a point of contention in our hearing. She said she left, that she was sent to another division. It's my understanding she had some, she was outspoken about, she didn't like some of the things that was happening in that office, and when she voiced that, she was sent to a different department to work, and it wasn't something that she wanted to do, because she did the communications, and so she quit after that, is my understanding.
Okay.
Based on her testimony and the allegations and all the pleadings.
All right, so after, I might be skipping parts of your investigation because it's pretty darn thorough, and you had gotten this track hawk or cell hawk, what's it called, where you're tracking the
Yes.
location. You were mentioning to me earlier when I kind of got y'all that employees can have it on their own phone if they want to, and she could have gone back and proven that they had not been communicating before he was hired.
Yes.
Yeah.
So let me explain that, because there's two different systems, and I'm always learning new things about this, but cell phone data is one of the new things in criminal defense. We see it in a lot of cases. The CellHawk data that you just showed, that is geolocation data. That is different from the Cellbrite. So there's two different programs. CellHawk is the program that does geolocation data. Essentially what you do is you get all of the pings. So every time your phone, you see those cell phone towers everywhere. Every time you use your phone, it's trying to find the closest tower. So in a metro area like this, there's a lot of towers. That's why we get good signals. So when he's in Hateville, there's a lot of towers. So we can really, really narrow it down. So what we had our investigator do, and I'm only talking about the geolocation stuff, I'll talk about the text in a minute, but what we had our investigator do was narrow it down. We got all the raw data, And we had him narrow down, and we actually excluded a ton of things that were not right on top of this location. Like, we wanted to be very, very careful just to have what was literally right on top of this location. So he created a geolocation fence, which
The location you're talking about is Miss Yeardy's condo.
yes,
Okay.
it is Miss Yurdy's condo, that area. So he was able to find, essentially, just to summarize a couple of things, where he, Mr. Wade would call Miss Willis at midnight, something like that. And then all of a sudden his phone would travel, and you can actually watch it. When you do the live Cellhawk, the app, it's pretty cool. You can actually watch the phone travel, and it's pinging because you're using it. If you have an app open, your phone's pinging. So my phone's pinging right now because I'm sure I have an app open. So it's pinging from his house all the way down to the condo at midnight, 1 a.m. And he calls her when he gets there. And then it goes silent for 4 or 5 hours. And then, early in the morning hours, he starts pinging again, driving back, and then he texts her when he gets home. So,
And this is before he gets hired in November of 21.
Yes.
Okay.
So, and there's a couple different ones, and I would defer to the experts on the Cellhawk data, but that's the summaries based on what we had him do. And again, we try to be very, very narrow. There were a lot of dates that it looked like it happened also, but maybe he was bouncing off a different location, and so we wanted to be very narrow.
So is that why y'all asked him in the hearing, how many times had you been to this location? I mean, you already kind of have the data on it.
Well, so that's an interesting point. All we have as defense lawyers is the right to subpoena evidence. I have to have an evidentiary hearing to do that. I could not issue a subpoena for AT&T for this evidence until I had a hearing date. So, and it takes a while to get this stuff. We got it that morning. So, the morning of the hearing, and obviously I'm kind of busy doing the hearing. We got that data. My paralegal was literally trying to download it for the investigator at the time and get it over. We knew we had the data, but we didn't know what it showed. So at that time, we didn't know, what it showed really until he was able to do the analysis. We had some preliminary reports from him, but nothing. I mean, it took a lot of hours. It's a lot of data. So it takes a lot of time to pinpoint this information. But the other thing that I was talking about, so this is the Cellhawk report, and heat map is just like how many times it's pinging. Heavy concentration is, you're talking a lot at this time, or you're at that location a lot. There's a lot of usage. The other thing I was talking about, just to make sure it's clear, so that's Cellhawk. Cellbrite is a different program. Cellbrite, and it's CELLEBRITE. Cellbrite is a program similar to Cellhawk, but it downloads data in the phone. So like this one is you pinging off of towers. It's geolocation.
Showing where you were
Exactly.
at a certain time.
Cellbrite actually can get your text, your pictures, your app usage. I mean, all of that stuff. So it's one of those things that if you want, if a defendant is threatening someone by text and they delete it, they'll take their phone and hook it up to Cellbrite. Cellbrite it makes what's called a forensic copy of the phone. But you can also limit the data. So it's very expensive program. So not a lot of people have it. So when I have my clients use it, it costs a lot of money for them to have it done. But the DA's office has it. They have the software. They pay for it. You can find that in their open checkbook. The city of Atlanta police have it as well. But what you can do is you can copy cell phone. So what I had mentioned earlier is
You have to have the cell phone to do that?
you do. You have to have the
So
cell
what
phone.
did Mr. Bradley give you all his cell phone? Or
No.
how'd you get Mr. Wade's cell phone?
So we did not get that data from Mr. Wade. So we only got the geolocation data from Mr. Wade. We cannot, I do not have the power to get the text messages. I don't have that power. I would have to have a search warrant. The state's the only one that has the power to add messages out of their phone. But my whole point in saying that was if I had been accused of having an affair and it didn't start, and I said it started in April and someone else said it started in November, they have the ability. I don't have the ability. They have the ability to plug that phone into the Cellbrite and print out a report that shows all of the texts.
So Mr. Wade and Ms. Willis, had they wanted to disprove your allegations, could have just used that Cellbrite program and it would have shown no communications between them.
Yes. And it would have also showed the contents of the text. If the texts are romantic, if they're not romantic, if they're friendly, and they would control the data. So if there's something that was privileged, they could redact it. If there's something that, that they wanted to only limit it to, like, we want to prove that we weren't talking romantically in November. They could
So
limit
they
it
could
to
have
that.
actually pulled up the text itself to say, hey, I need you to help me work on this case, or else, hey, I need you to meet me at the Love Nest.
Yes, 100%. Yes. I don't have that ability. So I don't have the ability to get a search warrant and get that data. All I have the ability to do is get that geofencing.
Who found out about these 12,000 texts and calls and all that kind of stuff?
That is what I was able to get by subpoena. So I was able to get the geolocation data by subpoena. What I can't get is what's inside of the phone. I can't get the text inside the
The
phone.
words in the text.
Exactly.
But you were able to find out that they were texting each other
Oh yeah.
prior to November 1st of 21.
Yes.
How
And
did you find that data? Is that anything you produced to us?
that is so the CellHawk data actually analyzes that. So you can see and we just summarized 2021. So approximately 12,000 interactions, that's voice and texts for the year of 2021. And again, remember 2021, he didn't get the contract until November.
Right.
So most of 2021, he's not under contract. Over 2,000 voice calls, almost 10,000 text messages.
How did they explain that? Did you confront? We're not privy to what all came out in evidence at the hearings that you've had. Did you get either one of them to say, that's not true, we didn't really talk 12,000 times? Or
No, what they did was they filed an affidavit saying that geolocation data is not always reliable.
does that apply to Cellbrite data though?
No, it doesn't. And it was ironic because I have a number of cases. I mean, almost every murder case I've had in the last decade has had geolocation data.
Used by the prosecution against the defendant, right?
They use CellHawk data. I mean, literally, they're using this right now. So our investigator actually analyzed the same. There's a trial going on. It's called the YSL trial. There's the same data being used in that trial, and our investigator actually analyzed it for them in that case. So I mean,
For them, you mean for the Fulton County DA's office?
no, for the defense looking at that data. So the point is, they're currently using the same data in another one, but their defense in our case was that it's not reliable.
Got it. And did your Cellbrite data come in? The existence of the cell phone calls?
No. So the Cellbrite data, that would have to be voluntary on the part of.
Okay, didn't do it.
No.
Neither Wade nor Willis.
No.
Okay. All right. So you've done your investigation. You've determined you think there was a relationship that had begun before he was hired.
Yes.
And after having met with Mr. Bradley,
Mhm.
you began to prepare a motion to disqualify and to dismiss the case altogether, right?
Yes. I actually started the motion in September
Cell phone.
and then added to
text
it.
messages. All right, and so then you somehow preserved, you had text communications with Mr. Bradley to confirm this,
Yes.
and was that because you didn't want to file a pleading that was inaccurate?
100%.
You
I mean,
wanted him to verify the accuracy of what you were claiming had happened,
I did not want to say one word that had not been verified.
because he was the source.
Yes.
He's the guy that was his law partner and his divorce attorney,
Yes.
who probably knew. So let's pull these up, Senator. When did you?
So I actually, Mr. Bradley uses an Android, I believe. And so it was not easy to just download them. And I'm not the most tech savvy person. I also, there's a lot of texts that just went into things that I didn't think, I thought would just embarrass people and weren't relevant. So what I did was I screenshotted the texts that I thought were relevant. I tried to use those in court, but the prosecutor kept objecting and saying I was hiding things because I wasn't showing all of my text. So they just kept.
Child, we is good over here. You see who we stuck with? We stuck with Big Terrence with his big hot mouthing ass and them messages. So I ain't play Fanny. I ain't play that dude Nathan. Like I said, I downloaded 2 Chainz. I'm gonna play 2 Chainz. Fucking hot mouthing. And I played when I found out that Terrence had and took the stand. I found those videos and downloaded and played them with y'all this morning. Saw how he was talking. Now, this woman has successfully solicit and elicit that information from Terrence. And he is fixing to lead them right. Lord have mercy. Right into the belly of the beast. All that hot mouth. I told you, I have a problem with that hot mouth. And shut up. And you are, sir, you an attorney yourself, sir. You knew. Oh. She running her mouth like, baby. She got them big old grandma pearls around her neck. Again, Terrence, when it came to the job and her case, she was going to always pick her case. She didn't give a damn about y'all being friends. Nathan and none of y'all. Throwing y'all up under the bus. It's crazy.
On and on for days, saying I was hiding things. And I explained to them, I let them look through my phone. They scrolled through all my texts.
Who's they?
It was Adam. So he just kept saying, that I was, where's the beginning of that text? Where's the thing after that? Where's the other part of that text? These aren't complete, rule of completeness, kept objecting. And I had just screenshotted the texts that I thought were highly relevant, but weren't slanderous, I guess. I don't even know the word, but there were some that that Miss Willis's daughter had failed out, like things like that. They were just ugly. They didn't need to be admitted.
Oh, I've read that.
I had tried really hard to just screenshot the relevant ones, but they kept saying that I was hiding stuff and I wasn't showing the whole thing. So when they objected to my text coming in the screenshots, they said they wanted the whole text chain, and the judge ordered me to, if I was going to admit the text, to go figure out a way to download all of them. So I bought a program for $20-$30 and took 3 hours. And I was very proud of myself for finally figuring out how to do it.
I got to stop it again. I'm sorry. I got to stop it again. I got to stop it again. Hold on. Let me pause this foolishness. Okay. She's running down there, the big white. And to tell all about what she's low-key telling all of the hurdles and shit and all of the shit they done took her through in the little hearing. Yes. This is crazy. Oh my gosh. I'm mad at all of them. But big Terrence, you're gonna have to move your mama in the words of Dvorsky, you have to move your mama. Oh shit. So she's up here crying about the rule of completeness. She knows the rule of completeness dictates that if asked, you have to submit the text messages or whatever communications before or after or around that conversation or around that time period or whatever, so nothing can be taken out of context. So everybody in the court can have a proper and complete and informed opinion about what you're submitting, honey. Why are you down here complaining to Big White about all the hoops and shit you had to jump through? They legal hoops. Jump through them. This your damn shit. You the one signed up. I want to fight her ass.
Redact our phone numbers. So this actually showed like when they're read, when they're viewed.
What were you? All right, so up there on January 5th at 9:50 a.m.
Mm-hmm.
You're at. What do you read the question?
So I'm asking him, do you think it started before she hired him?
You're talking about the affair.
Yes, the affair.
What's his response?
His response was absolutely. It started when she left the DA's office and was judge in South Fulton. And so, these are things that he had told me, but I was getting ready to file. My filing deadline was the 8th. And as we're doing this, I'm fact checking line by line, basically.
Right. So did you send him a copy of your proposed motion?
I did. And I actually admitted, so at the hearing that we had, I was able to admit the email where I sent him that. So I sent him a copy of the motion that weekend when I was I wanted him to review it. And then he had a text. He didn't write me back by email, but I submitted my email so that the court could see exactly when I sent it and when he responded. And then he responded that everything looked good. Because I asked, I said, I'm sending you this motion. I need you to look at it. And then he responded that everything looked good in it.
Right.
He actually, because I had not included the information about how much money he had, I didn't know that it wasn't really highly relevant to my motion. But he was like, oh, that's going to tip them off that I'm talking to you. And he did not want anybody to know that he was talking.
Oh my
Was
God.
very concerned about what.
I'm going to let you just read through this chain. We left off up there.
Right, Carla.
It began before it began when she was a judge in South Fulton. When was she a judge in South Fulton?
She became a judge in August of 2019. And I did an open records. I first asked, I first did an open record.
Listen, this is an announcement to all you goddamn doxers out here, bitch. Y'all ain't got shit on Ashleigh Merchant, motherfucking ass. She gonna dox every goddamn body in the state of Georgia. God, she know this shit without even looking at it. She became a DA and just dated her. Oh. And no wonder you remember all them boards and shit. That's just something they be telling us to do. And if you interested in that type of stuff, yeah, you go join all these boards and stuff like that. You be all everywhere and stuff. But who actually have the time to really commit to all of them like that? Like, because she don't read. She said she active members of all these boards and stuff like that. But bitch, girl, do you drink coffee all day? Girl. Ain't nobody gonna ever tell you shit. You gonna hang that up.
And they said no. So then I subpoenaed the records for the judicial conference, the municipal court conference.
So she was a municipal court judge.
They were both municipal court judges. So I got the
Who's both? You mean Wade was the judge at the time?
Wade was a judge. He was actually a speaker on the panel. It was October 2019. So I found online an old agenda where he was speaking, and Terrence Bradley had told me that they met at a conference where Wade was speaking and Willis had gone. So I knew that. So I found, and it was in person, so I could narrow it down because of COVID. I figured out when COVID happened and when all the conferences went virtual. Narrowed down my timeline. So I searched for this specific time period, which is when Bradley had told me the relationship started.
And when was that conference?
It was October 2019. So I found the agenda for that. So then I reached out to the municipal court judges CLE group and said, here's an open records request. I would like a list of attendees because I wanted to verify Miss Willis went there because I was trying to fact check.
CLE is continuing legal education conferences and classes and stuff like that we be going to. I'm sorry, the ones that be interested in going to, unless you got to go to them. Oh, Lord. She probably go to all of them. All over the country. She probably go to all of them. I mean, when I tell you, this is the best example of when I tell you your law degree function is many different aspects, and investigation is one of them. Good God Almighty! Whew. I mean, bitch, do you have anybody else working in the office? Because it seemed like she did all this herself. Oh my goodness.
And they said no. So I subpoenaed them and they gave it to me. I also subpoenaed.
Was she in attendance?
She was. I also.
Where was that conference?
It was at Lake Lanier.
Okay.
I also did an open records request to the city of South Fulton because I know that they have to sign off if your judge is going to go to a conference. So I did an open records request to them to make sure that they had actually sent her to that. So I verified from 2 different sources that she attended that conference, and that matched what Mr. Bradley had told me.
Right. So is that a part-time job, a municipal court job, the judge?
Yes,
Okay.
it is.
So Wade could continue practicing law and do that on the side.
Well, so she was a full-time, but Wade is a part-time, and Wade only did maybe once or twice a month at most, because he was in the city of Marietta. I mean, he was a fill-in judge for that. That wasn't his.
Okay, so you narrowed it down to that's when the relationship began. Scroll through here for us, and I can't read that green. What's
Okay.
the next? If you don't mind, just sort of.
No, of course. It says, "Is this accurate?" And this was again on
So
January.
you're saying, is this accurate? You're going over this brief and saying, I'm about to swear this in court. Will you verify it's accurate?
Yes.
Okay.
So at that time, I was going through the actual statement because I was trying to figure out how to say it, and so I said, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And he corrected me and said, no, it was municipal court.
You had said magistrate court, and he was in.
Right.
Okay.
And I was, I slipped up. I should have said municipal court. I knew that.
So you say thank you. What was his response after that? No, this is 12 something p.m. on January 5th as you're getting your pleading ready.
He said, you can't put where they met. Not many people know that. I might be one of only, not even Chris Campbell.
Chris Campbell was their other law partner.
Yes.
Okay.
And I did not disclose Mr. Bradley in my initial filing. I didn't until the state forced me to.
Why was he afraid to be disclosed? Just because of his relationship with Wade, or was he afraid of these people, or just didn't want to betray them, or what?
Multiple reasons. I mean, it's the district attorney in Fulton County. I didn't really want to go, file something against her. It's not exactly a fun position to be in. Also, I mean, they have a lot of mutual friends. I'm sure it wasn't a fun position to be in, to be outing a friend of yours, but the attacks, I mean, it's a small legal community.
Were you able to get this into court? Because Bradley, I saw some of his testimony, all of a sudden can't remember anything about anything now. Were you able to use this to impeach him and show that he did know precisely what happened and when?
Yes, and he changed his testimony somewhat. At first, when he first testified, he testified that he had never discussed this with me. And
then you showed his text message where y'all discussed it.
Well, that.
Oh, hell no. Now, I think that was real unprofessional. He gonna laugh, Big White gonna laugh about the shit, because he really is in awe that she did a real good job. But notice the question he asked. Were you scared of these people? Were they scared of these people? Whatever. Trying to see if he can get any type of inclination that Wade and Fannie may be the type of people that people that holds authority, but that somehow are threatening, or people feel intimidated by them, which will give him another angle to press to get them to to say where they should be they should step down or be removed or what have you, right? Yeah. See, you ask questions just like she was asking Terrence to get angles in which to go, right? To further your prosecution. Okay. Big White is asking questions for the same reason. Yeah, this is crazy. Her talking, but Terrence need his ass whipped. And we're gonna see what 2 Chainz said too.
At that point, that caught me off guard. So, I didn't expect that. So then I pulled my text messages, and I had some screenshots of them just in case. And I told his lawyer, do you want to look at my text messages? And so then he later came back and testified that yes, he had.
Tat told you that.
Yes.
Okay. And did Wade testify at any of these hearings?
He did.
Did he acknowledge the relationship or not?
He acknowledged the relationship, yes.
Before he was hired?
No, he did not. So before I filed the motion, nobody acknowledged any relationship. So I filed the motion on January 8th, and then on Martin Luther King.
Walk us through that. What were the grounds why is it you feel like Bonnie Willis should be disqualified from continuing this prosecution?
Yeah, and so and these are things that I alleged in my initial motion that was filed on January 8th. I outlined this. My client in particular was not part of the special purpose grand jury. They did not recommend him to be indicted. He wasn't part of that. So he was added on.
That's interesting, because I remember hearing that the special grand jury had recommended prosecuting like 40 something people.
They had.
He was not even in that list of 40.
He was not.
And they didn't take, or they, as in Bonnie Willis, did not take the advice of her own special grand jury as to more than half the people they wanted prosecuted.
Subsequently, there's been a book that was published that called "Find Me the Votes," that authors had exclusive access to her, and so all of her theories in how to indict people and who to indict was explored in that book. So from that, I was able to learn that she cut a lot of people. And I mean, I have
Is that because they cut deals with them, immunity deals, or
some of them are that. Some of them I just don't think she wanted to bother with.
then she added to the list though people that were not even recommended, or
My
at least your client.
My client, yes, she added him, so he was one of the ones. So there were some people, and it's publicly available in that book, like Senator Graham, Loeffler, those Purdue, those people.
They recommended prosecuting them.
Right, she had considered prosecuting them and taking them off the list. So there were a lot of people that had been on the consideration and then had been removed. And my client had not been considered, and then he was added. So to me, I was trying to figure out, why would you want to expand it? There's different ways you can go about prosecution.
You figure out why they add your client to the list?
No, but the my allegation and my motion is that the bigger the case is, the more money that's made, and that that made sense to me. So for me to file the motion to disqualify, obviously we had to have some type of a basis, besides all of the violations, and so expanding the litigation. Because of how large it is, the judge has said we're probably going to have 3 trials, and each of them is going to take several months. Where if you just imagine, follow me down the path, if you only indicted one person and it was narrow, you could try it in a month. If you indict 19 people and, 3 different essentially alleged criminal schemes, like I divided it up earlier, that you now have 3 years of trial. You've now gone from a month of trial to 3 years of trial. That's a lot more money. And so that, to me, was a financial motive, particularly since my client was not recommended by the special purpose grand jury to be indicted.
And you had the data to show that she was financially benefiting from the continued prosecution.
Yes. And so to answer your question, you were saying walking through it. So January 8th, I have a deadline to file this. So I'm verifying. That's what you can see in the text. You can see heavy text with Mr. Bradley right around then to verify everything. I file it. And at that point, the world is shocked. I mean, shocked because nobody had any idea. This had been hidden. This was even hidden from her father, who she had testified she talks to 10 times a day. So very few people knew about this relationship. And so they very much wanted to know who knew about it. Mr. Bradley,
Girl, don't be using that word situationship. Get your ass on up out of here. I'm sick of your ass.
Next weekend, he gets some calls about, he gets a call, trying to fish to see if he's the leak, is what it was couched as. He gets a call from a gentleman named Gabe Banks, who ultimately represented Chris Campbell he filed a motion to quash against Chris Campbell, who's the law partner.
Gabe Banks' wife works for the DA's office?
Yes, he does. She does.
Works for Fonnie Willis.
Yes, and I've not gotten it. I've not open records it, but I have been told that Mr. Banks also has one of these.
So I know we went through motion to quash before, but motion to quash is pretty much a request to stop a legal document, a legal request to void it out for validity or it's insufficient or what have you. So it can be a motion, it can be a warrant, it could be anything like that, but it's pretty much to shut it down when they submit a motion to quash.
Special counsel contracts. Again, I have not open records. That's not part of my case. But so he calls Mr. Bradley, and Mr. Bradley calls me and another friend of ours. Her name's Cindy Yeager. She's a district attorney in Cobb County, and he was upset. I talked to him. It was, I believe, a Saturday night, and I could tell he was upset by his text. I left my kids and went and talked to him because I was worried about him. And, he took it as what he described to me as the first shot against the bow, that they were trying to figure out if it was him, and they were trying to silence him. Gabe didn't
silence him.
Mm-hmm. And he said Gabe didn't say anything that threatened him. He just out of the blue called him, and he hadn't talked to him in quite some time. So it was out of the norm for him to call. So Mr. Banks called and told him that, meaning if he was my source, and Mr. Banks said that it was because he had seen a news article, and Mr. Bradley knew that wasn't the case. So he said, send me the news article. So he sent him some article that did not say he was the leak, and that put an end to it. But then the next day, Mr. Wade called Mr. Bradley's best friend and said, he didn't call Mr. Bradley directly, but told his friend to call Mr. Bradley and remind him of his privilege.
This is attorney-client privilege.
Yes.
Who's the best friend? Can you tell?
I'm not. He told me his name, and I'm not positive. I think I know who it is, but I'm not positive.
All right. So Wade calls Bradley's best friend, says, "You better call Bradley. Remind him he's got attorney-client privilege with me, and he better not spill the beans."
I do know the best friend works at a law firm called Beasley Allen. He told me that. He said his best friend's name, and then he said he works at Beasley Allen. And he was pretty upset about it. And it was the same day of Miss Yeager's birthday. So he didn't want to call Cindy, but he was upset. So he called me, and we talked about it. And we were both pretty upset about it because it seemed,
Tampering with witnesses.
it just seemed like tampering. And it's just, it's just an uncomfortable position to be in, and all of us were kind of worried how the state would react to all of this. But at that point, it's
Did
still.
he interpret that as Miss Willis trying to intimidate him from revealing this affair?
Or Mr. Wade.
Okay.
He took it as intimidation, yes.
All right.
Because what he called it as is the second shot across the bow. Those were his words. So he said first shot across the bow was Gabe Banks, second shot across the bow was Nathan Wade calling. So that's how he interpreted it. But at that point, I had not disclosed him as the witness, as the primary source. So nobody knew that. And I was trying to protect him as much as possible, just because I knew he didn't want these calls. It's not something that you want. So they filed some motions to quash, and I had to
Quash what?
quash all of the subpoenas, pretty much every subpoena that I had issued.
So after you filed this motion to disqualify, I guess a hearing was scheduled,
Yes.
and
Yes.
then you started issuing subpoenas to line up your evidence.
Yes. So
That's when this witness tampering occurred?
Yes.
After that, to try to intimidate your witnesses from coming to court?
yes. So, and let me walk through the timeline. So I filed this on the 8th. The next thing that happened was Miss Willis testified. She spoke at a church on Martin Luther King Sunday, and was making some statements about why did they single out Mr. Wade. Didn't say anything about that we singled him out because he's the only one she's having an affair with. Did not agree to that. Instead said that it was racially.
And the other two special prosecutors were white,
Yes.
but they were making significantly less money.
Right. And she even said, to the church, she even said that I'm paying them the same rate, which is not true. Mr. Floyd's contract is for $150 an hour. It's never been $250 an hour. So that, one of my kids was listening to it and, said, come listen to this. And I listened to it and I was like, wait, that's not true. So that was one thing that she said that wasn't true. Also that it was racially motivated. She didn't say anything about, they're singling him out because he's the one I went on all these vacations with and he's the one I'm romantically involved in. Instead, she said that we were singling him out because of race. And then she said that they were all paid the same, which is not true. So I thought at that point, okay, they're not going to admit that they have this relationship. And so I'm texting with Mr. Bradley, oh my gosh, are they going to lie about this? Like, it's on their credit card. Like, I don't know what's going to happen here. And so then in the divorce proceedings, Miss Willis had been subpoenaed to testify, and she actually invoked her executive privilege as the DA.
She didn't testify.
She would not testify. So
And
then
then they settled it.
right, and then they settled it because because the judge said he was going to have to testify. So they settled it, and he did not have to testify. So at that point, the judge had given us a hearing date, so I was able to issue subpoenas. So my subpoenas started going, and I filed the returns of the subpoenas, and all of a sudden the motions to quash started coming in. Right around that time, the state filed their response where they admitted to this relationship, but they put limits on it. So their response that they filed, I believe it was February 2nd, I believe February 2nd, they filed their opposition to our motion. They admit that there was a romantic relationship, but they claim that it started after he was hired and that all of the gifts and travel was roughly divided. They submit an affidavit from Mr. Wade, and they submitted a receipt from a credit card where she had paid for one plane ticket. So, it was a couple $100 on hers and then thousands of dollars on his. So then my subpoenas were filed, and every single one of them had a motion to quash. And they kept saying, I don't have a good faith basis. I don't have a good faith basis. Kept very harshly saying that I was making this up and nobody had told me this, and it was, gossip, and I was lying and I should be sanctioned. So the court held a hearing on their motions to quash, and I was forced to disclose Mr. Bradley as a witness, which I did not want to do because I was worried because I knew they had called and all of these things. but I had to disclose him as a witness. And so at that point, I was still talking with Mr. Bradley fairly regularly, but that then changed.
Okay. So you're waiting on the judge to rule on your motion to disqualify.
Yeah.
In summation, the grounds for that are what? That this is improper for a prosecutor to have a relationship with the special prosecutor?
Yes, it is a conflict of interest.
And that's because of the financial benefits, or just because?
Mainly the financial benefits. There's a couple different aspects to it. We've also alleged some other misconduct because.
So, Bim, we got the answer now. So early on the early one, I wasn't sure where they was going with it, but just based on the certain just general knowledge that I figured they was trying to say it was a conflict of interest. Okay. So, and that's the reason for the disqualification. So she just confirmed it. It was conflict of interest. So it has nothing to do with the money, or it has nothing to do with the fact that she was in a relationship with them. You got to take it back. That is just the babies from the relationship, if you could say that, right? You know, the money that they allege he received, the benefit from being in a relationship with her, this, that, and the third, right? The fact is that it was a conflict of interest, and she's going to explain more. Give us the details, Ashleigh, because I know you're waiting.
The prosecutors aren't allowed to publicly condemn an accused prior to trial. And she made a speech at a church and said this was racially motivated, talked extensively about the clients being guilty. She testified at our hearing that our clients were guilty, that my client was, guilty of trying to, I don't even remember, subvert democracy or something. But she's made a number of public statements condemning their guilt, which is not allowed.
That's inappropriate conduct for a prosecutor.
Very much so. And there's case law on that. There's bar rules on that. So there were a lot of public speeches that were made along the way. And, you can kind of follow them through this media monitoring company. But so she makes these, and then she got disqualified from prosecuting another person she wanted to prosecute.
For making public statements.
It was for a fundraising. She had thrown a fundraiser for his opponent, his political opponent.
Right.
So when that happened, you sort of see her press stuff dwindle a little bit. So she stopped making as many public comments. But then when this motion came about, she made the church speech, as I call it, where she's, calls me and, my client racist, and says, condemns their guilt. And then she also gave interviews to this book. I don't know, the timing was just nuts. But the book came out right around the time that all this was happening, and it's called Find Me the Votes. And
that came out in 2024, you're saying?
It came out a month ago, if even. And she literally let the authors of this book in when she was deciding how to prosecute this case, who to indict, who not to indict. I mean, their whole thing is that they had unfettered, behind the scenes access to her thought process and stuff. So, and she's talking about all of this.
Is it me, or are y'all not getting upset at the smirking and at I can't believe they were this dumb. I can't believe they were this stupid. And see, that's why I be telling y'all, I be chasing these white people down in the streets about their racist shit. I don't know if it's just me, but I'm extra sensitive to shit like that. Okay? Verbal and symbolic shit. I don't give a fuck. Listen, that'll get you chased down by one of my cars, bitch. Fuck on.
They're guilty, but the big thing for the forensic misconduct is she's in the church speech. She's saying, and she says this in the book too, that God has told her to prosecute them. So the theme between these two things is that God told her to do this, and that she is doing the will of God by prosecuting our clients. And
that's unethical,
in my opinion.
All right. So there was, I'm trying to recollect what I remember reading in basically the Atlanta newspapers about all this, because this was new to the state Senate as well, because all of this began on January 8th, which is that the day we started, 8th or 10th or something. It was the day session began, and all of a sudden these bombshell allegations come out. And I think that was the motivation for our Senate resolution forming this investigative committee to say, let's find out if this is true, independently of all you guys' legal issues or whatnot. So I remember she wouldn't testify in the divorce case. But did you subpoena her to testify in your motion to disqualify?
Yes, and she filed a motion to quash.
She refused to testify, but then she came to court and did testify.
Yes.
Okay. And in that,
as they were arguing the motion to quash.
I wondered, okay, so in that testimony, did she deny the start date of this affair?
Yes, she said it started in early of 2022. There was some discrepancy between them, a month or two here and there, whether it started, generally it was around March is what Mr. Wade.
So what are the consequences for an attorney to give sworn testimony that she did if you're Bradley, what is it, Yearkey? Yearty, your Trackhawk data, your other independent verifications are found to be truthful?
It's a crime. It's a felony. You lose your license. It's perjury.
Same for Wade.
Yes. And we have rules that are one of the, outside of privilege and confidentiality, we cannot suborn perjury. So if I have a client who tells me I did it, I can't put them on the stand to say I didn't do it. I would lose my license over that. I cannot do that.
Yearty came to court and said, oh yeah, this started in 2019.
She saw them, she saw them together. She testified that she saw them romantically together. And they were very close.
And you had Bradley's text message that showed he confirmed that absolutely back in January.
Yes. And he had a lot of details, little details that matched up.
Did you get other details from him by phone?
Yes.
That wasn't in the text. What did he?
A garage door opener that Mr. Wade had a garage door opener, and then I subsequently learned that he told Mr. Aurora the same thing.
Garage door opener to her place.
To her place.
Okay.
Mm-hmm. Yeah, to her place. There were other things. Just a lot of context. Things about how freely Mr. Wade could go in and out of the office, the DA's office, stuff about they would sometimes use hotels. One thing that he told me was that Mr. Wade had, before he filed for divorce, had used Mr. Bradley's credit card and then paid him back in cash so that there wouldn't be a record of it.
Okay. All right, so I'm a little puzzled by the legal standard. I'm reading the newspaper articles that explain to us the difference between a conflict of interest and an appearance of a conflict or an appearance of impropriety.
That is the big argument right now. And I'm not the best person to explain that. My husband argued that part. But appearance of impropriety, it's one of those things like that if it undermines the outcome, undermines the competency in the outcome. And we spent a lot of time in our brief talking about the constitutional underpinnings of this. Due process, that my client has a right to due process. He has a right to a fair and impartial prosecutor. And we don't think that's happened in this case. And so I think that would be more along the lines of the appearance of impropriety. And then actual impropriety is receiving money, like receiving money and not paying it back. And there was testimony about that. Ms. Willis came in and testified, and Mr. Wade did, that she paid him back in these sums of cash, but there's no records of any of that or where she got it.
Anything shows him depositing cash or
no,
receiving cash?
No. And, we asked her like where you got it. She said that she said she borrowed it from her campaign. So, she said the original large sum of cash came from her campaign.
I think all of us up here that have campaigns know you can't take campaign funds for personal use, right?
I'm not well versed in that area of law, but that is my understanding.
It's pretty black and white.
So she testified that she took that the majority of the cash she had on hand was from her campaign. That a loan she had given herself from the campaign. She was very clear about that. And then she also said that when it got low, she would supplement it by getting like $50 back at Publix. But she's giving him, $4,000, $2,500. So, large sums of cash. So, and there's no trail. Obviously, there's no record of any of that.
In some of the documents you produced to us, there are a couple of IOTA trust accounts.
Mm-hmm.
Those were Mr. Wade's account?
Yes.
So he had more than one trust account in his law firm?
Yes, he did.
And did you find any discrepancy or whether these funds were deposited there?
Yes. And, so he testified because we asked him where he deposited the funds.
And these are the funds where his paychecks basically from Fulton DA's office?
Yes.
Okay.
At first, he deposited them to his joint IOLTA that he had with his law partners. And then he started depositing them to his when I say personal, just him IOLTA, an IOLTA that did not have anything to do with Mr. Bradley or Mr. Camp.
Do you think Mr. Bradley was aware that he was running the money through a separate account?
I think it might have been part of the reason that they dissolved.
That they broke up?
Yes.
Do you think his ex-wife knew that this money was being held in a trust account rather than previously it had been going through his home bank account?
His ex-wife didn't have any idea. I mean, you can tell from the pleadings that he was even making this much money. He filed some interrogatories and some answers in that divorce case saying that he made a couple $1,000s a month. I mean, very, very minimal amounts.
Well, we knew he was making up to $35,000 a month under this contract.
Right. And he has a lot of money parked in one of those IOLTAs that's not disclosed in the divorce.
So that's, does it look like he was using his law firm trust account or his personal lawyer? IOLTA is a legal trust account, right?
Yes.
The interest from it goes to the state bar to help fund some
Yes.
indigent care or whatever. Right.
Yes. As much as I wish we could park money in our IOLTAs that was earned and not pay ourselves, we can't do that. So when you earn money, you can't leave it in your IOLTA. IOLTAs are for client money. So they're a lawyer trust account, and essentially what they are is like if you settle a divorce case, not a divorce case, I'm sorry, you settle a civil rights case or a
Personal injury case.
personal injury case, and you get $100,000, and 60 of that's the clients and 40 of it's the lawyers. It has to go into your IOLTA. It sits there until you clear the case out. You finalize the case, you send a settlement letter, you get the amount, and you have to put it in your actual business account, and then the client gets their check for their part. So IOLTAs are very highly regulated by the state bar. They can't commingle funds. It can't be earned money. It's got to be money that's not earned. And the interest does go to the state bar, but once you earn the money, you have to pay it. You have to have it in your account because you have to claim it on your taxes.
Right.
I mean, lawyers wish that they could keep money in IOLTAs and not have to pay taxes on it until it was a year that.
So sometimes
they wanted to.
attorneys may take a retainer
Yes.
up front and bill against that retainer. So you might do that on some of your criminal cases. So yeah, I'm going to take $25,000, I'm going to put it in my trust, and then I'll submit an itemized statement and pay myself as I earn the money.
That's exactly what they do with retainers that are refundable. So they would ask, $10,000 retainer, and then if this month I bill $1,500, I send you a bill, and then I take the $1,500.
So these funds, if they in fact came from the contract with Fulton County, should probably never been put in a trust account at all because they were already earned after he had done the work, and within some amount of time after that he sent the bill and he got paid for work that had already been done.
I mean, if they were put in a trust account, they would need to be transferred quickly.
Is that the kind of
I don't do that.
ethical violation that can get you disbarred?
They highly regulate the IOLTAs, highly regulate. I mean, the state bar, like there's a list of places that we can do banking because they're regulated by the state bar. I have to go in person for most of my IOLTA transfers. They're not something that I can do like online banking. I mean, it's a pain. But yeah, so they're highly regulated, and we know these were deposited in his IOLTAs because the back of the checks for Fulton County show where they were deposited.
And have you asked him about this? Has he given any explanation for why he ran this money through a trust account? Or is it still in there? We don't.
I mean, the last I knew, he didn't give any explanation. I mean, he just said that he pays for everything through his business, and then he basically just said his accountant figures it all out.
Okay. I know you have a court appearance this afternoon, and you've been very patient with us. I'm going to give Senator Harold Jones an opportunity to ask a few questions. Under our rules, we do allow at least one member of the minority party to participate. And Senator Jones, you're not time limited. If you, when the buzzer hits and you've got to go to court, you tell us, but I feel like we got at least 15, 20
You
minutes.
definitely do. And I'm happy to answer any questions you have. My court's at 115 in Fulton County. So, if I get in trouble, if you can call the judge. Then I'm fine.
Oh, and she'll kiss ass. Oh,
I just want to go back to the issue about the conflict. The thing that's kind of brought us all here to some extent. On one issue, in your brief, the most recent one, you went in and acknowledged that the aspect about him not signing, I believe, or being duly authorized to be a prosecutor, that's already been handled in one court, but you're still bringing that issue back up. But it has been decided in the negative in one court. Of course, you are still bringing that issue back up.
Yeah, so you're talking about the oath,
Right?
The oath issue. Yeah, so Manny Aurora was working on this issue early on, and he filed a motion about the oath. At the time, it hadn't been filed, and in and of itself, that's not, that's not filing an oath. That's not going to get rid of a case. That's not going to disqualify in and of itself. Clearly, the judge told us that in the order, but I was trying to paint the entire picture and how I felt that it was relevant, and it definitely is not a ground that I was arguing for disqualification, but I felt that it was relevant because it shows that they were hiding this relationship and all the evidence indicates that.
Right. Now, I just kind of show them I'm moving on to this next particular point here, which goes to page 24 of your brief, which deals with, I think, the thing that's really out there in the media, which deals with the relationship and aspects of that some kind of way this creates a conflict of interest. And of course, the judge is going to rule on that, but I still think it's important to kind of go through it. And you cite the case of Whitworth versus State. What in that case actually applies to this particular case?
I don't know if I'm looking. You said it was the last one that I filed?
Yeah.
So February 9th.
Yes, page 24.
Page 24. You said Woodward?
Whitworth.
I don't see Whitworth.
At the bottom, Georgia courts have developed their own standard for disqualification of prosecutors.
That's not my page 24. You must be looking at a different. The one that was filed February 9th at 3:47.
We can't hear you.
I'm so sorry.
Just pull the microphone just pull it closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47.
No, let's go back.
Okay.
Let's use your first one.
Okay.
Yeah. And there's a little bit more. Okay. So that one there in the Whitworth case, tell me how that actually impacts this particular case.
Which page are you referring to?
Page 24.
Page 24. So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification, held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me, but essentially, to answer your question, that first of all is physical present only. So
Right.
yes, so, and we
But you did cite it.
and said
Right.
that it's physical
Yeah.
present only.
And you that is the basis really to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict other than Whitworth and also amusement sales. In case you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had or the prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on.
Hold on, I got to listen. I got distracted for a minute. I want to roll back and listen to how the brother gets in our ass. And look at Carla done went back and got some of her family members to come on there and represent on the front row, baby. He done put his cowboy hat to the side, baby, in the chair, baby. You hear me? You hear what your old Harry Tugman done went got some of her family members, and look at the sister in the back with her arm folded. Ashley, you gonna have to run your ass up out of here today, baby. Oh shit, Ashley, I hope you got your flats in your goddamn purse, baby. That's why we carry the tote bag, baby, because Carla went got her people, baby. Look how he looking at her. Boy, he giving her a unit out of this earth. Look how he looking at her, y'all. Look. Look how he looking at her. Look at this man's face. Look at this lady's arm. Baby, they is sick of her ass. She gonna have to get her ass up out of there today. But let me go back a little bit. Let me see what the brother was asking. Oh shit, that's funny as hell. Hold on.
February 9th at 3:47.
We can't hear you.
I'm so sorry. I'm
Just
so
pull the
sorry.
microphone just a
Of
little
course.
bit closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47.
No, let's go back.
Okay.
Let's use your first one.
Okay.
Okay. Yeah. One that's a little bit more. Okay. So that one there on the Whitworth case. Tell me how that actually impacts this particular case.
Which page are you referring to?
Page 24.
Page 24. So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification, held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me, but essentially, to answer your question,
It's prepared.
that first of all is physical present only. So
Right.
yes, and we
But you did cite it.
and said
Right.
that it's physical
Yeah.
present only.
And you're using that as the basis, really, to say it's a
Mhm.
conflict. There's no other case law that you actually use in this particular brief to say it's
Yep.
a conflict other than Whitworth and also amusement sales, which deals with contingency fee. And so in Whitworth, and I have a case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had or the prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he had. There was a motion early on. It was. I didn't even bring this up here, and I don't think we talked about it in the brief. But there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the
I
other
remember
defendants. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, "Call us to represent you."
And then they came up with the third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, in the prosecution also. So, and in that case, that's physical present only. And I don't remember the specific facts of that case, but it's not just a conviction. And obviously, the state wants it to be just a conviction. And we argued this extensively over 3 hours, I think, in front of the court. But it's also a personal stake in the prosecution, and that was an amusement. Prosecution in that case, that was a contingency fee case. So
That's
that's
correct.
completely different.
And so in amusement, it was a contingency fee case. So they had a personal stake actually really in the conviction because they only received the contingency fee when the conviction happened. So what you're really saying is that they had a personal stake in just bringing the case because there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture.
Correct. But they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the
They
key.
get money if they keep the forfeiture. So it's where that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right. But
That's
you-
not how they get money.
but
They
you
don't get
said
money for
conviction.
bringing it.
So I just wanted to make sure it was clear
Right.
that was not conviction because you can't have a
But they
conviction.
only get money if they're the victor. He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct? Not because he wins a case.
No, he can lose the case and still have
Absolutely.
make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, oh God, that's a long answer. The actual conflict is lying on your disclosures about how much money.
I'm talking as far as this issue is concerned right here. When you use Whitworth, you use amusement sales, and they say that there has to be an actual conflict.
Uh-huh.
And amusement sales, and let's go back to Whitworth if we can, because in Whitworth, the person was actually told, the prosecutor was actually told by another prosecutor that they want the case to actually resolve in a conviction. Because what had happened was the defense attorney came to the prosecutor and said, we would like to plead. And the prosecutor basically said, no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so the question, and that then was held not to be a conflict. They said that still is not an actual conflict, even though someone told that prosecutor. We want to see a conviction. We actually want to see go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial. Can you point to any unfairness in the trial that's taking place?
It's not in the trial. It's not limited just to the trial. But to answer the first part of your question, when you're asking about the conviction of personal mistake, Ms. Willis has made numerous public statements about her interest in a conviction. There's some emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleadings, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then,
Okay, but that's when she brought the indictment. She's not bringing it for her health. Of course, she is bringing the indictment. Even if she didn't ever go on and say another word, everybody knows she's bringing the indictment hoping for a conviction. Duh, everybody knows that. Okay, you can't hide behind that little case law that you brought and just say it's for physical presence. No. Now in this kind of case, let's go. Let's listen. He getting our ass.
in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said, no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something, because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end your client's case.
With a $5,000.
It was going to end. It was normal billing on that case, because earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You're the one who's continuing the billing.
Oh, I don't bill by the hour.
No, you're the one that's continuing to make him bill. He was willing to cut that off. You said, I believe that they created this case against my client so they can continue to bill. But he basically went out and said, I'm tired of billing. I'm going to offer misdemeanor. And you said no.
Take a couple notes because you had a couple questions there. I want to make sure I answer all of them. So billing, as far as the billing and the offer. So what I was trying to explain, and I'm glad you gave me this opportunity to sort of go into it a little more detail. I tried to explain that there are really three classifications is how I broke the indictment down. There's the folks that are involved at the federal level. You see those people having, they were in DC. Then you see the electors. Then you see coffee. These cases could have been handled.
Marcia, we can't even hear you.
Oh, I'm so sorry.
Just pull it
I didn't.
right. Pull it to the desk if you have to, so everybody can hear.
Sorry. Okay. So how I was trying to explain it is I separate this down into three different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that. The stuff with the federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, and it's not just my client in particular, but that group is the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, you litigate that. They expanded it to include these three different classifications. What does that do? That means the trial is going to be a year. They can plead people out. They can plead Michael Roman out. They can plead this person out. They can plead people out, but they're always going to have that large enterprise. And it actually does, even if they pled my client out, the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because he's not gone. The deal's not, you can plea out and you're gone. Bye. We're not taking time with you. It still expands it. So my whole point earlier was that this expands the litigation, because imagine if we just had, like you see in other cases, one defendant. You can limit the information to just that crime and that case, or you can have three separate indictments. But what we've done here is we've put them all together in a courtroom that can fit all of those people. So that expands the litigation.
So in the case that you cited, physical or not,
Which one?
Whitworth, it said that when the prosecutor goes up, Morgan, who is the person who's not supposed to, who's talking to him, who's the prosecutor, Hobbs informs Morgan, who is the prosecutor, that he anticipated a successful criminal prosecution, but that any decision regarding Withers' proposal to Morgan was Morgan's to make. Morgan decided to continue to go forward. And they said that that was not a conflict, that was the prosecutor's decision to make. And you're saying, using this is the case you cite, well, in your case, they actually came to you and said, we're willing to give you a plea. And you said no, which is perfectly fine. But then you say, well, they want to extend prosecution on my client. They were willing to cut it off. And so therefore, the case that you cite is totally opposite than what the situation that you're dealing with. How would you say that you have a conflict in this case? Based on this case, just based on this case, that was your first case that you cited in your brief.
I don't think it was actually the first case, but
the first was actually a federal case, but the first Georgia case you cited was Whitworth on this particular issue.
Right, on this particular issue.
Correct.
And again, I don't have Whitworth in front of me, and there's a lot of different facts about these cases. I would be happy to review it and let you know. But what I can tell you is that I still, and we still believe that this is to expand the litigation. And even if it's minor, the law says over $100, that's enough to have a personal interest. So what we've got these financial disclosures where they're not being truthful. Ms. Willis is lying under oath, which is the same thing my client is charged with conspiring to do, lying under oath about receiving a benefit over $100. So you've got those. You've got this concerted effort, which we have seen, unfortunately, drag out over the last couple months, this concerted effort to hide this information from the public, to keep this information out. I think that it is very reasonable for a court to think that that is a conflict of interest. And whether or not it's a stake in the conviction, a stake in the prosecution, we definitely have seen a stake in the prosecution. And Whitworth, the problem with Whitworth, and this is
who actually brings the case?
The district attorney. Well,
how did they get the case?
Well, we know a lot more now because of the book Find Me the Votes. So we know a lot more than we normally would know. So, and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Wade. So he's the one that he presented most of the witnesses.
How was your client charged? How are these clients charged?
So my client was charged just in the actual grand jury.
Okay.
Yeah.
So grand jury. Okay. So we had a special grand jury, and then you had a grand jury.
Yes.
Who made this determination?
Well, yes.
They made a determination to bring charges, basically, to indict. Okay.
Yes, and I.
So are they part of all of this?
No. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is a witness who comes, and in this case, it was actually the investigator for the DA's office. So just understand this: it is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a lawyer that I worked with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it by accident, and the grand jury indicted.
You're saying the grand jury has flaws?
100%.
Oh, so would you think it'd be better for just the prosecutor to draw the accusations?
No.
So the grand jury.
I know you guys have a bill doing that right now. No, I definitely don't think so. The grand jury is better than no oversight.
Correct.
Definitely, but
Right.
it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is. I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury is one-sided. They only hear from the prosecutor. So, and they hear hearsay. So in this case, using as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went in there and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment. The prosecutor brings that indictment and then they vote and it's a majority. So all they have to do is a majority vote, and it's by a very low standard. It's a probable cause, which is about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally. You've got a standard of 25%. I think there should be much more safeguards on the grand jury process personally, but that's for another day.
So you went through special grand jury, and they made their recommendations. Then went to a grand jury, and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3.
2 or 3 already.
And they were lawyer. Well, there was one. So the first gentleman who pled, he was a bondsman, and he was not, because of the state law for bonding agents, he's not able to actually run his business while he's on bond. So he had a significant financial interest in entering a plea early on because he was essentially couldn't work if he didn't enter a plea. And I mean, he got probation. It was not what you would imagine in a huge racketeering case. You would not imagine probation and a $5,000 fine. The other two people who pled are both lawyers, lawyers at the end of their career. And, you know, I can imagine when I'm close to retirement and I have my retirement funds, if I would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking about is Mr. Wade's kind of qualification. So,
Yes.
but you did mention early on that he was very instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills. Yes.
Right. So other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get their positive recommendations, I guess, from state side. He's able to go to a grand jury and get indictments, which is positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
That would be up for dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying. I mean, when you say that someone's totally unqualified, that's basically what's been going on. It's very surprising he was able to go to a special grand jury. You say he's integral
Well,
in
that's
that.
not surprising.
And he's going to a grand jury. You say he's integral in that. Then why even say that he's unexperienced? And he's getting people to plead guilty. But basically, you're saying those are just lawyers that don't want to do anything anymore. They just play the clients guilty. I
No,
understand.
no. So the special purpose grand jury, first of all, remember my client was not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So he did that along with Mr. Wooten, and he never did it all by himself. He definitely led it, but Mr. Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. But that, I mean, special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not.
But when a person's trying to insinuate that somebody's basically totally unqualified, it is important to realize that they walked this case to this particular point. Very complicated case, I imagine.
I mean, that's something that we can debate. You know, if walking someone through the grand jury, the special purpose grand jury is complicated or not. You know, asking questions, and again, there's a team of 10 lawyers. So
now there's a team of 10 lawyers.
who knows what part he's doing? But the question would be then, why him? Why not all of the public servants who are taking government salaries and, you know, restricted in their private law practice? Why do they need him there when there's all these other people? As far as the qualifications, asking questions in a special purpose grand jury in and of itself, I mean, there's no opponent, there's no adversary, there's no judge.
Once it became adversarial, you've had persons start pleading, and maybe more potentially correct, possibly, but we'll find out. But let me ask you this though, because you're talking about the staff. One of the reasons you may go outside to outside counsel could be the fact that if you actually put this type of case within the office, just speculating, but to some extent we all are, the office would basically shut down. It's a potential that the DA's office would actually basically shut down.
Oh God, no! If you took the $1 million that he's been paid, you could hire 5 lawyers.
You could do that, but how long would you be able to keep them? In other words, if you had 5 new inexperienced ADAs, they're not tackling this case. And also,
Well, the inexperienced
Right.
ADAs are not going to make
He's going to-
$200,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what.
But the key thing is that job that you're talking about that you're going to hire with that, with the $1 million that you'd have paid him.
Yeah.
If that's your theory on it, that's not going to stay. That's not necessarily going to be long term. If you're just saying the money you paid him, you could have done this, because his is a short term kind of situation. His is on contract, so it's short term. It's not a long term contract. It's not going to last for a person's career. So I understand the back and forth when persons are saying, well, they could use this money for that, but that money was delegated for him on the short term project, so to speak. So it's not anything that a person would come in long term and actually necessarily do. But at the same time, that would be up to the district attorney to make that decision how she's doing that. I just make the point that so far, from a district attorney standpoint, I would say that they probably believe that so far the case is successful. And we can argue about what's qualified, what's not, but certainly I think that they would argue at this point the case has gone from a successful pattern for somebody that's been denigrated and said it's totally unqualified. I did want to go into these trips. How much was the money? Go ahead. Thank you.
Was that a question? Because I'd like to respond if it is.
Yes.
Okay. I took notes because there were a couple different questions in there. So the first one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, you know, unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this, and I just wanted to make sure that my testimony was accurate. This money was never delegated for this. The county did not ever delegate this. The county was not involved in that at all. Ms. Willis is the one that decided, and there's no budget. There's no transparency at all on this.
She does the contract with him, and I believe you showed those contracts. So in that sense, it's delegated to him because that contract can end at any time. She could say, hey, the contract based, because he works at her pleasure.
Oh, yeah.
So that contract can actually end at any time. That
Yes.
would be the point.
Yes.
On the trips, how much total were the trips?
About $20,000.
And I think about 17,059, but even if we say 20,000, what was the average cost of each one of those trips? Well,
Unfortunately, they did not provide all of the records. So I can't tell you exactly. All I can tell you is what Mr. Wade charged on his credit cards. I can't tell you most of it was paid in cash. So there's no record. So I wish I could tell you, but
going by your slide, one was 3,335, one was 4,453.
which one? Hold on. I want to make sure I'm clear on each.
You had 6 trips.
Okay, but which trip are you talking? Well, you said one is 3,000 something. I want to make sure I'm clear.
Yeah, put it back up for me, please.
Yeah.
There we go.
Okay.
So the first one, Royal Caribbean, 3,335, Aruba, 4,453. And then we see the next one, and then the next two. How would that compare? I mean, what is that so unusual for on price points as far as trips are concerned?
I mean, I don't think so. The Royal Caribbean, so I can tell you because I know these records really well. I mean, Royal Caribbean, I specifically kept out the money that he spent on his mom's cabin. So they had 2 cabins. His mom had a cabin. They had an oceanfront balcony. You know, for Bahamas, I think oceanfront balcony is probably, you know, upper middle, but I don't know that it matters. Flew, you know, comfort class, not unnormal for a lawyer. I mean,
You know what maybe the average American spends on a vacation?
not this much.
You don't think?
No.
Have you looked?
No, I haven't, but I would imagine most of the Fulton County taxpayers would love to go on any of these trips.
Well, you know, if you, since you speculate, well, I could speculate and say that you did look, and that's why you didn't put it in your brief,
I did.
because Forbes actually says that the average is about $3,700 that a person spends on a vacation.
For a single person or a family?
Family of 4, but at that time they were taking 2 and 3 at the time.
That makes
So
sense.
that makes
So
that's
these, no,
about normal.
hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on,
2 adults.
2 adults, yes.
It's nothing extraordinary.
So you said 3,700 for a family of 4.
Right.
That does not surprise me. For families that can afford to go on vacations, does not surprise me.
So it's basically what the average American would do.
So
Yes.
this is half of that for 2 people. So you said 3,700 for a family of 4. This is for 2 people.
Right. It's just 2 people.
So
Yes.
yes.
So it wouldn't necessarily be half. It's 2 adults. Bottom line is it's not extravagant. It's not lavish, is it?
The law only says $100. So
But it's not lavish.
that's one of the reasons I didn't include all the Ubers. I quite frankly didn't want to do the math. But there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamas. I didn't include that. I didn't want to do the math, and I also did not want to.
And how much does Ms. Willis make?
200 and something thousand a year.
So your
in my brief.
argument is that a person makes $200,000 a year
Mhm.
is actually setting up prosecutions to go on a trip that costs $3,500. That's your argument.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about in isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is the benefit that she got. And all I'm saying is that I've got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip with $3,300, $4,400, and they have made up all these prosecutions to go on a 3-day cruise for $3,300. I mean, that's your argument. If that's your argument, that's your argument.
That's not.
That's in the brief.
That's not our argument. So, we did
What else
argue
is
for
in the
about
brief?
3 hours.
What else is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in at the same time. You can kind of assume because it's from the airport to the hotel, but I did not want to speculate to that. So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are
That's
on
just in
trips.
brief.
Yes, the ones
Right.
that I actually had hard numbers that I knew that she had. Yes, that's in the
In
brief.
our business, we deal with proof. And so that's the proof that we have.
Exactly. That's
that-
why that's what I
That person
Yes.
is doing all of this for that.
Right. Oh yeah. And
Understand.
so what I included was what I had the actual hard proof of. And then some of it's attached to the brief. Some of it I got by subpoena. So some of it is actually exhibits that were admitted. I think I submitted to you all the certified business records from a couple different travel agencies. Those are actually admitted. And there were a lot of other receipts that I had that I did not know for sure if they were joined. And so I didn't include those. And I haven't
And
told
you
you
should,
today.
correct?
Exactly.
That's correct.
I 100% agree.
So this is what we're dealing with.
Yes, you're dealing with the stuff
Okay.
that's hard proof.
Correct. So my next question then becomes, when the conflict as far as his salary is concerned, just curious, is it the amount of salary that you really creates the conflict? I mean, because we get stuck on money a lot. So is the amount of salary that is creating this conflict in your mind?
No,
Or
it's
is
the
just
fact
the
that
fact that he gets any salary at all?
no, it has nothing to do with that. I did not make any allegations against Mr. Floyd or Mr. Cross. It's the fact that they were sleeping together and he was paying for trips for them to go on and they were hiding it from the taxpayers.
Which we just discussed that.
That's why.
So if there's not a trip, then you don't believe there's a conflict.
Oh, I do because of the Fulton County laws. The laws say that they
I'm not understanding the county code. So I'm talking about as far as like what the case law says, which is
Oh, yeah.
what the judge is actually going to. If they're not hiding that or against the Fulton County ordinances,
They were
do you
hiding
believe-
it though.
do you believe that there's a conflict? They brought it out and said, hey, we date, and is it a conflict in your mind?
They only brought it out once I alleged it and they called me a liar multiple times.
What I'm saying is that they brought it out, would it be a conflict in your mind?
If
Is
they
it a conflict?
here
And what would be the conflict?
So in a perfect world, what you're asking is if Miss Willis had gone to the Board of County Commissioners and said, I'm having an affair with this man, but he is brilliant and he would be an amazing prosecutor on this election interference case. Can I have an appropriations of $3 million and I will get it done? And she had said, and I'm going to go on vacations with him and we're going to date and we're actually going to go home to the safe house that Fulton County is paying for, and he's going to be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J, knowing that, Exhibit J, we wouldn't be here.
But then your client actually has no conflict because that would still exist. Your client has no hard conflict then. There's no actual conflict. It doesn't matter if she disclosed a conflict. If you disclose a conflict, it still exists. And that's exactly what they said in one of the cases that you cited. If a person says, I got a conflict, but I'm still going to testify against you. I know I represented you and I have a conflict and I'm going to go testify against you. Conflict is now over. Absolutely not. If you have an actual conflict where your client is harmed, just because they disclose it doesn't end that conflict. What you're describing is not a conflict at all. You're just saying, I caught somebody, so therefore I'm going to create something and call it a conflict. You cannot waive a conflict like that. You just could. If your client is, you could not do that for your own client. If your client is actually suffering harm, as far as how the prosecution is taking place, because that's what a conflict is. Just because she says, oh, I'm doing these things, you're not going to go to your client and say, you actually have actual harm, but she said it, so we're going to still go forward. That makes absolutely no sense.
No, I'm sorry, I don't understand your question to me. I don't know.
You don't have a conflict if you're saying if she disclosed it, it would go away. Then there is no conflict.
No. I did not say that. I said we would not be here if that had happened.
Right, because you wouldn't claim there's a conflict.
No, because we wouldn't be here because it violates so many of the Fulton County statutes and ordinances and the state statutes that we wouldn't be here because it wouldn't have been approved.
But if she disclosed it, not the way you said it, but if it was disclosed, It's disclosed now. What is the conflict?
The undisputed facts, the facts that we all, your side, my side.
How's your client harmed? That's my question.
Hold on, I'm trying to answer your first question now. So if all these undisputed facts, if those had been in front of the Board of County Commissioners, we wouldn't be here because there would not have been a contract because it's in contravention of law. So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now, I wish we could go back in time and undo that and see, but we can't. And so Mr. Wade was in the grand jury. He should not have been there. He should not have been appointed. Had the Board of County Commissioners known all of the facts of the case, he would never have been appointed to this case. So we can't now speculate as to what could have happened.
What case law do you point to prove that?
Oh, the statutes. It's
not stat, not Fulton County statute. I'm asking the Georgia Court of Appeals, Georgia Supreme Court. Is there any case that says that? And there's not.
No, and it's really not surprising, honestly, because can you imagine this happening? I mean, honestly, in December, would you have imagined this happening? I think most people wouldn't.
All sorts of conflicts are taken up by the Court of Appeals.
I can tell you, I have found some cases in other jurisdictions, but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton County cases where there would be a special prosecutor.
Mostly black.
So otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting county approval, not filing.
Paying him, or is he earning the money because he's actually billing hours because he's prosecuting the case?
I don't.
He's billing hours because he's prosecuting the case, correct? The case that grand jury indicted.
I would hope that he's billing based on work that he's doing. I don't know because I don't have proof of that, and the billing is very irregular. But I don't know. So I don't.
I mean, words do matter when we say that she's not paying him in that sense. He's earning money for a case that he's in charge of prosecuting, that a grand jury indicted, and that's where we are.
You're correct. She is not paying him, the Fulton County taxpayer.
As they pay every prosecutor, as they pay every public defender and every government official that actually exists,
employees,
100%, yes. And that he is part of that process, and he is prosecuting a case that you're involved in. He's prosecuting, and he's been integral in that prosecution, and you've said that. I
mean, he has been very involved. Integral to me means that he is necessary.
Senator Jones, are you getting close?
Yes, sir. I just had one last question, and that was in the case that you cited, it clearly says in Whitworth versus State, it clearly says the prosecutor should see no unfair advantage in taking advantage of the accused. That creates the conflict. What unfair advantage has he done in this case?
And you've asked me a lot of questions about Whitworth. I would love a chance to read it if you have a few minutes, just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Sure, I have it.
Okay.
Yeah, absolutely.
Thank you. I'm sorry. I'm one of those people on visual. I like to see it. Thank you.
While she's looking at this, we're going to wrap up here in a few minutes.
Don't wrap it up now.
Know how you can get information to us.
Yeah.
Each senator on the committee has a separate email address for committee business, and it's simply the last name of the senator. In my case, it would be calcert.inv@senate.ga.gov. INV, obviously, for investigation committee. So each senator, their last name, .inv@senate.ga.gov. And David Cook is sitting over here in the corner as the Secretary of the Senate. He is going to be the safekeeper of any documents or evidence that we accumulate. His email address for this purpose will be cook.inv@senate.ga.gov. I've had a number of citizens that have reached out and wanted to provide information or be heard or testify possibly in front of this committee. And we are encouraging anybody that has input or information that might be helpful to us to provide it to a committee member, ideally to cook.inv@senate.ga.gov, because Secretary Cook will provide it to all committee members. We don't have a next meeting scheduled yet, but it will be no more than a couple of weeks away. Ms. Merchant, you may not be able to have completed your testimony today, and we may have to call you back for additional questioning after the day, but I'm not rushing. Take the time, read that.
Can it not be the first week of April?
Yeah,
Cobb County spring break, please.
that'd be fine.
Thank you. Okay, yeah, no, I'm so glad. So this is Morgan. When you said Morgan, it should have J-Tom. It should have struck with me. I remember this now. So this case, J-Tom was actually the district attorney when he first took this case, and he was not.
Don't talk, wait.
Oh, I'm sorry. I forgot. I'm not good at that. Sorry.
She gonna fall.
He
Why?
took employment later on. So the employment, so it's different than our case because he took employment later on. He wasn't actually paid hourly. He was a member of Prosecuting Attorneys Council. And I'm glad you brought that up because that was one thing that I didn't really go into earlier. The other way that counsel is usually appointed in these cases is the Prosecuting Attorneys Council actually appoints it. And that's what happened in that case. But they sometimes will pay an hourly rate if it's something that is needed. But in that case, he was actually the district attorney in another county. And that's what I've experienced before. So the 2 times I've had special counsel, it's been because it's somebody from outside in another jurisdiction that's brought in. So that's what happened in this case. But then it's very different post-trial than it is pre-trial. We're in a pre-trial posture. And we talked about that because the judge asked us a similar question about how to distinguish that. That's the big issue. And the judge pointed that out. It's not a great review. So, it's just like ineffective assistance of counsel. If you stop the harm before it happens, it's a different review than if you fix the harm after it's already done. It's really hard to overturn a conviction once the conviction happens. And that's what you have there.
In this case, they never got to the harmless error because they said that no conflict existed. I understand what you're talking about by the harmless error, but they never discussed that because no conflict existed. And you're right, it is post-conviction, but bottom line is you really did not address the aspects that I was talking about when they say is a conflict. And it's not me putting this case in, talking about a conflict. It was the case that you guys actually did cite. With that, Mr. Chairman, I yield.
Can I at least answer that question?
Sure you can.
We definitely cite it because we have, both myself and my husband have a very strong policy of citing everything. We don't hide cases. So if there's something that's adverse to our position, we're going to cite it. We're going to explain it. We don't hide behind it. So we cite adverse authority all the time.
Adverse authority, but that's fine.
The oral arguments that we did, that was how the oral arguments started.
All right, so that line of questioning deals specifically with the legal principles involved in your motion to disqualify. As I understand it, you're not really claiming a conflict of interest between defendants, et cetera. It's the conduct of the prosecutor.
Yes. Yeah, there's no conflict.
Conduct.
Yeah, we're not talking about the conflict between defense.
We're talking about the fact that the DA's office failed to follow state law and get an approval, failed to follow county policies to get approval of her budget in this contract, that he was not eligible to have been hired had he been disclosed because of, you refer to it as nepotism, but it's relationships with, and your complaints are of she's receiving a financial benefit of gifts of more than $100, which violate county policies.
Yes, county and state. So and we attached that to one of the briefs, her return where she filed it under oath that says, it specifically says if you've got something over $100, you have to disclose it. And here it is. It's so it's called the Fulton County Income and Financial Disclosure Report. And that says, and it says pursuant to section 2-79 of the Fulton County Code of Ethics, that anytime you've got each gift or favor from a single prohibited source in the aggregate amount of $100 or more. And then it says, for purposes of this section, gift and favors means anything of value given by or received from a prohibited source. Prohibited source means any person, business, or entity that the involved officer, so Ms. Willis, knows or should know is seeking official action or seeking to do or doing business with the county. So obviously that would apply.
Okay. And failing to respond to your open records request and potentially giving false testimony under oath if your version of facts is proven to be true.
Yes.
Keep us posted. I guess we'll keep reading the press as to how your case progresses. I guess there. I'm troubled about this Find the Votes book. Are you saying that the prosecutor has been discussing an ongoing prosecution and her prosecutorial strategy and indictment strategy to authors of a book during the course of the prosecution?
Yes.
And
yes.
that book is now come out?
It is. It's. I don't think I brought it with me. No, I have a copy. We admitted a copy at the hearing. No, it's out there. It was published. Is
that a violation of ethical obligations in some way to be publicly discussing, just like the public statements you made about the guilt of a defendant, et cetera?
Yes, definitely. And we allege that and argued that as far as forensic misconduct. It's very surprising, shocking. And, I don't know that there's a ton of cases on it. But that book, also, we talked about it somewhat in our hearing because it goes into a lot of details about the financial troubles that Miss Willis had prior to becoming DA. And so, it talks about.
You're going to talk about it later. Oh, Pam.
Is she getting a financial benefit from that book?
I don't know.
Is she getting a royalty or payment for having been a contributor to it?
I have no idea.
Okay.
But I know her dad testified that he was interviewed for it. He came to the district attorney's office and was interviewed for it as well. And I think that was when her dad first learned that she had dated Mr. Wade, I think. But I may be wrong. Or maybe that's the first time they met, something like that.
Well, thank you for your willingness to testify before us, and the documents you provided. We'll need some time to analyze and review those. And again, all committee members have access to those. At David Cook's office, he's got them literally locked up in a room. We are not making copies or disseminating those. I will review the documents in more detail, and I'll confer with you, Senator Jones, if you're able to. We might can agree on what should be kept confidential there. I noticed some bank records and things that if it were me being investigated, I probably wouldn't want it divulged to the public. I don't think that's necessary for us to do our job here. I do appreciate everybody's attendance, and thank you all for making time to be here on our committee day. We'll keep you posted for the meetings. The meeting is adjourned.
Baby. Hold on. Let me get your talking ass up off my damn screen. Oh my goodness, y'all. Can y'all believe that? He up all night. We got him back, y'all.
No. I just want to hop in for a minute. I got to echo. Let me make sure this thing is off. 1 second. Jesus Christ. Can you hear me?
I hear you.
Yeah, I want to say real quick that Ms. Merchant, for one, is standing on solid ground, legally sound ground. However, her oratory skills are horrible. And it's crazy how, I don't care how much education a person acquires in this world.
Wait a minute, sucker. Go ahead.
And I'm not talking about you. I'm saying that.
Oh, Mr. Blessed said, "What's up, Levi?"
Hey, what up, Blessed? How you doing, bro? It is one's ability to articulate. It is one's ability to disseminate that matters. At the end of the day, I've sat in a lot of courtrooms, and I've seen this before, where you have attorneys who can articulate and paint a picture, and then you have those like this Miss Merchant, who can't really fully articulate what she's trying to say, and she's not quick on her feet. Now, here's the deal. From what I've observed about this case, she has fallen prey to what Robert Keller tries to do with me.
Oh,
Oh, yeah. And this is when street smarts come in. You have to be street smart.
here we
The
go.
guy with the bald head and the glasses, he has street smarts. So what he did was he met her in the argument at square D, and she fell for it and started challenging him at square D, and automatically that placed her at a disadvantage. I'm gonna give you an example of what I'm saying. When he drilled her on Mr. Wade's qualifications, and he talked about how you had stated that he wasn't qualified to be the prosecutor in this case. He got her right there because she wasn't quick enough on her feet to say, sir, first of all, let me say this. If you study your great orators, those who can really speak and paint a picture, most of them speak very slowly. They speak at a certain pace, and they the enunciation and how they pronounce words, they're very clear on their wording. They don't mumble over words, and they speak at a certain pace. In other words, their mouths follow their brains. With this woman, she allows her mouth to override her brain. Her mouth first, then her brain. Okay. So when he talked about the qualification of Mr. Wade, had she taken the approach that I take with Mr. Keller, and that is, no, I'm not going to allow you to talk about his resume in so many words. No. I myself personally, in my complaint or brief, I refer to him as being unqualified because anyone, has she slowed down and explained it to that body of people there, anyone who engages in unethical practices and unethical activities, automatically I view them as not being qualified. As I don't care what you've accomplished, I don't care about his resume. If he's an unethical person, if Miss Willis is unethical, if he was placed there through unethical means, that means everything that he has done post being placed there, his involvement with the grand jury, his crafting of the indictments for the grand jury, everything that took place after he was appointed prosecutor, I view that as fruit from a poison tree. So it's the equivalence of a detective was Mark Furman a qualified detective? I'm quite sure he had been on the job so many years, and when it came to forensics and how to break down a crime scene, Mark Furman more than likely was a qualified candidate for that. However, his unethical behavior, whenever you are unethical, that's why the code of ethics exists with most professions. You could be a qualified surgeon. You could be an excellent surgeon. Your qualifications are fine, but if you are a racist, how do we know you haven't allowed 3 or 4, 5 black people to die on the goddamn operating table? How do we know that? You may have increased oxygen, decreased oxygen. you may have when that person flatlined, you may have said to the nurses and the assistants, okay, it's over with, let's go. But if that had been a white person, you may have said, give them more oxygen or try to revive that person. So I'm asking you, do you agree with this aspect of it? And that is, whenever someone engages in unethical behavior, that alone, from my vantage point, deems them as being unqualified in their profession. Would you agree with that?
Well, yeah, and that's the whole premise and the basis for this thing. I don't think, and maybe we missed it, or maybe we didn't, but I don't think she conveyed that over strong enough. Because if someone is unethical, if someone is displaying behavior such as that, then it does make them disqualified in a sense, right? So that is a one level of one level of being unethical that you know that one can raise, right? So yeah, that's true.
Absolutely. So the gentleman was able to trick her in that area. And I'm sitting here listening like, damn, you ain't got enough sense to go back to where the unethical behavior started. And you don't have enough sense to say to this man, look, I'm not here to question his qualifications as it pertains to his education, what he's done in the past, as far as his resume. I and this by the Fulton County's own code of conduct, they have deemed him as being underqualified or unqualified by the ethical behavior that he's engaged in. Miss Fannie Willis, the same thing. How many cases has that woman prosecuted and pulled certain strings or done some behind the back, under the table shit, is what I'm saying. I look at the microcosm and the macrocosm. If you'll do that, what do you do? Now, the reason why I came on here real quick was to ask you, because it seems like you were cheering for Miss Willis and Mr. Wade. And I find this with a lot of Black people, that because Trump is at the center of this, that we tend to take sides based on, the Republican, Democrat, Black, white thing. Do you believe that Miss Merchant and her position, that she's standing on solid ground? Is she right?
Here's the thing, right? It's going to depend on those little details about the law, whether or not she's wrong or right. Does it pose a conflict of interest? When does a conflict of interest begin? What is the ramification? All of that, right? So you have to go through and flesh out all of that in order to say whether or not if she's going to be successful. My personal opinion is, yeah, there is some, just by just looking at it, there is some issue there that if it wasn't meant to be, if they didn't do anything wrong, if this was a legit, because the indictment was brought by the grand jury, right?
Yes.
And so if so, that kind of takes her out of it, like it's some type of malicious prosecution, so they can't really go that route. So if she but going back to what I said, let me reverse it a little bit. Going back to what I said, the because the crime can also be the appearance of a conflict of interest. Doesn't have to be, and she should have called that. Miss Merchant should have called that. And
absolutely.
That point, that it's also the appearance of. It doesn't have to be a conflict. It's also the appearance of. If the judge settles the law that way, okay. So You all remember we already got written laws and rules and stuff in place. But then also the judge is also going to probably be charged with settling the interpretation of. So if it is, if because it was a hot issue on the table, is it the conflict of, or is it the actual the presence of a conflict? The look, the optics, pretty much is what they're saying. So
Absolutely.
if it's the optics of, I believe she got them dead to right. If it's proven a conflict, that may be a little because they're hiding a lot of stuff under attorney-client here and this, that, and the third, and money. I gave him cash back. He didn't, all of that. But then she done already impeached them because they lied. But even though she said went back, Mr. Wade went back and changed his testimony.
Exactly.
So, yeah. So it's by that, is if it's ruled to be the presence, the look of a conflict of interest and not an actual conflict of interest, then it might be some issue. They should just go ahead and get the hell on off this case.
Absolutely. And once again, I being a purist when it comes to the law, I call a spade, a ball, strike a strike. And I'll give you an example what you just talked about as far as the appearance. If I were to present Robert's situation with his attorneys prior to Miss Bonjean coming on the scene, the key word that you just said was appearance. I can make a strong argument that by his attorneys emboldening the terrorists, who I refer to as terrorists, by his attorneys emboldening them, co-signing their harassing, intimidating activity, and I would be able to present tangible proof that these individuals on social media were targeting and harassing and engaging in acts of intimidation and threats. They did, in fact, take that information to Homeland Security and the prosecutors. And once that was done, it gave the prosecutors a very strong legal stick, if you will, or leverage to ask for partially sequestered anonymous juries in both cases. So how Miss Merchant said something. If you listen to about, when you were playing it, she said, well, in so many words, I'm paraphrasing. She said there are totally two different dynamics when you're dealing with ineffective assistance of counsel or whatever. She said it is easy to challenge it when the acts are occurring, or the act is occurring. But once the person is convicted, it's hard to go back and argue that when it should have been dealt with then. So when you consider what you said, the appearance, the optics, for the love of God, you have individuals berating and attacking the potential witnesses in R. Kelly cases, and they're using the most vile language, detestable language, detestable depictions of Jane Doe number 5 sitting there with plates of feces and eating feces, and it's just a constant beratement and attack and attack and attack and attack. So when you consider that you take one of these same individuals, and then you look, if you were to play a clip before an assembly, a board like this woman was speaking on, and you were to take that clip of that individual calling Azriel bitches and hoes and feces and talking about screwing her and just all of that. Then you take a clip of Robert's attorney sitting there with that individual saying you're doing a great job. The optics of that alone is unfathomable. It's unreal. And I'll say this, Ms. Walker. This woman who I just spoke about, Miss Merchant, she's very educated. You could tell that. But she lacks certain basic fundamental what's the word I'm looking for? She lacks basic fundamental methods when arguing and presenting her case. And if you notice, I say that to say this. When it comes to my cousin, if you notice, I don't move on. I'm still talking about the ineffective of counsel, assistance of counsel. I'm still talking about the inappropriateness of what his attorneys were doing. I'm still talking about the text messages. I'm still talking about the father. I'm still talking about those strong points because I understand from the streets, incorporating that street mentality, you don't move on from the main points. If the nigga robbed a dope spot or a couple of trap houses, and there's a meeting and they're dealing with that in the streets, you'll find in the streets that his defenders or their defenders, those who want to plead their case or cause, they will try to move on from the infraction. They'll try to move on from what the person or people did. And in the streets, you're taught, no, hell no. We're not going to move on from that. We're not going to move on from certain things because if you allow that to fly, then what you've done is you have not served the best interest of both sides. You have not served the best interest of the streets, period.
But what about if nothing is there? What about if nothing is there?
And if nothing is there as a okay, that's a great question. If nothing is there, that means you're dealing with a slanderous person. You're dealing with, listen, I'm gonna ask you a question in full. For one, if nothing is there, you're dealing with a lying, slanderous individual who would point a finger from a street perspective and say, they did that. He did this. You have that in the streets also. Well, he did this or he did that. Or I'm gonna give you an example if nothing is there. I'm gonna give you a perfect example from a street perspective. What I found growing up in the hood was guys, very rarely, guys would try to get some shit going. And they would accuse a person or a group of people of doing something at the leadership of a person over there, that person. So in the streets, you hold court. And when you hold court, you're getting down to really what happened. And what I have found in my life is that, guess what? The nigga is putting something that took place on this guy because that guy screwed his woman. Because the nigga was screwing his woman. Or the nigga used to kick it with his woman. You feel me? So when you say nothing is there, nothing is there. But this unscrupulous person, this cutthroat person, and oh my God, and so many people in all of the major cities, all across this country, probably the world also, but I'm speaking about the hood. So many people have lost their lives. That is nothing was there. Listen to me, Ms. Walker. When you say nothing was there, that guy saw FBG Duck at the Gold Coast. Nothing was there. All he was doing was shopping with his chick for his son's birthday. The guy spotted him, called his people back at O Block and said, man, Duck is down here. They just chased me. Four of them, he and three other guys just chased me with switchers. They trying to kill me. And when he put that call in, all of them rushed there and ended up killing Duck, only to find out that the guy was lying because he had it in for Duck because Duck had screwed his baby mama or his ex. We see that on YouTube, Ms. Walker. We've witnessed it on YouTube. I'm answering your question, but we've witnessed this on YouTube. YouTube is a microcosm of the macrocosm, which is the world, what people do in the world. And in the world, you will find the worst people imaginable. And on YouTube, you will find the worst people imaginable. But when you say the worst people, when I say the worst people imaginable, there's no imaginably worser person than someone who is willing to bear false witness when nothing is there. A person who, in order to achieve their objective, to lie on a person and slander a person. Now, let's get to it. If nothing is there, everything that I have said and every position that I have stood on, I can back it up. I was an acquaintance, friendly, if you will, with the father of Jane. You know that. Very friendly with him. You even said to me, well, that was your friend. Yeah, I extended him courtesy. I extended him the benefit of the doubt. I wasn't there. When I spoke out against him, people said, well, you're speaking out against him because of Larry and the this and the that. No. You're only doing this because of the rift between him and Larry. Y'all fell out, this, that, and the third. Well, in order to make that assertion about me, you would have to show where I was attacking the other fathers, the other mothers, the other alleged victims and accusers of Robert. You can't find that. You will never find it because I wasn't doing it. I extended him the same benefit of the doubt that I extended to Mr. Rogers, Mr. Savage, and anyone else that's ever been accusatory of Robert. I'm going to give you the benefit of the doubt. You know why? I'm a father, for one. For two, I'm going to give you the benefit of the doubt because guess what? At the end of the day, it comes down to the washer and the wrenching. The ring is going to come out in the wash or the ringer if you're BSing me. So I'm going to give you the benefit of the doubt. I'm not going to take a position and say you lying like most 95, 98% of the people on YouTube who don't even know my cousin. 98% of them. R. Kelly can't do no wrong. 98% of them. R. Kelly can't do no wrong. And they don't even know him. I know and love the man. But I've never taken a position that he can't do no wrong. Not only on social media, I've never taken a position with him. Way before this, tell me if I'm breaking up. Way before this stuff jumped, I've never taken that position. I've never been a yes man or someone who was enamored at my cousin's celebrity or success. None of that shit. None of it. So if I've said to him countless times, and he said, you're right. I will never try to defend you in a defenseless position. You're right. The truth and only the truth can make you free, me free, and everybody free. You said that right. You're right. He understands it. He understands me. So when I say things to him and when I impart certain things, he don't even second guess it with me. When the Larry thing came up, you know him? Yeah, I do. Speak to the dude damn near every day. Is that true? No, sir. It's not. It's not true. What you mean? It's not that. It's what we just talked about, Ms. Walker. It's the niggas in the hood lying and slandering. It's the number one reason why people get caught up, go to prison, killed over lies and slander. You understand? So I'm not going to lie on Mr. Rogers. I'm not going to slander Mr. Savage. And I would never lie and slander the father of Jane. Never do it. I would never, I don't get down like that. I'm going to give you the benefit of the doubt. I'm going to give you the benefit of the doubt. My mother wasn't the kind of mother who, when the people said, I did something, not my son. No, she's, what did he do? Then she'll ask me, what happened? You heard? So unfair people, low down people, slanderous people, and you've seen it in real life, and you've seen it on YouTube. You get mad at a person, the first thing you do is slander them. That's your weapon, to lie on them, to slander them. God damn, if I don't have to lie on you,
now just leave you alone.
Yeah, exactly. Just leave you alone.
Leave you alone. God damn, I'm gone.
I'm gone. But if I point a finger, it's not going to be on no lie. It's going to be on what I've observed, what I've seen tangibly. You understand what I'm saying? So when you say when there's nothing there, I took 20 minutes to answer your question. But when it comes to Levi, Ms. Walker, something has to be there. And I'm not one of those persons saying, I hate when people say that, where there's smoke, there's fire. I never believed in those shit. People say, I heard somebody say it the other day. Well, who said that? Well, there's smoke. They were talking about Puffy. No, Puffy said that. Charleston White said that about Puffy. He said, well, there's smoke. There's fire. That's a damn lie. My cousin has stood on many of stages with smoke all over the goddamn stage. It was an ice machine. It wasn't no damn fire. You've seen special effects in movies. You've seen, they can make smoke. They can make rain. They can make, no, don't tell me where there's smoke, there's fire. You understand? So I don't subscribe to that, where there's smoke, there's fire. No, I got to see some shit burning. Go ahead. Well,
that's you. You got to see the shit burning and stuff like that. And that's fine, right? That's fine, right? That's the proof you need, right? That's the proof you need. However, a lot of times when there is smoke, there is fire. When there is fire, there is some ashes, honey. And you know, it's just that's just how it is.
Well, I agree with you in your listen. This is what I'm saying. The nigga gets off work at 6 o'clock. All of a sudden, he ain't coming home till 9. Always got something to do. In addition to that, he's wearing cologne now. Wait, hold on, nigga. You feel me? You ain't wearing no cologne. Or the girl ain't been wearing no perfume now. Wait, you smell nice. Okay. That's fine. In your personal life, where I should have qualified what I said. When you suspect something, Yeah, that's the right mentality. Where there's smoke, there's fire. I've always said that. Nowadays, with AIDS and herpes and how crazy people are, a person will be a damn fool to suspect that their mate, husband, fiance, whatever, wife, girlfriend, is doing something and not pay attention to it because it can cost you your life. Okay. That's your own personal assessment. Well, the nigga, yeah, okay, well, there's smoke, there's fire. He's switching up his schedule. He's this, okay, fine. I'm talking about this thing that niggas talk about, people talk about on social media. When they use it, they're saying, when Charleston White said it, and when people said, what's her name? The heavy set woman that used to, she did a couple of songs with Robert and Ronald Isley. What's her name again?
Kelly
Price. Kelly Price said that on Vlad when it came to Robert. She said, "Well, where there's smoke, there's fire. That's bull. No. Where there's smoke, there's fire. When the person that you're observing started the fire." Yeah, I agree with that. It's smoke now, it's fire, but it doesn't apply to what they use it for, which mean when they say it, know what they saying? When 10 people, 20 people, 50 people, 100 people, when these people all start saying it, that means it has to be true, because where there's smoke, there's fire. You understand? And that is not correct. That is not correct.
That's not necessarily the truth. And sometimes it could be something as simple as, a lot of talk that's going on, and where it may not be exactly what the people said, how it happened, but it could sometimes be some type of impropriety that's there. So that's what I mean. And you look at that through, and I'm looking at it through investigative lenses. So, like, normally you say, okay, you might get a hit about something, and it might not be exactly what it is, but you keep digging, and you're gonna find something. That's all.
Absolutely. There's no question about it. But it's also it's this thing now where it's crazy. A person can just spread a rumor and get it going. It is all through social media that Puff Daddy and Meek Mill are gay, and that yeah. I entertain it. I listen, but in my mind, like, I'm not gonna just go with that because people said it. They said Suge Knight had Tupac killed, and people are just heard it like sheep. You understand? And I've never. I told you where I used to live at, the suburbs of Detroit, years and years ago. I would jog past this hair salon. The women would come to the window looking, waving. And then I noticed about 4 of them at the window waving. Then I noticed only 2. Maybe a month or 2 later, 1 would come and wave. And I said, what the hell? So one day, the one that would come and wave, she called me in. She said, come in. And to make a long story short, she called me in. I just ran some miles, and she took some, she was a hairstylist. So she took a towel and put some cold water on it. And she sat me in a chair in this crowded hair salon and put the towel on me, gave me some cold water. I'm just sitting there like, how y'all doing? And some of the women were looking at me strange. I ended up kicking it with her, right? And I ended up kicking it with her. And one morning, she was staring at me, and I said, what are you looking at? She's like, that's crazy. She was like, I told them. You told them what? I told them you wasn't gay. Well, 2 of the niggas who were gay that worked at the hair salon, one of them I hooped with a couple of times, told the women when they would come to the window, they told the women I was gay. I said, what? She said, yeah, they said it was gay. Yeah, so.
Why you was hooping with a gay guy?
Say it again.
Why you was hooping with a gay guy?
Why was I hooping with a gay guy?
Yeah.
It wasn't like me and some man hooping. We all hooped at the Y. Everybody would show up. You feel me? Yeah.
Okay.
So this particular
Okay.
this particular guy was a hairstylist, and he would show up to the gym. I didn't know. Even now, I didn't know I don't know the nigga was gay or not, but I would assume. You feel me? You see certain things, and you feel me, like he was always well dressed or whatever. And I just assumed it because all them fine ass women in the hair salon. And I never seen him with one of them or seen him with a chick. Cause Detroit is like that. It's certain areas everybody go to, and I would see him out and was always with a nigga. That's his business. But
Right.
you feel me?
Cause see, I'd be in the trenches out there at the parks with the men. You see what I'm saying? I ain't seen that gay guy hooping at the park. So when you say YMC or some shit like that, okay, yeah, they be up there.
Yeah, Saint Cecilia play. Yeah, and he. Yeah, he would be at the gym sometime, be a bunch of us, and he would be hooping. I never had none against the dude or whatever. I just suspected he was gay. I'll put it like that. And she told me that him and the other dude at the salon told them I was gay. And see, that's what I'm saying. When you have been the victim of slander, you understand? Like, damn, so all these women, you know what I'm saying? And then all it takes is for me to be downtown. One of the women at the hair salon is downtown at the restaurant. She telling her girls, oh, he gay. You feel me? Because what two niggas said, two gay dudes said. You feel me? And that's how it spreads and spreads and spreads. But when she told me that, I was like, hell no. And that's what you find on social media. That's what you find in our culture where people just, listen, man, like, Ms. Walker, I have prevented guys from being killed, murdered, straight up, like killed, maimed, because I was the fairest dude in the streets. I've always been fair. I'm just a fair person, and I'm a merciful person. I've told niggas like, look, man, go. What do you mean go? Go, leave town, nigga. Like, just go. You got relatives that you made enough money, just go. You feel me? I've always been like that. I've been merciful. So I take it personally. When I don't like liars, Miss Walker. I don't like slanderers. I just don't like no damn liars and no damn slanderers, man. I just don't like it. And this is what I have found. So when my cousin told Gail King, it's easy to spread rumors on me. One person said, the next person said this, then the third. Yeah, and that's true. But getting back to what my main point is that you talked about appearance, and one could make a strong argument that his attorneys had no business associating themselves with people who were doing things that I say ultimately ill affected his case. As far as Miss Merchant, I came on here because I wanted clarity from you as it pertains to, do you as an attorney feel that there were improprieties in how Miss Willis and the other dude conducted themselves? She said it just right. She said, well, had she went for this budget, this money for him, and told them that they were screwing, we wouldn't be here today. Then the guy with the bald head and the glasses misunderstood what she was saying, and she had to come back and clarify it. You see? But a good orator, you are not going to need clarity when you're dealing with a decent orator. As much as you and I go at it, as much the people who hate Levi, not saying that you do, but those who hate me, who despise me, one thing that they would never be able to say is that I'm not clear on where the fuck I stand. Is that right, Ms. Walker?
Yeah. Clear.
I'm gonna be clear. That's just the truth. But I just want to hop on here and get your position overall on Attorney Merchant and what they're shooting for.
DV said, "Did you hear Terrence Bradley, the snitching friend, testimony? What did you think about that?"
The other bald head guy or somebody else?
No, the other bald head, the black bald headed guy, just told all the bones are buried.
He's an attorney also, right?
Uh-huh.
Yeah. Once again, Ms. Walker, I think that I think it harms. I think he harmed. And DV referred to him as a snitch, but really he was trying to. For what I saw, DV, he was trying to give. Well, I know they said originally he spoke with them and told them a lot of stuff, but when he got in front of, when he got on, not in front of him, when he got in a witness on a witness stand, he was trying to minimize the damage. You understand?
Yeah.
He tried to minimize it. I'm just to brother DV. I'm just a strong proponent of when a person raises their hand and solemnly swears to tell the truth, the whole truth, and nothing but the truth, that they do just that. That they do just that. You understand? And that's just me. Like, hey, it is what it is. Excuse me. This is why, this is why I played at a certain level in the streets. I'm very loyal. You understand? I'm very loyal. So I'm so loyal. My thing is, don't put me in a position where I gotta raise my damn right hand and all that shit, nigga. Get out of it. You feel me? Don't even put people in that position.
Right.
Is that DV?
Well.
Is he on here?
Oh,
okay.
I'm in the chat.
Oh, okay, word. But that's all I'm saying. Now, you asked the question. I'm gonna way around. You asked the question, what if there's nothing there? What did you mean by that when you say, what if there's nothing there?
Okay, so you said, if you don't stop, you keep going. And I said, well, there's nothing there. And I guess I was speaking in legal terms. Like, legally, you can't press the envelope. If there's nothing there, what you do? Keep on pressing something that can't be pressed?
Well, you see with Ms. Bonjean's last submission that she's now treading on, should I say, she's now embarking upon in her wording. You even said it. You said, well, she's kind of like increasing, turning up the temperature. Now, but here's the deal. My role when it comes to Robert, I've said it 1,000 times, is to influence the court of public opinion, just as Lifetime influenced the court of public opinion, just as Gayle King influenced it, just as the father sitting on Lifetime and in other interviews telling 100% lies. What they were doing was influencing the court of public opinion. You understand? Does that make sense?
Yeah.
So that's my role with the truth.
Okay. But you want to argue the law as it pertains to the text messages or whatever else. See, she is pushing the BOP thing because I told you, or I told them or whoever, that she can craft a proper legal argument around the whole BOP situation. That's a little different than those text messages.
Absolutely, without a doubt. See, you're right. Here's the deal. Jesus, there are certain things I can't disclose, but I will say this much, that I respect how Ms. Bonjean moves. I know that there's a process. I know the things that I often, the positions that I stand on, she herself would find are not germane to the case overall. If you understand what I'm saying, I understand the cases. I understand that. That's cool. But when I argue or debate with you as it pertains to the law, I'm. Let's give an example. I felt after Robert was convicted that there was a strong argument for ineffective counsel just based on what I just said to you. However, Ms. Bonjean did not choose to go that route. That's fine. That's yeah, like Brother Blessed said, I believe them just because they raised their right hand. Absolutely, Brother Blessed. And that's just the you know, that's just the way the process works. That's how listen. I am not an attorney, but I strongly believe that a lot of the things that I have pointed out for the last year and a half, I think you're going to see them appearing in paperwork. Let me put it to you like that. I think it's going to get to the point where these things are going to surface in paperwork. You understand? In filings and stuff, but maybe not. You feel me? I'm just,
They can surface. Don't get me wrong. You can put anything in paperwork.
yes.
Don't get me wrong. You can put anything in paperwork. But when so you got to realize when the other side's going to come back, they're going to check your law factually, see if you're standing on facts. Then you, of course, it's about what you can prove. And then the judge is going to make a decision. He's going to be the trial of facts. He's going to make a decision at this point. The judges is going to make a decision on is your argument, legally sound, is it
Absolutely.
so that type of thing. But yeah, you can put anything in paperwork because the key, the game is to persuade.
Yeah.
Okay, so yeah.
Okay, so let's just say what we talked about earlier. Let's just say the BOP concedes and says, look, leave us alone. We don't have a dog in the fight, but this is what was given to Tasha K. This is what she received in its totality. Here it is. We're giving you the first transmission of text messages that when she first contacted Tasha K, their conversations, how it all went. And in that discovery, if you will, or in that file, you find that, wait a minute. So all of my clients' conversations with his attorneys, all of them in that time period, were leaked. I would think, and tell me if I'm wrong, there would be an immediately filing by Ms. Bonjean asking the New York court to dismiss the case. Would you agree?
You said what now? If it's found that what?
If it's found that through the BOP's admission that every single conversation during that time period that Robert had with his attorneys were leaked, given to Tasha K, and then in turn, she gave them to the father. And in turn, he gave them to the daughter. Now, this is how I say it went. That's my personal opinion, and I stand on that. And if he got a problem with it, then it is what it is. That's my assessment of the turn of events. If that is found to be true, hypothetically, so you have Ms. Bonjean that's in possession of everything that Tasha K received, and in that, in those communications, because keep in mind, Tasha K said she had the visitors list. She said she had the emails, all of his emails, and she said she had who was putting money on his books. She said she had it all. She said that. Oh, I know who puts money on his books, this, that, and the third, da 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 da. All right. So if Miss Bonjean is afforded that, she's given that information, and she discovers that every single conversation that Robert had with his attorney while at the MCC during that time period was leaked, would you agree that chances are she would move for dismissal very swiftly? Would you agree with that?
Hold on. If she finds out that it is attorney-client privileged information,
All of it.
and every conversation between an attorney and a client isn't privileged. I keep telling you that. I just showed you that.
Okay, let me say it to you. Let me rephrase it. Let me rephrase what I'm saying. I said she received confirmation in the form of tangible proof, the recordings themselves of, let's just say, I'll give a ballpark number, 156 conversations between R. Kelly and his attorneys is in that data, is in that file. I would think that she would immediately move to have the case dismissed based on attorney-client privilege. Now, what you did was you said, well, all conversations are not protected under attorney-client privilege. Okay, so what is he? So I would ask you then, what was he talking to his attorneys about? Playing basketball, going to McDonald's and shit? I mean, come on, you talking to your attorney.
Oh, I just showed you. I just showed you confirmation of what I was trying to tell you. And I put it on my wall and I read it and I put it up there. Now you coming back and acting like we didn't just go through these steps.
100.
Hold on. I don't give a fuck if it's 5,000. All conversations that you have with an attorney is not considered attorney-client. Is not covered under attorney-client privilege. It's not. And it got something to do with the venue. It has something to do with permissions. It has something to do with a third party.
Listen, Miss Walker, I have a golden ear. What you read and put on the screen, it said clearly, if the client is under the belief, read it again, that his conversations with that attorney are private, that's covered. You read it. You put it on the screen. I just didn't say nothing. I listened attentively. I don't understand why you bring these strong.
I don't understand why I have to go through this. That's what I don't understand. I don't understand why I got to go through this. Why I got to go through this. Hold on, let me put it up again. Let me put it up again. Because that's not all it said. See, I learned just to shut my damn mouth and do this. Can y'all hear me? Can y'all hear me? Can y'all hear me? Okay. It says, the privilege extends only to communications that the client intends to be confidential Communications made in non-private settings or in the presence of third persons unnecessary to accomplish the purpose for which the attorney was consulted are not confidential and therefore are not protected by the privilege. Listen, this part right here is important. This part. We just saw it in the debate with Ashleigh Merchant and the other side going back and forth. You heard the attorney say, hey, the information that which the attorney was consulted for or which he was hired for or what have you, meaning pretty much they're talking about information related to their case, which is what it really boils down to. Information really pertaining to the case. Some other little information that could extend there would have that same privilege, but mainly, if you want to really look at it, information to not confuse nobody further, information pertaining really to the case. Certain information outside of the case is protected too, but really, when you consulting, when you're hiring an attorney, or you have hired an attorney, what are you going to talk about? Yeah, I don't understand. I don't get it. It's very simple. I keep telling you, and I told y'all guys, when it comes to the law, it'll start with one block. Then you got to keep going because there's an A, there's a B, there's a C, there's a D. Just like when you determining what is hearsay. You guys call just rumors and shit hearsay. No, it's a whole process it goes through to actually determine whether it's hearsay when it comes to the law. And then some hearsay is acceptable. You got that it's acceptable based on hearsay exception. Oh, I don't be wanting to do all of this. That's why I always say, just pay attention to what the attorneys do on both sides, not just one, because that's what y'all get all caught up in. I don't really get, unless I know which side is has the best position. I don't get all up into that until I see what the judge say. He dropped off. I don't know what happened to him. He dropped off. You understand what I'm saying? So it's a lot. It's not just cut and dry, black and white, whatever. He wants to simplify it. It's not simplified. There's no way you can simplify it. If it was, then the words that are written on the statute would be the final say so. It's not. Mm-hmm.
I froze the screen and I'm reading what you put on the screen. Listen, y'all. Ms. Walker doesn't like to be wrong. Okay.
What you mean I don't like to be wrong? That's you that don't like to be
No,
wrong.
okay, let's deal with it logically and
Not
scholarly.
logically. Deal with it from the point of the law.
Oh, okay, let's read. Okay, so let's I got it. I got it in front of me.
Logic is going to depend on the person that's doing the thinking.
Okay, people, let's deal with what she put on the screen. And then I want y'all to consider what I asked her. Now, she says she places this on the screen. The privilege extends only to communications that the client intends to be confidential. Stop right there.
No,
The
not
client.
stop
No,
that.
oh no. We're going to dissect this. Okay.
Okay, well, dissect the whole thing. Don't give me no.
No. You can't tell. Listen.
First two lines.
Listen. You can't. Okay. No. Am I stopping there? No. We're going to dissect it though. The privilege intends only to communications that the client intends to be confidential. Stop right there. Does Robert meet that bar, that criteria? Listen, are you telling me, people, that when Robert was speaking with his attorney, no. Okay. You can't, I'm not stopping there. I'm trying. Okay. Allow me to present my case, please. No, you can't tell. You can't. No. We're going to go through the whole thing. But you can't tell me how to do it. I'm going to read the whole thing. I ain't got nothing to hide. The privilege extends only to communications that the client intends to be confidential. Are y'all trying to tell me that Robert was sitting on the phone at the MCC having maybe hundreds of conversations with his attorneys, but he did not intend for those conversations to be confidential? Y'all know he did, so that he's protected right there. Now, communications made in non-private settings or in the presence of third persons, unnecessary to accomplish the purpose for which the attorney was consulted, are not confidential and therefore are not protected by the privilege. Communications made in non-private settings. Stop right there. If when I speak, no, my what? What did you just say?
I said, hold on.
You swear? Hold on, no. Let me, no.
Hold on.
Wait a minute. Hold on.
I'm going back to listen. Let me finish what I'm saying. In a prison, if it has all of that, okay. If you got the security, you get that warning, and you get this, and it says, hey, it's on you on a non-secured line. Do you want to keep going, whatever? And you say yes or whatever, then there may be a problem there.
That is so sad.
Hold on. So sad. Let me finish.
That's sad.
Hold on. But if there is a warning that pop up and say, hey, all these lines are secured and whatever, and if you got some kind of secured whatever they go through or what have you, then that should be attorney-client. What are you talking about? It's both scenarios.
I'm talking about what I know.
That's your problem.
No, excuse me. First of all, I've been dealing with this with my cousin for a long time. And if you think that Levi is one of these bloggers that sit around talking crazy, I research everything and I have an attorney that backs up to proof read what I research. to give me the proper interpretations. Now, I think it is absolutely sad, I really do, that you would use communications made in a non-private setting. Listen, y'all. Communications made in non-private settings. You know what that's referring to?
What are you talking
Excuse me,
about?
can't
We
you won't let
just
she won't let me
this
speak.
morning.
She won't let me speak.
Well, no, you're not gonna put
She
it
won't
back.
let me. I don't care if you went through it
I'm going to you
for the
do
last
not
week.
understand shit. And what you can do me a favor, get that lawyer on here. Get all your lawyer friends. Bring them on here.
Communications made in non-private settings, people, are when you go to a restaurant with your attorney. That's a non-private setting. Listen, and you're discussing anything. If a third party is in the next booth listening, that's not protected. Listen to me, people. I don't understand it for the world. Why? And Ms. Walker knows I speak with my cousin 3-4 times a goddamn week.
That's fine.
I don't get how. Listen, no. Listen. I would have to be a crazy man dealing with this and not knowing the facts. Listen to me, y'all. When Robert, I'm going to give you an example. Prior to his New York trial, I sent him one of the best attorneys in New York. I said to that attorney, I said, look, he's going to be calling you from this number, that. That attorney said to me, Levi, I don't have to go through those channels. All I have to do is put in a request. This was during COVID, I think. All I have to do is put in a request. I understand it's a COVID. If I can't get in, all I got to do is put in a request. And they'll allow me to have a Zoom meeting with him because I am an attorney. All you got to do is give him my name. So when they contact him, he'll say, yes, I'm awaiting attorney such and such to communicate with him. I'm waiting for him. The next day, wait a minute, hold on, wait a minute. The next very day, the man called me and said, I spoke with your cousin and da. Okay. When Robert calls me or anyone calls someone from a prison, from a jail, whatever, that system is set up where there's a totally different line when it comes to speaking with your attorneys. That's a totally different line, for one. For two, even his conversations with me or anyone would not qualify as a non-private setting. Listen to me.
So you saying your conversation with him is private?
I'm saying my conversations with him are so goddamn private that if I tried to put someone in on a three-way, I couldn't do it. Now listen to me. Let me answer your question. They're private between me and him, but they monitor them. So if I say to him, I'm about to go hit a lick, I'm about to go do, if he and I discusses anything that's illegal or something that can put him in harm's way legally, oh, hell yeah, they're going to pick me up that day because that conversation I had with him wasn't it was a private communication, but it was being monitored from that facility. Check this out though, y'all. Listen to me. If I said to Robert, listen to me, man, I had to move all my money from my girl's crib to my crib. For real? Yeah, man, like, 350 bands. I'm talking to Robert on a monitored line. Listen to me, people, and think. That's a monitored line. We having a private conversation, but it's being monitored. For real? Yeah, man, shit. I just brought my own crib on such and such. And I just moved 350 bands from her crib to my crib. I don't believe in banks and shit. I had to, the safe was so heavy. I said, fuck it, and put it in bags and brought a new safe. And that BOP officer told her cousin, I listened to their conversation. He definitely drives a Cadillac truck, such and such, such and such. I just heard over the thing that nigga got 350 bands in his house. And her cousins and them cased me out and broken my shit and took $350,000. And it came out that the woman that worked for the BOP was monitoring our conversation. That's how they knew I had it. And they went in there and stole it. I would be able to sue the hell out of her, the BOP, and everyone else. What you all must understand is that the privacy, listen, the privacy of the conversation stops at the monitoring of the conversation. I want y'all to listen to me, because Ms. Walker is talking right now. What she's saying is absolutely absurd. When you all, excuse me, let me finish. Let me finish.
Don't believe
when you all go to your bank and you go in the safety deposit box room, it is being monitored, and they let you know cameras are on. They got little things on there saying this is being monitored. Whatever jewelry you take out of that safety deposit box, whatever money you take out or put in, is between you and that bank. The person at the bank who is monitoring it cannot come back and say, yeah, I saw him. He had about $75,000, $80,000 when he walked up. He took it out the thing. Yeah, it's true. I called my cousin and them, and they robbed him around the corner. And then argue and say, well, that was not a private room you were in. That was not your transaction in that safety deposit box room was public. It was not private. Hell yeah, it was private. Listen, your security companies, the security company that we use that monitors our place, they monitor this shit. But is it private? Yeah, it's private. We're paying them to monitor our, listen, y'all, Ms. Walker is talking insane. You're paying them as a service to monitor your place, right? Does that mean they can just take the shit and tell people what you got and what you're doing and this, that, and the third? It is private, but the privacy stops at the monitoring of the conversation. So yes, me and Robert's conversations are private in a sense that what we talk about is between me, him, and yes, is being monitored by the BOP. But it's a private conversation. And proof of that is that if I tried to do a three-way call, it wouldn't even work. No, this I'm on the list. He's calling Levi. Boom. End of story. Now, his conversations with Vlad, his conversations with Kwame, his conversations with Wack, those conversations, like Suge Knight's conversation, that on his podcast that are being displayed. It is the person who is being jailed is up to them. As long as they have permission, the person has permission, is up to them. They would have to say, no, you recorded my call. No. If you notice, he told Wack, I want this to be known when he spoke with Wack. He's given him permission. And you heard Wack say, and he said, well, everything else when it comes to business got to go through my attorney. And y'all heard Wack say, I only deal with you, Levi, or your attorney. And he said, that's right. So to convince y'all that when they talk about public settings, they're talking about a jail phone. That is, for her to even say it, I have to question her sanity. What do you mean a private, non-private settings? It's a prison. It is a detention center. It's private as hell. You can't just walk in there with no McDonald's and say, I'm dropping my cousin off some McDonald's. Hell no, this is a private. You can't just walk up there and get this to him. But, and I'm going to say this, Miss Walker, from my vantage point, seems to be grasping for straws. She appears to want to find.
That is you, honey.
My phone acting up. Y'all go ahead. Go ahead, Miss.
You don't have a clue as to what you're talking about. Right here, y'all, listen. Look, I just put up what we have been listening to all over YouTube. Is these calls from Nesto and Sonya, Shirley Strawberry husband and his side chick. How you think they got them? There's a whole channel on YouTube called Phone Calls for Prison. So it ain't private. Again, I'm going to say this to you again. This one here knows what she's talking about. This one over here has no clue. This man over here, like I said, trying to create a defense using some evidence, and when minors involved, allegedly. Anyway, okay, you can't even do that. So listen.
I'm trying to do it. Say it again. Say that again. Say that again.
Which
some about minors?
You with alleged minors.
But you said minors. You say
minors. Yeah, they say it was minors in the thing, right? With evidence.
What I got to do? What does that have to do with? What does that have to do? What does minors?
No. Listen. What you're trying to come at my credentials? I'm telling you about yours. You are trying to craft a defense around here talking about evidence to support a defense when they're saying minors were involved, which everybody knows. That
what does that have to do with anything? What does that have to do with anything?
I just told you what it got to do with it. If you let me finish, I let you go on for 20 minutes.
If he was in there for bank robbery, whatever, what does the charges have to do with what we talking about?
What the bank robbery had to do with it? What all that money? If I got drugs in the car, whatever you said, what all that have to do with
what
it?
Does minors involved have to do with what we're talking about?
What does what you said have to do with it? What?
No, because you said with minors involved.
Right, I'm trying to tell you about your credentials. If you let me finish, this man here, let me finish, is trying to create a defense using evidence. He says that's going to support a defense when they say minors are involved, which everybody knows by now. If you don't know, that there's a problem with consent and there's a problem with the alleged minors, which his attorneys have already acknowledged. So we ain't getting into that. We're talking about credentials. When you say I'm talking crazy, he's talking crazy. He's been talking
What does
crazy.
minors have to do with what we're talking about, though?
I just told you.
I mean, what I'm saying is that what we're talking about, the confidential phone records.
You got, hold on. Let me mute you like you do me. Do you need to be muted? You're telling me I'm talking crazy. You're telling me that I don't know what I'm talking about. And I'm giving examples like you give your examples. I gave an example and a true example. This is a true example of you talking about making a defense with some text messages and shit when they say a fucking minor was involved.
Well, yo, I'll tell you one thing. Listen, I know one thing.
You can't do nothing about what you're talking about. Listen, you don't let me listen, because you won't let me speak. I'm showing you on the screen of a man in jail talking to this woman. Let me tell you what happened. If y'all don't know by now, this is the side chick. The channel name is Phone Calls from Prison, which tells you this man Levi asserted that his calls with R. Kelly is private as hell. Well, I'm showing you where they're not. Because I'm just trying to tell you guys that this is what we got. And when I lay out talking about privacy from this morning to this evening, that people think that when they say, privacy and privilege, boom, that's it. There's nothing else outside of it. And I'm simply going through and showing you, yeah, it is. It's not as simple as you think. I showed y'all a whole early this morning and went through it, I think, pretty decently to show you where in court, a whole bunch of lawyers, more advanced than my ass, and definitely more advanced than his, was telling y'all about attorney-client and going down different roads and avenues. Even the judge got involved with it. Everybody in that goddamn courtroom damn near was attorney. Even the motherfuckers that they goddamn questioning, trying to disqualify. So they know. So what I'm showing you is that on my screen, right? Y'all don't know nothing about what happened between Nesto and Shirley Strawberry from Steve Harvey Morning Show. Here you go. So this is how Shirley Strawberry found out that Nesto, the man on the screen, was, dealing with a side chick. Phone calls from prison. This latest channel. Got the phone calls, put them on the YouTube. Everybody's playing them. Sylvia was playing them. I played like the first 3 of them. His wife, Shirley Strawberry, found out about it and said, Nesto, no, I can't help you no more with your legal defense. I can't help you do shit. As a matter of fact, he said on one of the calls, I want to thank you for putting an affidavit in saying that, you'll let me come to your house as one of the bond conditions. She said, no, I ain't do that. And I'm not doing that. You're going to have to go somewhere else. After he found out about this trollop on the other end of this phone. This is a whole fucking visual phone call. So, again, Levi don't know what the fuck he's talking about. Again,
I don't.
I
don't. Let me prove that I know what let me prove it. Let me prove it.
Go and play the call.
That same Nesto case, y'all can go in a lot of these state cases, in a lot of these jurisdictions, and watch the whole trial on goddamn television. We're talking about the MDC and the MCC. We're talking about federal cases. You will not find nowhere where you'll find phone calls from federal prisons. Federal prisons have a higher level of protection. They don't allow no damn filming of federal cases, and y'all know that. This is why y'all saw sketch artists in the R. Kelly case. They don't allow no goddamn cameras in the courtroom. So for Miss Walker to be an attorney, excuse me, can I finish? You're lying. You're lying purposely. You're lying. You're lying. You're lying. And you threw.
I didn't say he was in court. I didn't say he was in court.
I said, show me federal phone calls from federal prisons. Show me that site.
I didn't say he was in court. You said
show me phone calls from federal prisons. Show me that.
When you put a state call, when you get a state call,
Show me phone calls from federal prisons, and then I'll concede, and you're right. You'll never find it.
But don't you tell me I'm lying.
You sat here and lied to the people.
I ain't lying to no goddamn people. That's what you.
We're talking about the MCC.
You don't understand no motherfucking privilege. You don't understand no motherfucking law.
We're talking about a federal detention center.
Have come true. I don't give a fuck what.
We're talking about a federal detention center.
None of that shit ain't gonna catch no feet.
We're talking about a federal detention center. You cannot mix apples with oranges.
I ain't talking about no apples or we talking about phone calls.
Oh, yes, you are.
You said no. You said federal, nigga. We said phone calls, period.
I made reference to the MCC and the MDC.
Federal shit. We talking about phone
you
calls.
Have to be dis.
You call phone calls. You said phone calls.
What?
People call you from jail. You said they are privileged. Attorneys go to.
I said my conversations.
Hold on.
I said my conversations with Robert.
You like you do me because I'm tired of yelling. What he said, and this is what he do, because he's never going to win. Because you ain't stepped foot into a school to get trained for this shit. And even if you did, it was probably some motherfucking raggedy ass school that gave you a motherfucking certificate and you ain't had to come in one day to perform one motherfucking hour and work nowhere to do shit. Now, I'm not saying I'm no motherfucking trial attorney because that's not what I do. I'm cut deal bitch. Yeah, I'm the cut a deal bitch back in the day. So I ain't had to do all this. But you still have to know certain things an attorney-client. I mean, my God. That's the basics of the shit. He said phone calls. Listen, there's no such thing as a federal attorney. Attorneys make applications to try to defend federal cases. Okay? He said phone calls. When you get a phone call, it comes, they say the same shit on the line. You getting a call from what? You getting a call from what? Whatever. And listen, you get the goddamn call, they tell you it's supposed to be private or whatever. Remember, the jails, the BOP, whatever, they have their own rules and regulations in which the BOP officer A or whatever the lady name now fucking did whatever too, right? She broke those rules and regulations. When it comes to attorney-client privilege, it doesn't extend to everything you tell your attorney. And he gave an example of like if he get busted, if he was on the call talking to somebody and somebody overhear it and whatever, he get jammed up, he could sue everybody because he got caught in the commencement of a crime. Huh? Where that logic come from? Huh? That's crazy. That's crazy. Even with attorney-client, if your client tells you that they are in the process of committing a crime or they're planning a crime, you have to reveal that. But if they tell you about a crime they've already committed, you don't have to reveal that. Don't fucking tell me. This is ridiculous. I got to have this fucking conversation. That's what I'm talking about. I can't talk law with, I'm just going to let you say whatever the hell you want to say. Just say it. I don't give a fuck. But just know it's probably not the truth. If somebody don't give me no fucking up here to talk to, I'm not talking no law with no lay people. This don't work for me. This don't work for me. You don't know what the fuck it is you talking about. You want to come at my credentials, and when you don't
let me know when I can speak. Let me know when I can speak.
Motherfucker, your record ain't clear. This motherfucker ain't shit you said and done have been facts. It have come fleshed out through the case. Ain't shit been proven. I have a proven track record. Mind you, I have a track record. You just been out there running track. The fuck?
Let me know when I can speak.
Go ahead.
And hopefully you will allow me as much time as you've taken. Let me say this to y'all. For one, I made reference to the MCC and the MDC several times. When I spoke about giving a scenario, a hypothetical of me on the phone with my cousin, hypothetically saying I had to move this money here and there, I never spoke about anything criminal. Only a fool. In that hypothetical scenario that I offered, only a fool would sit up on a federal goddamn jail phone and say, I had to move $350,000 to a new safe at my new place, and that $350,000 is not accountable and accounted for legally. Only a damn fool would do that. So when she introduced or injected criminality into it, that's another thing. This is what's sad, y'all, is that when I speak, I'm very detailed on how I speak. Now, let's get down to it.
Don't mean you know what you're talking about.
Okay, so I didn't interrupt you.
You have.
Okay. We're talking about to say to a person, if I said to y'all, no, there are no cameras allowed in a federal courtroom.
We weren't
And
talking
Ms.
about
Walker,
courtroom.
my God, can I finish?
We wasn't talking about courtroom.
Can I finish? Can I finish?
No.
Can I finish?
No.
Okay,
No.
I can't. Okay. All right.
We weren't talking about courtrooms. And that's what you do to me? We weren't talking about courtrooms. Everybody know you can't film in no goddamn courtroom. Who don't know that? Next. You got something else?
What Ms. Walker did would be the equivalence to showing y'all, look, this is a case right now that's being litigated. It's on camera. We're talking about federal and state.
I didn't say I didn't say a case on camera. These people are in jail. They're not in court. They're in jail.
I'm gonna say a
case.
I'm gonna say it again. Whenever you speak with someone in a federal facility, that is a federally protected conversation. That conversation should not be leaked unless the defendant or the person that's there, that's in the facility, says it's cool. I ain't got no problem with it. But when that individual, when she says phone calls from prison, you will not find one phone call from prison on that website of a defendant or a convict speaking to their attorney. All of the communications between attorneys and detainees, convicted persons, defendants are privately protected. Ms. Walker said communications. Oh my God.
I didn't say shit about you gonna find an attorney on the phone.
Listen, man.
Listen. Motherfucking lie. Anybody know that you ain't gonna pull no goddamn phone call from no attorney and on the goddamn shit? You tell a motherfucking lie. I ain't said nothing about that.
Okay. Well, I'll tell you one thing you said
about a call from prison, and I was showing you that you can get some phone calls from prison because you seem to think that all your calls from prison are you can't get a copy of them. This girl getting them through FOIA. What are you talking about? I ain't saying that.
May I respond? Anyone who reads,
we do the truth over here.
Oh, we dealing with the truth. We're dealing with the truth.
I know you've been. We tell the truth over here.
I don't think so.
Weird shit. Check my.
No, you don't. No, you don't.
Yes, I do.
No, you don't. No, you don't.
You ain't been able.
No, you don't.
As it's come true.
No, you don't. No, you do not. No, you do not.
You still trying.
You do not.
You ain't won
You raise every argument you can possibly raise.
I ain't raised every argument.
Listen, excuse me. You raise every argument. Okay, let's deal with it. Then you said. Wait, hold on. Listen, y'all. Listen.
You ain't even.
You tell the truth over here, right? You tell the truth. You tell the truth over here, right? Oh, really? But listen, y'all. She said she tell the truth over here. Excuse me. She said we tell the truth over here, but even after reading the text messages, she told y'all, I don't see nothing that shows that father set and mother set R. Kelly up. But you tell the truth. You don't even speak on the father, but you tell the truth. You don't even speak on the father, but you tell the truth.
He's so motherfucking pitiful. It don't make no motherfucking sense.
It's the truth. You don't even speak on that father, but you tell the truth. You don't speak on that father.
That's your right and complaint with the motherfucker. I said, only thing I can tell is they some bad parents. What the fuck you want me to do? I ain't got. Listen, he's not sleeping in my bed. He's sleeping in your bed. He ain't sleeping in my bed.
That's fine.
And talk about the motherfucker all day and all night. Bad parent, bad parent, bad parent, bad parent. Shit, I think he got it by now.
But you said about 15 minutes ago that R. Kelly was accused of sleeping with minors. I tell you this, the father didn't say his daughter was a minor. His father said his daughter was an adult. Deal with that. The father said the daughter wasn't a minor. That's what the father said. The father and mama said she wasn't a goddamn minor. So deal with that.
Right. The mama said.
The father and mother said it. The father and mother said she was of age. Okay, both of them said it. Both of them said it. Okay, deal with that.
Yeah.
However, as an attorney, a surgeon, a doctor, a 6th grader, a 10th grader, anyone reading those text messages that can come before people and say, well, I don't see where they set him up, is either disingenuous or you need to take your law degree and get your money back. One of the two.
No, you need to take your degree and get your money back. Oh, I'm sorry, you don't have one. So when I say a setup, I'm talking about the legal definition of a setup and not no jackleg, bootleg, nigga in the street definition of no motherfucking setup. That's what I'm talking about.
Go on up in there and screw him and tell him you're 18, y'all.
If anything, he was frauded.
He was trying to go on up in there in that hotel room with a bed.
What you can never answer.
I can answer.
Why doesn't his attorney run with your assertions about the setup?
I'm gonna tell you why. Excuse me, ma'am.
Yeah,
you've been reading it all day.
Don't turn on me.
Can I answer the question?
Yeah,
Can I answer the question, please?
If only you're gonna answer that question, I don't need.
I'm sorry. I'm gonna answer that question. Just that one. Can I answer it? Can I answer it?
Yeah.
This is a means to an end, people. You can never say that an attorney, any attorney, is not running with a theory or running with this or that when they have not exhausted all of their legal steps. You can never say that. But I'll tell you, no, let me tell you this. Before this is all said and done, what that bastard, that so-called animal, that father did to Robert and his wife is going to be front and center in the courtroom. And I'll leave it at that. It's going to come to fruition. It's going to be legally heard in the right legal venue with the right person at the helm questioning them two goddamn criminals who did what they did. Okay? That's going to come to fruition. Believe that. Yes. This is America. This is America. Okay? This is America. And well, you will see. You're going to see. I ain't tripping. You're going to see. You're going to see.
Here's the thing.
You're going to see. You an attorney. You an attorney, right? You an attorney. You are an attorney. You are an attorney, but you don't think that a man and a woman who sends their daughter to a goddamn hotel room to screw a grown man and tell that grown man she's an adult shouldn't be in prison, but you an attorney. Stop it. Stop it. Well, I'm asking you, should they be in prison?
I didn't say that.
Should they be?
Yeah, they sent their child there to school. Yeah, stupid.
Oh, okay. Okay, so they should be in prison, right? They should be in prison, right? You said if? Did you say if? Did you say if? Okay, didn't she say he trying to screw? Didn't she say, didn't they know he was trying to screw? What do you mean if?
Apparently, we know they screwed. What are you talking
No.
about?
You said if. No, it's no if.
Hold on. Be quiet, because you get on my damn nerve, and we don't confuse my people over here. Listen, there is no concrete evidence that says that they sent her in there to screw, say, hey, screw him. As a matter of fact, Jennifer Bonjean on her post-conviction motion said that the mother did not know that she was having sex with him. Okay? And another thing, before I'm allowed to not allowed to speak again, he said that all the methods and shit from the attorney hasn't been exhausted. That's that shit him and Larry done cooked up to say. Let me tell you something. She could have used whatever they talking about on her post-conviction motion, on the appeals, and on the habeas corpus. They just thinking they're gonna rely on the habeas corpus because they done read a little piece of it and think it means what it means, and it don't really mean that. It's not that simple, right? So ain't no attorney that's not gonna exhaust 3 tries at the ball rather than just 1. That's stupid. That's stupid. And stop lying on that motherfucking lady. Stop lying. That lady ain't say that shit.
He's trying to screw, but I'm trying to keep it business. But going up in a hotel room, sit on his lap, entice him, shimmy, give him a goddamn lap dance. He's trying to screw, but tell him you're 18 and going up in the goddamn hotel room with a bed in the middle of the goddamn room. I gotta go. I'm waking up this whole house. We'll resume this tomorrow. Yeah, y'all better use common sense, okay? Yeah, common damn sense. I don't give a damn.
You know, talking about the attorney. She talking about like she gonna wait her final try. Maybe her final 2 tries is to run they little motherfucking chicken George ass theory. But if it was so bona fide and such why she ain't do it at the post-conviction stage? Why she ain't do it at the appellate stage? Huh? Who the fuck gonna wait? And listen, and we see how Jennifer Bonjean works. Every time she writes something, you will see she'll bring something over from some other motion that was already denied. Don't fucking play with me. The fuck? That's crazy. That don't make sense. That's not logic. That's not logic. And again, if you think that if she marches into the court raising attorney-client, and I said I gave some pretty good options in which, hey, she got a good argument. But if you think that they're not going to make it seem like whatever was said isn't attorney-client. First of all, again, she got the proof that it was attorney-client communications. What was said, where it was said, what was the expectation. I don't know the little boxes that pop up on the the computers when you access the emails, because it was supposed to be emails. Now I think what And they saying phone calls now. I don't know. But just say we're going to say it's all of them. Based on all of that is going to come into play. So it's not cut and dry. It's not simplified. If it was as simple as Levi puts it, and if all of those things had happened in this case, as Levi suggests that it had, then why is the man still sitting there? Why we don't have nothing in front of somebody saying, hey, somebody, all these things happened to my client. He should be out. Or you should be, looking into saying that, he should be out. Now you can use logic. Discredit my motherfucking ass and you ain't got no credentials or credit. What the fuck? I'm going by what you said. You said prison calls. You said the calls are my calls are private. And the calls are private. Private. But private and one, and that's why, and it's so crazy that I will go through and explain to y'all that private and privilege and all that shit doesn't mean the Merriam-Webster dictionary version of it when it comes to the law. Let me tell you something. If you don't think that the people that craft these laws don't make a loophole somewhere in there so that they can get out of, or they can defend it or whatever, you got to be out your motherfucking mind. That's how it works. That's the game. They're not going to sit up there and boom, that's it. Cut and dry, that's it. That's not how it works, honey. That's not how it works. Case in point, let me tell you something else about it. Let me give you a clear idea, a layperson idea, where a layman's idea where you can understand. On the phone, right? When your doctor call you, the doctor's office call you, or somebody calling you for some business or whatever, and they verify if they speaking to you and whatever, and just say they'll ask you. Sometimes they'll say somebody around you, somebody on the line, because they want to make sure that it is a privileged conversation, because that's another kind of privilege. A lot of times, if you say yes, somebody in the room, or yes, somebody's on the line, they won't go no further, because they want to remove the privilege from you, and they want to make sure that they can secure the privilege. They don't want no ifs, ands, or buts about it if it comes back later. Another example, you're in the room with your doctor, your family in there. They ask you, can I talk about this in front of them? Or they're just automatically sending people out the room, because it's about privilege. And when it's a third party involved, or the setting and all of that, that's when it becomes a contested issue. They can make, and just like I showed y'all earlier, when attorney Sadow tried to make crime, I think it was crime fraud with regards to attorney-client, one thing, and the judge had to correct him because he saw what Sadow was trying to do. Who's to say what the government would consider the third party setting, whatever? Like I said, I don't know what kind of Okay, is it what kind of security steps R. Kelly have to go through, whether it be a phone call or the emails. I don't know what the little captions are on the bottom and all of that. I know that was raised out here before as some argument, right? I don't know. Well, just know all calls aren't privileged. All calls aren't private. I don't know what else to say. And when I say that, I'm talking about in the eyes of the law, not talking about in the eyes of us when we are regular, everyday Americans. I'm not talking about that. I'm talking about where it matters in this situation. I mean, that is so crazy. We went through this morning. Whatever. Ain't nobody gonna make my goddamn head hurt over no bullshit that they just playing practicing. Who the fuck does that? I got time for that. You can't just hinge on a word. That's what he likes to do. Hinge on a word and be like, I got something. And be taking something totally out of context. No, we're talking about in the context of what we're talking about. That's what we're talking about. And you can't take just a sentence or two and think that's it. That's not how it works. And that's when you know somebody that don't know the law. Because if you don't know, it's back doors, loopholes, exceptions, exclusions, and all this other bullshit to what you just read, then I don't know what to tell you. I don't know what to tell you, honey. All I can say is y'all need to pay attention. Those who are unsure about certain things and aspects of the law, unsure about some of the stuff that we talk about, whatever, pay attention to these cases that's going on. It's a lot of cases that's being viewed out here on the YouTube streets. And they are taking you through some real good, they give you some real, knowledge-based information, right? If ever you should need it, then you'll know it. If you just into the shit like that. But what we get a problem is when he try to discredit me on something I'm saying about the law without showing in black and white. And I'm popping up in black and white. Who does that? Even in what we just saw today with Ashleigh Merchant, right? You had Big White sitting up there, agreeing with everything she said, agreeing with her angles, whatever. And then you had Mr. Jones like, uh-uh. But listen, my whole point is that you cannot talk to me about what I'm doing and I'm not using logic if you think that you can use some evidence, any kind of evidence. And I'm talking about more specifically text messages or the parents as a defense in a case with alleged minors. When that has already been decided, it has already been decided when it comes to it's so stupid. I ain't got time for your shit. Leave me alone. But you cannot, and when I say that has already been decided, I'm talking about as far as the case portion of it, right? And we saw the judge answer that and make those decisions through that motion in limine, right? We see her do it in pretrial, through the motion in limine. We saw her answer that in her response to the motion to was acquit and the motion for a new trial. We saw her answer those things. At least Larry would go, and he did go figure out what I kept saying procedural law and substantive law is, right? At least he went and do that. And I think he can make some sense of it. So, unfortunately, that purist shit and all that bullshit, it don't matter. It don't matter. It's about, and with regards to the law, it's about, if it's civil, it's about, making it whole. If it's criminal, it's about that too, but in crime and punishment. But nothing should be oppressive. That's why when you appeal, you want to find constitutional issues, rights being violated, things of that nature. Hell, that's crazy, y'all. Oh Lord, I'm been here 8:35, baby. Let me get on up off here. Once again, another day I ain't do shit I was supposed to do. But anyway, I spent it on with y'all. But anyway, y'all, let me get up out of here. I shall see y'all later on. I hope that white lady don't do nothing else. Cause I'm following her ass. Her and Big Terrence. Oh yeah, I meant to play 2 Chainz. Wait a minute. If y'all want to see 2 Chainz, let me see if I can bring up 2 Chainz. So I can bring up 2 Chainz ass. Oh Lord, I put 2 Chainz on my wall. Wait a minute. Let me get off my wall. Let me get 2 Chainz off my wall. What from 2 Chainz? How do I download a 2 Chainz? Wait a minute now. Hold on, y'all. I'm trying to get it. Hold on, let me find it. Vanderbilt's friend. I thought I damn downloaded that. Did y'all see Nathan in the courtroom? Just handling the Trump indictment before the disqualification stuff went down. Okay, wait a minute. Hold on, give me a minute, and I'm gonna download 2 Chains. Hold on. Lord have mercy. I just put my hand on a pair of Ferragamos, and baby, I know goddamn well these ain't no Ferragamos this lady got on. Oh Lord. I'm sitting over there listening to that damn lead attorney, and I holler when they done call that goddamn lady 2 Chains. I holler. Oh, I ain't going nowhere. Hold on, I ain't going nowhere. I'm gonna play 2 Chains. Okay, hold on. Let me play 2 Chains. And then you have the they're telling people that the jury, R. Kelly jury was supposed to be made up of people that's not older than a certain age and not. I can't make this shit up. Y'all just making up all kind of shit about the law. Y'all about to drive me crazy. I'm gonna stop coming on here. I can't take it. These people here, I don't know. Oh Lord, I hope these people don't believe shit y'all say. You ain't got to believe what I say. You go ask somebody else, or go look it up. Go the lead attorney be on, Pam be all the people. Go in their chats and ask them this ridiculous shit, and make sure you tell them where you get it from. Don't say you get it from me. That's a goddamn lie. Two chains there. Oh yeah, I thought I had 2 Chains already downloaded. I had to snatch it real quick. Okay. Download. Download it. Ooh, 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 ooh. Still looking, y'all. But if that's that, then what is it? I'm here. Hold on. I'm trying to find that video. I want y'all to see 2 Chainz. I don't know if it'll let me play. Oh, well, maybe it'll let me play it. I'm going to try to play it from here. I'm going to try to play it from here. Hold on. Let me see if I can play it from here. I ain't download. Let me play it from here.
Spell your full name for the court.
Robin Latrice Yodi. Thank you, Ms. Yodi. Thank you for being here. Can you
Well, I downloaded this shit. Okay. I don't know where it went, but I downloaded it. Oh my goodness. Hold on, y'all. I'm still trying to find it. I saw it. Some dumb shit. I know that's why I wanted to download it so y'all can see 2 Chainz. But it ain't let me be great. Close that window. Close that window. Let me let y'all go because it ain't letting me be great. But see, wait a minute, because it should complete this record because it's everybody throwing him up under the bus. And if this is the case, then why am I not able to bring it up? Okay. Oh, where it is? There it is, right there. All right, I got it. I have it. I have it. I have it. 2 Chainz.
Would you like me to swipe or touch?
We need to make sure. There we go. Debbie Scott, if we could swear to witness. Ms. Yuri, can you hear us?
Yes, I can.
All right. Please write this down. Swell for that's when you get a court will be a shoot. Shoot will help you.
Yes.
Would you please state and spell your full name for the court?
Robin Latrice Dirty.
2 Chainz.
Thank you, Miss Yuri. Thank you for being here. Can you tell the judge when you first met Miss Willis?
In college.
Okay.
So probably 90 or 91.
Okay. And have you been friends since 1990 or 91?
Yes.
When was the last time you spoke with Miss Willis?
March of 2022.
Okay. From 1991-ish till 2022, were you what you would consider good friends with Miss Willis?
Yes.
And did you all share personal information regularly?
Yes.
And did you even come and work with her at the DA's office?
Yes.
And when she needed a place to stay, did you let her stay at your apartment?
Yes.
It was a condo, right?
Condo, yes.
Do you remember approximately when she moved into your condo?
It was April of 2021.
Okay, great. And you know that Ms. Willis and Ms. Wade met at a conference in October of 2019?
I'm going to object to that, Your Honor, without a foundation for how this witness would know that. If Ms. Merchant can establish she had personal information of that, then certainly that's something the witness can testify to. But if it's she heard
Understood,
it,
Ms. Cross. All right, Ms. Merchant, if you can lay the foundation.
Do you have information that Ms. Willis and Mr. Wade met in October of 2019?
I'm going to renew my objection, Your Honor. Information is not source of personal information. If the question can be rephrased, then that may address my concern.
So Judge, I just want to make sure that I understand. So they've objected to me calling Willis and Wade.
It's just a matter of foundation. If you can just rephrase.
Do you have knowledge of when Willis and Wade met?
I'm going to object again. Personal knowledge.
Overruled.
Thank you. Do you have personal knowledge of when Willis and Wade met?
Yes. She told me that they met at a conference. I don't know what.
Okay. I'm going to renew my objection, Your Honor. Clearly, this is not firsthand information from this witness. It's hearsay that was.
But she said she told me.
Yes, it's statement against interest, Judge. If Ms. Willis,
Just pause.
that's it.
Okay, Ms.
Yes.
Cross.
The representation of the witness, the testimony of the witness was that Ms. Willis, District Attorney Willis, had a conversation with her. There is no statement against interest. District Attorney Willis is not a party opponent in this case. The information that the witness has testified to came from Ms. Willis, and we have a hearsay objection for that.
Why wouldn't she be considered a party opponent in this context?
She's a representative of the state, Your Honor. This isn't private litigation or civil litigation. Obviously, the place where this is, Ms. Willis is not on trial. Ms. Willis is not a party to the litigation outside her obligation to pursue criminal charges for the state.
Ms. Merchant, I guess it's evolved into a hearsay objection.
Yes, Judge. And we plan on calling Ms. Willis to the stand. She's under subpoena, so hearsay will be cured. If there is a hearsay objection as far as that issue. But we do still think that it's a statement against interest. Ms. Willis has filed a document that states that they met at this municipal court conference. So
Your Honor, I think maybe I can streamline a little bit. State will stipulate that District Attorney Willis and Mr. Wade met in October 2019 at the judicial conference that we've been talking about. No reason to get it secondhand from this witness. Well, that's true.
All right, you accept the stipulation, Ms. Merchant?
Yes. Am I permitted then to ask questions about that since it's now not hearsay?
If it's just to a stipulation, if it's just that basic fact, I don't think we need a question, but there's a follow-up.
Okay.
This is admissible. Go for it.
Ms. Yurdi, you have personal knowledge that Ms. Willis and Mr. Wade began their romantic relationship soon after this time that they met at the municipal court.
I'm going to object to that question. That certainly is a leading question. The foundation has been laid through how this witness would have personal knowledge of that. Until that time, we would say objects.
Judge,
I think you can do a yes or no and then follow up with how she knows it.
thank you. Do you know if Ms. Willis and Mr. Wade started dating in October of 2019?
I don't know if it was October of 2019.
Could it possibly be November of 2019?
Could possibly.
And when we spoke, you said it was shortly after the municipal court conference, is that correct?
Yes.
So you know that their relationship, their personal relationship, began shortly after this municipal court conference.
Yes.
And when I say personal, romantic. I just want to make sure we don't get in an argument over what personal and romantic is like. When I ask you personal, do you take that to mean romantic?
Yes.
And do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
Yes,
And you were essentially her best friend during this time, right?
not best friend, good friend.
Good friend. Okay, close friend. And so would you frequently socialize with her?
Yes,
And you saw her at work every day?
yes,
So you had a chance to see them interact together on a personal level.
yes,
And so from everything that you saw, heard, witnessed, it's your understanding that they were in a romantic relationship beginning in 2019.
yes.
And when you left the DA, oh, I'm sorry, let me ask you. You said that Miss Willis came to live with you in April of 2021. I'm sorry, April 1st, 2020 or 2021?
She didn't live with me. I never lived with her.
Okay, I'm sorry. She took over your lease in April 1st, 2020, correct?
No, 2021.
20. Okay, I had it both ways, so I'm glad you clarified. So when she took over your lease in April 1st, 2021, it's your understanding she moved out of the house that she was sharing with her father and started staying at the condo.
Yes,
And is it your understanding that that's because she needed to have her own space
yes,
away from her father?
yes.
When you left the DA's office, was it, were you fired?
No, I resigned.
You resigned, okay. Just one moment, sorry.
Queenie.
Can you tell us why you resigned the DA's office?
Two
A
chains.
number of things that was happening.
A number of things that were happening, is that what you said, ma'am?
Yes.
Okay. What was happening that caused you to resign?
There's a spiral of things. So, I guess the last law is I was put in a department that I knew had no knowledge about. Something happened, and I didn't like it. They didn't like it, and that was it.
Did you have any falling outs with Miss Willis?
Well, we never spoke after that.
You never spoke after that, okay. And so without going into all the painstaking details, there is no doubt in your mind that from 2019 until 2022, Miss Willis and Mr. Wade were in a romantic relationship.
What's the question?
You have no doubt that their romantic relationship was in effect from 2019 until the last time you spoke with her.
No doubt.
And that's based on your personal observations and speaking with them and seeing them together and things like that.
Yes.
Okay. No other questions. Thank you. The other folks may have some questions for you, Ms. Yurdy.
Say no. If it's more than a couple questions, then sure, but if not, okay.
Ma'am, let me be very specific. Did you talk with Miss Willis about her romantic relationship with Mr. Wade?
Yes.
Did Miss Willis tell you on more than one occasion that she was engaged in a romantic relationship with Mr. Wade prior to you leaving the district attorney's office?
Did she tell me or did I observe?
I'm saying right now what you tell me.
Yes.
Did she tell you that in the year of 2020?
Yes.
In the year of 2021?
Yes.
Are you certain that Ms. Willis told you about the romantic relationship with Mr. Wade prior to November 1st of 2021?
Yes.
Now, did you also have observations of Mr. Wade and Ms. Willis together prior to November 1st of 2021?
Yes.
And are those observations, were those in a social setting?
Yes.
Did you observe them do things that are common among people having a romantic relationship?
Yes.
Such as, give us an example.
Hugging, kissing, just affection.
All before November 1st of 2021, correct?
Yes.
That's all I have.
Mr. Stocks. Ma'am, did I understand you to say that there was a period of time when you as well as lived together?
No.
Mr. Durham.
No, nothing for me, Your Honor.
Mr. McDougal. Mr. Rice.
Good morning, Ms. Yurden. Were you aware in 2021 of any trips, social trips that Ms. Willis and Mr. Wade took together?
No.
Are you aware of any social trips that Ms. Willis and Mr. Wade took together in 2022?
No.
Are you aware of them 2020 or 2021 spending the evening together overnight?
No.
Mr. Gillen. Mr. McCullough. And Mr. Cromwell.
Good question, Joe.
Ms. Cross.
I do have some questions. Thank you, Your Honor. We haven't met before, is that correct?
Correct.
You're able to see and hear me okay?
Yes.
All right. I want to start with a couple things. Now, I think you've made it clear that you never lived, we'll call it the South Fulton address, the South Fulton condo that you were leasing. You never lived at that address with the District Attorney Willis, correct?
Correct.
And never at any time?
Never.
All right. You never observed or have any information about District Attorney Wade and District Attorney Willis and Nathan Wade living together, correct?
Correct.
You don't have any information about that?
No, I don't.
Anybody said that that information was sourced to you, then that's incorrect.
That's incorrect.
Did District Attorney Willis pay rent at that establishment, at that condo while she lived there and you were living elsewhere?
Yes.
Who paid the rent?
She did.
Nathan Wade ever pay the rent?
No.
And you never told anyone otherwise? I didn't hear your answer there, Ms. Yurden. Did you ever tell anyone otherwise?
No.
Okay. So let's talk for a second about your time at the District Attorney's office. You were disciplined several times in the District Attorney's office during your employment there, correct?
No.
You weren't written up ever for poor performance, Ms. Yurden.
Once, not several.
One time you were written up for poor performance. Were you counseled several times about your performance in the District Attorney's office that was subpar?
No.
Did the District Attorney tell you that your performance was insufficient and that you were going to be fired?
Oh. No.
That never happened.
No. Maybe when we were at the end. What's the question?
Question, Ms. Yurden, was, did the District Attorney ever counsel you on your poor performance in the District Attorney's office prior and inform you that you were going to be fired?
I don't really know how to answer that.
I'm looking for the truth.
I don't really know how to answer that. I mean, the situation happened. That wasn't my fault. And I either was going to resign or be let go. So.
You understood that that was the situation. You could resign or you could be let go.
Correct, yes.
You were not welcome to stay.
No.
And the conversation where you were informed that you could resign or you could be fired, that conversation was not the first conversation you had with the District Attorney about your poor performance in the office, correct?
Well, it was kind of a spiral, but no.
Yeah. Whatever the situation was.
Understood, Mr. Sato. Ms. Cross.
Ms. Yurden, the circumstances of your leaving the district attorney's office ended your friendship with the district attorney Willis, correct?
Yes.
Y'all haven't spoken since.
No.
All right, I want to talk about the representations that you made here this morning, Ms. Yurdi, about any relationship between District Attorney Willis and Mr. Wade. I want you to tell me what was the first time. And let me ask you this way. You said that District Attorney Willis personally informed you of a romantic relationship. Is that what you testified to?
Yes.
When did that conversation that you purport to have to recall, when did that happen?
I mean, I don't have a month or a day, but it's talking in general.
Your Honor. Redirect. Sorry.
All right, on those points only.
Yes. Resigned. Did something happen as far as purchasing that you didn't feel comfortable with purchasing things through the county for Miss Willis that caused you to not be comfortable working there anymore?
No.
And I didn't tell you how to testify here today, though, right?
Right.
And everything you've testified to is from your personal knowledge?
Yes.
Okay. And you've told the truth here today?
Yes.
Okay. Judge, I believe she's only under my subpoena, and I'm fine releasing her from that. Oh, I'm sorry.
By show of hands from other counsel, starting with.
Okay. I don't know if that was all of it. But baby, I ain't never seen no hooks or whatever them people be put on their glasses like that. Lord have mercy. So that was a lot going on there. As I was in the restaurant, I heard they first tried to disqualify her testimony as hearsay. And then they also at the end tried to impeach her credibility by saying she has a motive to come out and testify against good old Fanny. Messing with Fanny. How dare you? Hold on, y'all. Let me see if I can find if 2 Chainz was on there longer than that. $18. Hold on, y'all. Let me see if there's any more to this. Okay, well, let me see about this one. Let me download this one, y'all. This I found another one that's longer because it seemed like her testimony was longer. Now, Queenie, Yeah, Queenie, that's crazy. She mad at Fanny. She mad at Fanny. She done lost her job and shit. Where is? Okay. It's still downloading. It's some more to that testimony, right? I want to hear the complete testimony. I found a longer version. It's a shame that you got to do all of this with YouTube. Not letting you share it from the tab, you know. So I apologize, y'all. Let me see if I can find y'all something to listen to. What song? Okay. Let me get it to where.
Yes. Would you please state, spell your full name for the
Where
court?
we left off.
Right. And everything you testified to is from your personal knowledge. Yes. And
hold on.
I mean, I don't have a month or a day. Well, it was kind of a fire, but no.
Okay,
Yeah,
so
it was.
we could pick up right there. Okay, so I found the rest of her testimony. I want to see what else she said. What else 2 Chainz said. We gonna get y'all. Turn on old Fanny. Oh, merchant friends with what wife? Nathan's wife?
Whatever the situation was.
Understood, Mr. Sena. Ms. Cross.
Ms. Yuri, the circumstances of your leaving the district attorney's office ended your friendship with the district attorney Willis, correct?
Yes.
Y'all haven't spoken since. I want to talk about the representations that you made here this morning, Ms. Yuri, about any relationship between district attorney Willis and Mr. Wade. I want you to tell me what was the first time let me ask it this way. You said that District Attorney Willis personally informed you of a romantic relationship. Is that what you testified to?
Yes.
And when did that conversation that you purport to have to recall, when did that happen?
I mean, I don't have a month or a day.
Where were you?
Just talking in general.
Your Honor, you'd like to keep this witness under, but that's all the questions I have right now.
All right, thank you, Ms. Cross.
Redirect, sorry.
All right, on those points only.
Yeah. The state asked you a lot about when you were let go, when you resigned. Did something happen as far as purchasing that you didn't feel comfortable with, purchasing things through the county from Ms. Willis that caused you to not be comfortable working there anymore?
No.
And I didn't tell you you had to testify here today, right?
Right.
And everything you testified to is from your personal knowledge?
Yes.
And you told the truth here today?
Yes.
Judge, I believe she's only under my subpoena, and I'm fine releasing her from that subpoena. Oh, I'm sorry.
I feel hands from other counsel, starting with Mr. Sena.
Your Honor, I believe the door has been opened about asked particular witness about statements Ms. Willis made her. She brought it up on cross-examination on a couple of occasions. Did Ms. Willis say this or inform you of that? So I'd like to now ask the questions directly about what Ms. Willis told her about her romantic relationship.
I think we'll take this one at a time, question by question, and we can address those to see. I don't know about a complete opening of the door. We'll see where we go.
The first time that you spoke to Ms. Willis about her relationship, romantic relationship with Mr. Wade, do you happen to remember what Ms. Willis said? In essence, not word for word, but in essence, what she said.
No.
Do you remember the first time she told you, whatever words were used, that there was a romantic relationship?
No.
Is this the kind of conversation that you had with your best friend, ongoing over a period of time in which it was common knowledge to you that there was an ongoing relationship between Ms. Willis and Mr. Wade?
What's the question?
Yeah, I'll ask it again. Is the nature of your then relationship with Ms. Willis such that you were having these ongoing conversations, that is, best friend type conversations about her relationship with Mr. Wade?
I don't remember.
Without getting any further into too much detail, is there any doubt at all that Mr. Wade and Ms. Willis had a romantic relationship, as was told to you, prior to November of 2020?
She was already asked that question by Ms. Merchant.
I just didn't know whether that needed to be.
She said no, no doubt.
No doubt.
All right. Any other defense counsel by show of hands? Seeing none. last recross from Ms. Cross. Anything else?
Not this time, Your Honor, but that's the witness remain under subpoena and subject to recall.
She's under my subpoena, and I'm releasing her.
Ms. Cross.
I would prefer that the court keep her under subpoena, given the representation of Ms. Marchant, given how she intends to proceed today, that this witness may need to be recalled.
All right, understood. In the interest and knowing that we may have to bring witnesses back and forth, I think it's in the interest of effective presentation of the evidence here. Ms. Yurdy, you are still going to remain under the auspices of your subpoena. And so please stay in touch with your attorney. We may need you to rejoin us on Zoom at some point today or tomorrow. Understood?
Okay.
All right. Don't discuss your testimony with any other potential witnesses. All right.
All right.
All right. You can log off.
And Judge, can Mr. Partridge stay on for just one moment?
For what reason?
The state had made some allegations that I misrepresented some things to the court, and I just like the opportunity to clear that up. That Mr. Partridge is the one that told me that they lived together for months. They told me everything but a liar today, and so I just think that it's appropriate for everyone to know where that information came from.
All right, Ms. Merchant, I think you've made your position clear. That's I don't think we would need to get sidetracked. All right, Ms. Merchant, you can go ahead next witness.
Oh my God, she is such a damn crybaby. Oh, they call me everything but a liar today. And the one thing that I hate about proceedings like this, hearings like this, is that the bar is so low and so and all everything damn near goes and shit. And I really don't like all that. She's such a damn crybaby. Girl, shut the hell up. Shit. People got real problems. Yeah, he is going through it, Queenie. He is. Let me see. Who else y'all want to see? Want to see what happened to what is Nature Boy? Let's see if I can find it. They said Nature Boy was acting up in court. Let me see if I can find where he was acting up in court. Hold on. And all I wanna do in my life with you. He was acting up, Queenie. And did you hear when oh wait a minute. Oh no, it's somebody else. Did you hear when Ashleigh Merchant gonna ask Terrence, talking about, yeah, didn't she take her daughter to California after she failed out of the Florida school FAMU, meaning FAMU, bitch? Like, you understand what I'm saying? See, men, listen. I can understand if she feel like she's getting slandered and saying all kinds of shit, whatever, right? But listen, children is off limits. And all she had to say is, hey, didn't you say that she moved her daughter to California? That's all she had to say. She said, FAMU. Bitch, FAMU, ho. I don't mean to talk like that. Sometimes it comes out. You know what I'm saying? What? I want to give y'all a little sample of little Nathan. Hold on, let me see what this is. Judge considers, let me see. A-U-G-E. Okay, judge considers. Now, where is that one? Open that one up. Open it up. Okay, there we go. Now I want y'all to tell me, do y'all think old Nathan is hold on. Hold on. Let's see. Let me see what y'all think about Nathan's performance.
All right. If you are just joining us, right now you are looking live inside Fulton County Superior Court, where we are awaiting a hearing to begin at any moment now. This is surrounding the massive Georgia election meddling case in which the former president, Donald Trump, and 18 other co-defendants are charged with racketeering and a number of other charges. There you can see Judge McAfee approaching the bench, sitting down there. Let me try to get us some audio inside the courtroom.
BSC 188947.
Okay, so listen in.
Mr. Grubman, have you received express permission from your client to waive his presence?
Good morning, Your Honor. Yes, we have.
All right, Mr. Rafferty.
Yes, Your Honor. Good morning.
Good morning. So we have 3 motions teed up for this morning, and why don't we dive right in? Beginning with the motion to speak with the grand jurors, joined by Ms. Powell.
Judge, just as a preliminary matter, the state intends to comply with all of its legal and ethical obligations to turn over the co-conspirator information with just the understanding that the reason why the names of the co-defendants are not already in the indictment, Judge, is that it's of course it's frowned upon putting the individuals' names if they're not charged within the charging document. We'll turn those over to the court with what her request is that the court hold them under a protective order, so to speak, to protect the identities of those individuals or to control, I guess, the public impact of the names that are on them.
All right, so it sounds like you want to skip to number 3, the motion to disclose the co-conspirators.
So just to do away with,
right,
kind of streamline it.
All right, let's start with that one. It might be the easiest to get into. So
let me start right there. Now, you remember they were saying that Nathan had never tried a felony case. So we're critiquing if Nathan, y'all, I got the good people, even the people in the cloud. Y'all drop on out the clouds and say something. We had one dude, Larry, came on through here and Blessed was questioning him. Hey, I don't get in the chat business. I don't know what the hell was going on. Well, I was like, okay, what is going on? Blessed was asking him, who we talking to? No. I don't know what happened to Larry. But yeah, so we're gonna look at old Nathan's performance. I saw a few minutes of this early. This is also another example of legal process, procedures, rules, requirements, law. Yeah, this will be good. This should be good. Listen.
let me make sure I'm understanding what I'm hearing. So you're wanting to, you are willing to go ahead and just give this list to the defense counsel informally through the discovery process?
I'd like to present it to the court.
Okay.
the court can then distribute it to defense counsel as it sees fit, but it's the state's position that because the practice of naming the co-defendant, the unindicted co-defendant or co-conspirators in the indictment has been criticized. The state was elected to do it this way in order to protect those individuals, those names that are on this list. So
I'm tracking you completely there, and I agree. I think that's the standard practice. I'm a regular thing to do.
Well, I mean, the court could impose a protective order that all of the parties to this case are subject to about this government. But we have a trial on October 23rd. They have the list of co-conspirators. They're consenting to the motion. Why don't they just give us that information directly?
Sure, I think we're all about to reach the same place. So the bottom line is it seems like this is a fairly straightforward request. I think federally it would be a bill of particulars, and those are fairly routinely approved. So I can file an order if you want me to, but otherwise we'll say that the list of individuals 1 through 30 is going to be disclosed to not only, I would think, these two defendants, but the other 17 defendants through the discovery process and obviously right now. So in terms of a protective order, if the state's requesting one and the defense is not objecting, we can certainly do that as well.
Move to the protective order. Obviously, any protective order not disseminating discovery or information to the media would have to work both ways. The state would also have to agree with that. But we have the list now. So,
all right.
I guess the moot point.
I was just about to say that. So I'll go ahead and just enter a one sentence order. This list is numbered so it can identify which count refers to which unindicted conspirator and that sort of thing, right?
yes, sir.
All right.
And further, Judge, just to streamline today's arguments more so, the state does plan or intend to turn over the transcript of Mr. Cheeley's testimony, given that he's charged in count 41 in the indictment with perjury, and that testimony is an integral part of proving up our case.
Okay, so now we're moving on to number 2, the motion to unseal the special grand jury transcripts. Do we think we've addressed everything we need to cover with the unindicted co-conspirators?
Yes, sir.
All right, anything else, Mr. Raffi, you think we need to take up on that one? All right, thank you, sir. All right, then, let's move on to number 2. So obviously it looks like the idea of the entire report itself has been taken care of, but the motion goes a bit further than that, Mr. Wade. It says that they want to be able to inspect the entire transcript, assuming there was one, I don't know, and any recordings and essentially anything that the special grand jury produced. So let me get your, obviously I'll let the defense present their motion, but let me first start with where the state is in terms of what you think of that is disclosable and discoverable. If the state's following its standard open file policy, just maybe give me a bit of background about that and what you think is fair game here.
Yes, sir. Basically, Judge, the state would contend that any transcripts, any and all transcripts that have been produced by the grand jury or the special purpose grand jury are not discoverable. Defense counsel should not have access to. I know that the court wants to hear further argument afterwards. Has this opportunity to the case on the opposition.
With the sole exception being Mr. Cheeley's?
Given that Mr. Cheeley is directly charged in count 41 of the indictment, that's the exception.
And what if some of these witnesses that testified you call as a witness at trial?
So just then we rely on actually the discovery statute talks about that. We would say that at that point, when the state has made the decision to call one of the witnesses that has testified before the grand jury, at that point, the transcript becomes relevant.
All right, so we may have to talk some logistics, but we'll see where we end up. So Mr. Grubman or Mr. Aurora, your motion.
Your Honor, just take exception with doing what what they call Jenks material in federal court, where they give it to you at the last second, because we have to craft a defense based on it.
And then that's what I was getting to. We'll get there.
So if we look at the litigation that happened before the special grand jury, it's 2022-EX-00024. I'd like to adopt the brief that was filed by the media companies asking for the release of all these transcripts, because they've got a lot of the law that I've cited, so we don't have to sort of go through all of it. OCGA 15-12-101 lists out the requirements that a special grand jury needs to do. And that requirement includes interim reports that have to be presented to the judge as far as what their work is going on. I didn't know if there were transcripts, but apparently there are in this case, as what the prosecution says. We know that based on the report that was released, there were 75 witnesses that testified before the grand jury, which I'm imagining were all recorded. They've already told this court they're going to have 150 witnesses. So whether they choose to call those witnesses or not, I'm entitled to those transcripts to decide if we want to call them, if there's any impeachment material out there, inconsistent statements, or in fact, exculpatory material that might have been said by any of these people. So I think we have an absolute right under the discovery statute. They have to present all the information from their case in chief to us as ordered by your scheduling order, and there's no protection that's out there. We then go to 15-12-80 that gives you the criteria for publishing the special grand jury report. I've also cited the cases that talk about the secrecy issue sort of goes away. Hence, I think the foreperson of the special grand jury went to the press and made all kinds of statements about these issues. Olson versus State is probably the seminal case. It's 302 Georgia 288 2017 case. And then I also cited the In re Gwinnett County special grand jury case that also allowed for disclosure and said that secrecy doesn't apply after they finish. That site is in my brief as well, Your Honor. I would further go back about 70 years and go to Dennis versus United States in the United States Supreme Court, 86 Supreme Court 1840. It's a 1966 case that also talks about requirements for disclosure for grand jury transcripts. In every federal case, grand jury transcripts are made available to the defense. They just have a different statute as to when that Jenks material has to be released.
But it's not every transcript. It's simply going to be the witness that's called.
The witness transcript.
Right? You're asking for everything.
Well, I don't know what exactly they were.
Okay, so I know y'all over here know what all these terms they use, right? We know what case in chief means. That means whatever side is presenting the side. So that would be their case in chief. We know what Jenks material is. That's a part of, just like Brady material, that's exculpatory. Jenks material is also pretty much information gathered by witnesses that's going to testify. And it usually favors the government or the state in this case. Yes, the state. Well, the government. I'm sorry, it's a government case, right? State case. Sorry, state case. Duh. So, what else they said? What other terms? So, but y'all, we don't we go through this all the time.
Recorded. So, if they're talking about witnesses, that's fine. But as Your Honor knows, the grand jury is one-way traffic. The DA controls the information that's presented to them. So I don't know what it is they're giving them, what it is they're not giving them when we challenge the validity of the indictment, which I've done in a separate brief as far as that goes. So I would like everything, but at a minimum, I think the law requires the witness statements, whether they choose to use them or not, doesn't avoid the responsibility to give them to us. Maybe I want to use it. I'd like to know who those 75 people were that testified under oath in front of that grand jury, aside from Mr. Chuley, as they've identified. I don't think there's any way really around that. I think the law supports us, and whether it's a protective order or non-protective order, that's their choice. We don't plan on sharing anything with the press, but we need it, and our client needs it to actually prepare for this case. So I think the code sections, the case law, even the Supreme Court case law, and just frankly, fundamental fairness requires that those transcripts, at a minimum, the witnesses be turned over. But I think I'll be allowed to have all of it, because if we're going to challenge the validity of the indictment based on what the grand jurors represented, I think we have a good faith basis to ask for that.
What code section are you referring to that you think entitles you to all of it?
The way, again, I'm no expert in special grand juries. I haven't prosecuted one when I was a prosecutor as far as that goes, but I'm looking at 15-12-80 that generally talks about publishing. And a lot of that was discussed with Judge McBurney with regards to the case site I gave you as far as the special grand jury. So a lot more law is there. So I didn't want to just burn trees down if it's already been argued out there. So I just highlighted the 2 statutes and essentially 3 cases that talk about the secrecies, if not negligible, much, much lower as far as that goes once the special grand jury is ruled or made the recommendations.
Okay. Thank you, Mr. Rohr. Mr. Rafferty, I think you joined this one, did you not?
I did, Your Honor, and I would join in all the arguments that Mr. Rohr had made.
Well, actually, I think maybe you formally didn't on the record, but if you want to orally now.
I would
that's
join,
fine.
Your Honor.
Okay.
And the only thing I would add and echo from Mr. Aurora are the due process concerns that he's raised. The government has said they'll turn them over, but only turn them over after they call witnesses. That smacks the gamesmanship, and it would not be the efficient way to try this case. There is no real reason for the government. They have to disclose their witnesses, to not disclose the transcripts of any witnesses that testify before that special purpose grand jury that is going to testify at the trial. Moreover, and I'll raise this at a later point in this hearing today, I do have some very grave concerns about the government's compliance with their Brady obligations. I have already submitted 2 Brady requests. I have not gotten even a response. I'd like the opportunity to raise that.
All right, so Brady, Brady material, Brady evidence, that is the exculpatory evidence that must be turned over. As we heard early, I think she said that hold on. I think that she Charm Haven. What the fuck? I think that she said that yeah, she had a she opted in, right? Meaning, so they're going to have reciprocal discovery, meaning both sides have to give over their discovery, right? AKA the evidence. All right. So he's threatening pretty much the potential Brady violation, right? Because he's saying the government has not turned it over.
Later, but I believe that there could be Brady information that is in those transcripts that they are obligated to turn over independent of any statutory discovery obligations.
All right, Mr. Wade.
Yes, sir.
Judge, I think we have started to put the cart before the horse, so to speak. Let's start with the premise that long-standing and unquestionable authority indicates that grand jury materials, including transcripts and records, are not available to criminal defendants because grand jury proceedings are considered to be confidential. And the state is relying upon Stinsky v. State there. And I have a copy here of the report. And counsel, if I might approach that.
Thank you.
So this Stinsky case, along with the Ruffin and the Isaac case, stands for the very same proposition, which is they're not. Let's go.
Do you think there's any distinction here between these cases that are going to talk about grand jury proceedings and this having been a special grand jury that they're asking for?
There's no distinction.
And why not?
Well, the purpose is just the same function with the exception of the charging element. The special purpose grand jury is an investigative jury, does not make charging decisions, but can make recommendations. A regular grand jury obviously passes down the indictment. So,
but I think Mr. Aurora's argument is that there's a particular statute that only applies to special grand juries that might impact that.
There's not.
Okay.
What is that statute?
Well, he cited 1512-8, I think it was. 1580, excuse
Now
me.
he can't even get his glasses together. Come on, Nate.
And so just so we're not confusing things, these cases talk about
regular grand juries and their deliberations?
Well, I think that's the question I just put to him. So let's see where we go.
There's a difference. 151283, Judge?
Well, I think it was just 80.
That's a disclosure statute. There is no distinction, Judge. The case law is the same. I think that particularly the Olson case that defense counsel is relying upon is not even a case that considered turning over information. That Olson case essentially it merely considered which employees a district attorney can be of a district attorney's office that can be present.
I agree with you there. I think Olson goes more towards what we're going to get to about whether they can speak to grand jurors, what about. I think, and we can, if you need to do a supplemental brief, we can do that. But the issue is, because we don't see them as often, whether special purpose grand juries have some different degree of secrecy than a regular grand jury, such that we can't just reflexively look at this case law and say, all right, not a hard call.
So, Judge, I think that the application is the same. The analysis is the same. Why is there a distinction between the special purpose grand jury versus the regular grand jury? The law is clear on the defense counsel not being able to get the transcripts or anything that demonstrates that comes out of Ruffy's case and the Isaac's case. But I'd like to direct the court's attention to the fact that there's no authority that demonstrates any defendant is entitled to these grand jury
authority is simply the precedent.
Courts disfavor the release of these transcripts. Defense is pointed to none.
Authority is simply the precedent, right? The precedent, which is a decision that, or the authority, or a decision which help governs and determines how future cases are decided, right? And then the case law relies on those precedents, aka authorities, when they're making their decisions, when they make their opinions. That is what is called case law, aka common law. Okay. Common law versus statutory law. Statutory law is the statutes, the laws, what is clearly written. Common law is when the judges, case law, when the judges make opinions based on the law, but chiefly based on their decision, using the precedents as a guide. And like, just say Roe versus Wade, right? That's one. Historical decisions like that, you can consider those are precedents, right? And just look at the very nature of the word precedent, what it means, right?
No overriding factor that would override the policy favoring the secrecy of grand juries, and that is the guiding principle, Judge. It's the secrecy of the grand jury. The Supreme Court says that the grand jury is a public institution serving community that might suffer if those testifying today knew that the secrecy of their testimony would be lifted tomorrow. This indispensable secrecy of grand jury proceedings must not be broken except where there is a compelling necessity. They have to show what that compelling necessity is, Judge. And the Kessler case, along with the other cases that the state has just given, support that proposition. But also the Supreme Court in the Anderson case does as well. Now let's talk about the Supreme factors, Judge, that a Douglas Oil case that First, if the pre-indictment proceedings were made public Many prospective witnesses will be hesitant to come forward and voluntarily, knowingly, and those against whom they testify will be aware of their testimony. That's the first thing. The second factor against releasing information is witnesses who appeared before the grand jury will be less likely to testify fully and frankly, as they will be open to retribution and also to inducements, which we've seen a little bit of in this case. Third, there also would be the risk that those about to be indicted would flee, or fourth, would try to influence individual grand jurors to vote against indictment. 5, and finally, by preserving the secrecy of the proceedings, we assume the persons who are accused but exonerated by the grand jury will not be held up to public ridicule. Those are factors, Judge, that the court should consider in determining whether or not the grand jury secrecy provision has been overridden by counsel's arguments. We don't believe, Judge, that the defense has relied on any case that would override those factors, but moreover, any treatise that would assist upon them in their reliance, Judge. They did cite to the Henry Gwinnett County case, Judge. And even in that case, the requirement that secrecy be maintained among all types of grand juries without distinction. And that's in the Henry, and I'll report a copy of that case. I apologize, Judge. I didn't bring the court a copy of that Henry Gwinnett County grand jury case, but that's the case that counsel relied upon and cited in its brief and even in its argument today. But that case is found at 284 Georgia 510, and it stands for the proposition that the requirement that secrecy be maintained among all types. It says all types of grand juries without distinction. So again, the state would submit to the court that there's no difference.
All right. So obviously I'll take a closer look at all the cases you've given me. And I think just as an initial reaction, you're probably right when it goes to saying everything should be turned over. But I want to drill down a little bit more on the witnesses who maybe at this point already that you're going to call in November, right? I think that's the whole point of our scheduling order here, and what we try to do is that we need to use our trial days efficiently and use our jurors' time efficiently. And I would imagine that the state is going to have an order of proof going into this trial with a list of witnesses. And if there are witnesses that are on there, the idea of waiting until the minute before they're called, and then we've got to now pause the trial for an hour or two while then they're reading the transcript, I don't think we can do that. Would you agree?
I agree, and I understand that, Judge. The state wasn't intended to convey that it would hold on to a particular witness's transcript until the eve of trial. We're still obviously going through receiving the transcripts, Judge. We don't even have every one of the transcripts. And so we're still going through that process as well. Suggestion that the state not essentially implied that the state would not hold on to the transcription to the 11th hour. That's not our plan, and that's not how we.
So I would think at a bare minimum, and maybe we can talk about whether we have to move that timeline at all. But your witness list is going to be due 10 days beforehand.
Yes, sir.
And so in conjunction with that, I would think that any witness on there who has a transcript, that needs to be either expedited or rushed and also provided at that same time. And if the issue comes up that well, we didn't put a witness on that 10-day list, but now we think we need to call them. Unless it's for a rebuttal or some new issue that's come up during trial, I'm going to be looking at that and really wondering if a good faith effort has been made to turn everything over. So I think that's not only what defense counsel was referring to, but I think that's the way what we have to do to proceed efficiently at trial.
Yes, sir. Yes, sir. And there's no argument or disagreement. I think that the court is being reasonable there. But while we're talking about that discovery, we believe that we're still in line with the court's scheduling order as it relates to discovery. So counsel standing.
Yeah, well, and we can, we'll talk about that at the end. Let's get through the motions first so we can get more into discovery. But, generally I would think this case is obviously different, but the state's open file policy traditionally has been, here's everything we have, unless there's some kind of state secret or a confidential informant or something along those lines.
Yes, sir.
And you have everything that we have, and here we go.
Yes, sir.
So I don't know if that's going to be the spirit that we proceed with here. It might streamline things somewhat, and I would, we'll see where it goes. Any thoughts or reactions to that?
Oh, it is the spirit, Judge. The district attorney has been clear in our instruction. We are to make information available to them as it becomes available to us. We are here prepared today to turn over portions of the discovery to the two defendants that are going to proceed with trial on the 23rd. Obviously, we plan to supplement that discovery as we go along and as we receive the information, but we've made a good faith effort in complying and being reasonable and working with defense counsel, and we'll continue to do that.
All right. And when it comes to supplementing it, I would think that's going to be confined to new discovery.
Yes, sir.
Stuff you don't have right now, right?
That's stuff we don't have right now. Yes,
so I think for purposes of the motion, let's see, to unseal, I'll take it under advisement as it concerns the entirety of the record or anything that happened there. But as an initial thought, at a minimum, it's going to be granted in part as to any witnesses the state plans to disclose.
Yes, sir.
All right. Anything else, Mr. Rafferty?
Comments I want
Sure.
to make in response to the argument, Mr. Wade. We cited to a Supreme Court case, Douglas Oil versus Petrol Stops Northwest, Supreme Court case. It cites to Rule 6E of the Federal Rules of Criminal Procedure. The problem with that case, Your Honor, and the case he cited is it has to do with the use of grand jury transcripts in a civil proceeding, which I know Your Honor knows, grand jury transcripts in the federal courts as part of a criminal investigation can't just be turned over in civil cases. And so the case he cites has to do with whether or not and under what circumstances grand jury transcripts from a criminal investigation that results in indictment can be used by civil practitioners in a civil case. That has nothing to do with this case. And the point I'm making with this, Your Honor, is this. The government has now cited to a case that really has nothing to do with this. They come to court here today. They don't respond to the motions in writing. They drop some motions on defense counsel, or some cases, I should say. They don't put anything in writing, and they just say things to Your Honor. And that's a troubling practice for me as somebody who practices mostly in federal court. This is a serious case.
I think you have to realize, I think that might be the standard practice in this building.
I understand that, Your Honor, but I look behind me and I see eight folks here on the government side. We're talking about a case that is unique, to say the least, involving allegations related to the supremacy clause, First Amendment rights, all kinds of things. Defense counsel are writing motions. I think we're at least entitled to a written response from the government citing these cases so that we have an opportunity to inspect them. Because otherwise, what happens is the government comes in, cites to a case that has no application whatsoever, and suggests to Your Honor that it is precedent on that governs the disclosure of grand jury transcripts when it does not. And so my concern and my request is that, and I filed a motion last night where I specifically asked the court to order the government to respond in writing so that we have a chance to look at these cases before we come to court here today. That's my request.
So, Mr. Rafferty, I think that obviously some of this going back and forth will be touch and go, but I think what we could easily do today and going forward as well, not every motion may require that, but we can always say if a party wants post-hearing briefing, we'll do that. I'm not intending to rule from the bench on a lot of these complicated issues. I mean, I've been handed a stack of cases and I'm going to read them. and we're going to have time to get through it. It's going to be an expedited timeline, but I'm certainly going to give you the opportunity to respond.
I appreciate that, Your Honor, but I guess my point is, and I think my counsel here would join me in that, this process would go a lot quicker if the district attorney's office with their team of lawyers would write a brief that cites the same cases that they're bringing to court every day, so that we have an opportunity before we come before Your Honor to look at those cases and question whether or not what those cases say supports what they're claiming. And if they don't, be prepared to address it so that we can move this along, as opposed to us having to go back after today, research the cases, then write a post-hearing brief, point out to the judge that what the government is saying is not actually true. So that is one of the benefits, respectfully, Your Honor, of requiring the government to put it in writing.
All right, understood.
So just briefly, in response to Mr. Rafferty's argument, he did in fact, we would say at the 11th hour, file a motion requesting that the state respond in writing. The state has done that. I don't know if Mr. Rafferty has had the opportunity to check his filings, but the state has done that this morning.
Is this for this particular motion? Oh, okay. And obviously you file something and it's taking hours for it to post the docket, so we're just gonna have to recognize that. And I think that's why I would say emailing a courtesy copy is going to be the way to go.
Yes, sir. So this morning the state has filed it. It does cite to and speak about the cases that the state has cited to this morning and provided copies of.
All right. So, and Mr. Raffi and Mr. Rohr obviously want a chance to respond to this and review it. So we're not ruling on this today, and we can take the time to allow you to do that.
Just reflect the record of a couple of things with the special director.
Sure.
So again, I'm citing back to Judge McBurney's order as well as the issues on the special grand jury case. And when you look at 151280, they specifically said it's different from a regular grand jury because they make recommendations as to should we release this report or not release the report, and they vote on it. There's all kinds of discrepancies that aren't the same as a criminal grand jury, which is what we've got here. Now, I take exception to the courts. I know you made a comment that if they're going to call a witness, they have to turn it over in a certain time. I get it. What about all the other witnesses they don't plan on calling? They may be witnesses for me. 1716.4 should trump all that because that's the discovery statute that says any witness they've talked to has made a written statement has to be turned over. That's where the due process is. They don't get to pick and choose what witnesses we get to see or not see. I might want some of them. And if we wait, I guess your order says disclose everything by the 20th of September. So I'm assuming we'll get a big batch of discovery. I've been told up to 8 terabytes by the 20th. I need to be able to review it to figure out what my defense necessarily is going to be versus doing it on the fly like we do in federal court. And we don't have trial by ambush. That's why I appreciate we're here and the discovery statutes are strong. But that's my point to you. And I would also go ahead and cite to Olson again, which is the most recent case that specifically says, notably, the oath of secrecy no longer extends to the state's attorney, and even the grand juror's oath encompasses only deliberations and not all things occurring in the grand jury room. So at least for the special grand jury part, aside from the second brief that we've got, we should be able to get everything that happens in there aside from arguably deliberations, but at a minimum, at least the 75 witnesses or whatever else that they presented. So I would say that Your Honor said at least what they're going to use. I think that's not correct enough. It should be everything. Thank you.
All right. Like I said, I'll take a look at it. I also, just a passing thought as well, when it comes to Brady concerns, I think we could also utilize a mechanism where maybe they have to in camera give me the entire transcript. And so if during the trial something comes up that we think is Brady material or should have been disclosed, we can pause things and correct it from there.
And on that point, Your Honor, with respect to Brady, as I said, I'd like to talk about it in a bit, but I would just remind the government counsel here that Brady is in the eyes of the beholder. What Brady material does not. If I contend it's Brady material, I'd ask the court to inspect it and see if it does fit with what I claim. If it does, I'm entitled to it.
Understood. Okay, let's move on, obviously, and we may need to come back to this one at another hearing, depending on how it goes. So the last motion that we had scheduled for today is the motion to speak with the grand jurors. Mr. Grumman, it looks like this one's yours.
This one's mine, Judge, and good morning again. For this motion, I want to
begin with the indisputable proposition that I'm sure my colleagues on the state side will agree with, of course, that Mr. Chesborough and also Ms. Powell, although obviously I don't speak for her, have the right under Georgia law to be charged only by way of a grand jury. That is a key tool, as we all know, to prevent prosecutorial overreach. I would argue it's one of the most important provisions in both federal and state law. So that's clear. We don't have to, I don't think, argue that point. So then I think, Your Honor, the question becomes, if you accept that premise, what does that right mean? What does that right entail? So if, for example, a prosecutor simply gets up and summarizes to a grand jury a lengthy indictment, as opposed to allowing the grand jurors to read it and understand it independent of the prosecutor, is that indictment valid under Georgia law? To be quite clear, Your Honor, the case law is kind of sparse. We would argue that the answer is no. Thankfully, we don't have to argue that case right now. But the reason we would argue, if that were the case, the answer is no. The law is clear. The grand jury must act independently of the prosecution. I'll be quite frank, Your Honor, and this is not, I want to make clear, not in any way negative against the lady and gentlemen who sit here at this table. But just generally, I have very serious questions based on publicly available information, which unfortunately is all we have to go on, that this grand jury, as well as the special purpose grand jury, was independent. But we don't know that. That's the problem. We don't know that. And in order for us to find out the answer, which clearly we're entitled to find out, we have to be able to access information. Your Honor, I do very much appreciate the fact that Mr. Wade stood up here and said the spirit of openness applies to this case. And I truly hope that from the moment Mr. Wade said that forward, that's what happens. I wouldn't be doing my job, Your Honor, if I didn't tell you for the record, I personally do not believe that that has been the spirit of the state of Georgia in this particular case. I think quite the opposite, Your Honor, that every time we file a motion or ask simply for access to the same information that the folks on the state side have, where it's responded to and said, no, we can't do that. I know there's a discovery deadline that's, I think, in a couple of days. I understand that. But quite frankly, Your Honor, we turned over this, this is exactly what happened. The state said, Mr. Grubman, Mr. Aurora, we have your discovery. All you have to do is give us an 8 terabyte hard drive. That day, literally probably within 2 hours, we were down here with the hard drive. Follow-up email. Where's our discovery? Where's our discovery? Where's our discovery? There is no, we haven't gotten the discovery. And Your Honor, I'm not saying they violated the court's order because that deadline hasn't come. But if we're really being open, and if we're really gonna talk about the spirit of openness, I really hope that starts here. And this is just another avenue, our request to speak to the grand jurors, to allow us to have the same information that the state has. Now, Your Honor, we went back and forth internally, to be honest with you, about even filing this motion. Not because we don't want to talk to the grand jurors, but with all respect to the court and to the state, we quite frankly didn't think we were required to necessarily ask the court for permission. As you know, Judge, grand jury secrecy, with all due respect for Mr. Wade, citing all those cases that predated the Olson case, it doesn't exist except for deliberations. It does not. The Supreme Court in State v. Olson was absolutely positively clear, as Mr. Aurora stated, there is no grand jury secrecy here in the state of Georgia. There is grand jury secrecy in the federal courts, as Your Honor knows. That does not apply here. Prior to, there were certain legislative changes, and there was a time, my understanding is, in the state of Georgia where there was similar rules as to federal court, and that is no longer the case. So there's no secrecy. Now there is confidentiality, of course. And the only part that's truly secret and confidential is the deliberations. And I want to make sure it's clear that we are not asking to speak to the grand jurors about their deliberations. We will not do that. We're officers of the court. We know we can't. We won't do it. Now, Mr. Wade laid out certain factors of the purposes of grand jury confidentiality. I think he named 5, but the Olson case names 4. I'm sure there's different formulations, so I'm just going to go through 4. Again, prospective jurors would be hesitant to come testify. Actual witnesses to testify fully and frankly if the grand jury was open to others. The Supreme Court said there was a risk that those that were indicted would flee or would try to influence the grand jury against returning indictment if the grand jury was open. And 4th, it was ensuring that those accused but exonerated by the grand jury, apparently that happens from time to time, wouldn't be subject to public ridicule. Your Honor, I would submit to you that none of those purposes apply here. None of those purposes, in fact, even apply after a grand jury issues an indictment.
Let me jump in, and having read the Olson case up to today, and I think there was one, Collin, that really predates it.
Yes, Your Honor.
And in Collin, they've got the defense calling a grand jury witness to talk through some of these issues of who can be present during deliberations, who can be present during the presentation of evidence. And so it seems to me that I agree with you that you have a right to talk to grand jury witnesses. What about? We'll get to. But, and I'll say on the front end, I appreciate you filing it this way because these grand juries have been through a lot.
Yes.
And I think we need to recognize that and craft a remedy here that recognizes that. So my initial reaction, just to lay it out there, is that, yes, I think you have the right to speak with the grand jurors. How that happens, I think we can discuss or craft. I think maybe, I don't even know if you can have their contact information. I've heard that it maybe already be out there, but I think that might have to be something that is facilitated in hand with the state. It also has to be something that's voluntary on their part. But then the question turns to what end are we doing it? And I think that, as you alluded to, if the inquiry is to determine did they act independently, all right. But the standard you're laying out here that they have to, where I then start, drawing, kind of pausing, is this standard or this benchmark that they have to have affirmatively read every word of the indictment. And that's where I wonder if this might not be. There might not be a point in going down that road. If you have some other reason you want to explore, then so be it. But this idea that we have to show,
Your Honor, wouldn't necessarily say every word. And if I did say that, I apologize. But what I do think we would have a valid argument on, and obviously at the right time the court would, is that if it was simply summarized, Your Honor, please understand, and I hope everyone understands, all the information that we have is the stuff that these folks print in their papers. We don't know. So I am not saying that that's what happened in this case.
Well,
I will say,
let's even play in that sandbox a little bit. Let's say it was just summarized. And again, we're just previewing the arguments to see if this is even worth getting into later. At trial, a jury could come back with a 15-minute verdict. And there'd have been no way that they could have read a lengthy indictment or even looked at every exhibit. And there's no inspection or remedy for that. So why would the grand jury, where would this rule come from?
Well, it's not like there's a rule in the statutes, but what there is there's a rule, there's a theme in the case law. And we cite many cases, and I'm sure we could cite a lot of other cases, that the grand jury must be independent. Now, what is that? That's why I start with asking, what did that mean? Does it mean that they have to read every single word? I don't know, Your Honor. And if that issue comes before the court, we will brief that issue and we'll figure it out. However, I would argue that if the state of Georgia, in this particular case, presented their case to the grand jury in one day, which I can't say for sure, but based on the publicly available information, that's a possibility. It would cause my eyebrows to go up a lot. And I'm not alone. Judge Choflat in the United States v. Sigma International, now that case has been vacated. It's not presidential. Yeah, that's the right word. But that being said, the dicta still applies.
But that case didn't have so much to do with any method of how the jurors reviewed the indictment. I think they were citing the transcript of the AUSA, essentially steering them exactly where to go.
Your Honor, the thing is, that may have happened here. I don't know.
And I hear you there. Just my point being is that just summarizing an indictment to me, you know, for example, if we know the deliberations, we can't go into that. That's protected. How would you ever ask the question of whether another grand juror read the indictment to everybody else during deliberations? I don't even think you're gonna be able to answer your own question.
I respectfully disagree, Your Honor, and we could craft some questions. Obviously, we would have to think of the language, but what I think we want to know is, Mr. or Mrs. Grand Juror, when the evidence was being presented to you, did you have the opportunity to ask questions? Did you have the opportunity to follow up? Judge Troflat said, and this is dicta, but we rely on dicta all the time as at least persuasive. So too, would we dismiss an indictment that was issued by a kangaroo grand jury, quote unquote, one whose deliberations were so overborne by a prosecutor or judge that the indictment was in effect the prosecutor or judge's handiwork and not the result of considered judgment by an independently functioning grand jury? Now, while we can't ask the grand jurors what exactly happened in the deliberations, what I think we absolutely can ask, and we will ask, I will put this on the record, is was there anyone other than the grand jurors in the deliberations? And that, I think, is what the other case that we cite, Collins, stands for the proposition. But, Your Honor, we simply want information. The reason we filed this brief, this motion, is to be above board and make sure that everything was out there in the open. However, I would respectfully push back, Your Honor. We would not agree, obviously court could order anything they want, for any member of the prosecution to be part of those conversations. We are officers of the court. We know the rules. We will follow the orders. I would also ask the court to state, or I would ask the prosecution to state on the record and commit. I'm not saying that they're going to do this, but I have seen other prosecutors do this, that if the court grants this motion, they will not attempt to influence the grand juror's decision of whether or not they talk to us. We, of course, know it's voluntary. We would never, once the grand juror said, I don't want to talk to you, we're going to hang up. I can promise you that, whether it's us or our representative. But I think there's a risk here that someone from the state might try to get to them first, and that would be inappropriate.
What if the grand juror wants a prosecutor to just be on the call listening as well?
If the grand juror wants a prosecutor to be on the call, then, I mean, if they proactively say that, we can see where it is, but they're not inviting us into their prep. You know, they're not inviting us. I've never gotten an invitation to help them draft the motion and to talk to them, sit in their conference room, and they don't have the right to be with us. If they want to talk to the grand jurors, they've always been able to talk to the grand jurors. They have talked to the grand jurors. But I like Mr. Wade a lot, but I don't want him on that phone call because he's my adversary. And quite frankly, I think that think about this, Your Honor, if hypothetically there was something that happened in the grand jury that wasn't appropriate, the fact that a member of the prosecution was on this call, I think would prevent, or at least make it less likely that a grand juror would be honest with us. What if a grand juror felt, and I'm not saying this is true, but what if a grand juror felt that they were bullied by the state into prosecuting? What if a grand juror felt that the state, went a little overboard? Well, if Mr. Wade was on the phone, I don't think they're going to admit that to me. So as an officer of the court, Your Honor, I think the court, with all due respect, just needs to be able to trust counsel that we will do the right thing. And I could commit 100% that we will. These grand jurors, you're absolutely right, have been through a lot. They sacrificed a lot. We are not that, there's been doxing and all sorts of things. We are professionals. We are not those people.
How would you, or would you be planning to document this in some way? Or would you be recording these calls?
Yeah.
Would you have a court reporter? What would be the plan?
I believe there would be so we haven't talked exactly about the logistics, but there would be some sort of recording, whether it's a court reporter, just a good old, iPhone recorder or whatever it is. And we would tell the grand jurors that, even though you're not required to do so in the state of Georgia, I would be much inclined to tell the grand jurors, hey, look, we're recording this. It's, just so there's no question of what was asked. Obviously, Judge, the last thing I want to happen is for anyone to incorrectly accuse me or someone on my team of going past what we're allowed to ask. So for my own sake, we'll definitely have some sort of recording. Unlike the state of Georgia, as Mr. Rafferty said, they have about 15 lawyers, bunch of investigators, and basically an unlimited budget paid for by the good taxpayers of Fulton County, myself included. We don't. I want to be clear, despite what the media may have said, we don't have an unlimited budget. So whether we could ask a court reporter to be there, unless the court would volunteer your court reporter, I don't know that we can afford that, quite frankly, but we will certainly record it.
All right, so essentially what I'm hearing is what you'd be asking before is that we'd propose if not the exact questions, but the subject matter, very carefully phrased in advance. This would be a voluntary meeting. It would be documented in some way. And even if the state is not on the call, I think that we could also have someone from the court there as well, just at any point,
yes,
if the juror feels like they need to kind of pull the ripcord.
Yes, Your Honor.
All right, but otherwise, I don't think there's much point going into the merits of the motion because we're just a bit premature. So that's the initial reaction. Mr. Wade, or sorry, Mr. Rafferty, you joined this one. Excuse me.
I did join the motion, Your Honor. The only other point I would make is join Mr. Grubman's arguments is the possibility that these interviews not be conducted by phone at all. Perhaps they can be conducted in person, and there could be accommodations made, I would think, with most over the phone. That's just my opinion.
And I think, for me, the driving consideration is going to be the desire of the grand juror. Do they want to come all the way back down here and deal with that, or would they rather just do it over the phone? All right, Mr. Wade.
Just let me be clear, the state is absolutely opposed to any of this. And Ms. Young is going to come before the court and tell the court why. But I thought that at the outset of Mr. Grubman's arguments, I thought that I was clear before we started to argue in terms of the discovery. Mr. Grubman has indicated that he hadn't given him anything, but I thought that I was clear that the discovery was here.
Well, let's keep. I feel we keep getting back to discovery. Let's say that to the end there.
But those were his arguments, Judge, and I didn't want the court to.
Well, right now we're focusing on grand jurors. Let's. I understand. We'll get to that.
Ahead of schedule.
We'll get to that. Let's talk about grand jurors. All right, another PowerPoint. Here we go.
Your Honor, you could say another PowerPoint before. This goes to my original point, which is the state spends the time to put together a PowerPoint to respond to emotion. That takes a lot of time. I understand. I'm sure it's going to be persuasive. It would be much more efficient for all involved if instead of putting together a PowerPoint, somebody put pen to paper on the team of 8 lawyers here, put it in writing so that we could see the cases, we could move through this argument, and we could get to the end much quicker. Now we're going to see these cases from the state for the first time. Mr. Aurora, Mr. Grubman, and myself will look at these. We'll go back. We'll probably find things that perhaps are inaccurate and have no choice but to then file some supplemental briefing. With a trial date on October 23rd, this process is just not an efficient use of the court's time. The more efficient process here is to write a brief, file it, like we do in federal court all the time, like this DA's office did in federal court in this very case in front of Judge Jones, and just file it here. That's my ask.
All right, understood. And I think, again, we're just going to take that up on a motion by motion basis. All right, Ms. Young.
If I may approach.
Sure.
To be able to speak to grand jurors. And I think the state and Your Honor are probably on the same page, so I'm going to try to go through this pretty quickly in regards to deliberations, because what the defense motion stated was, in their motion, is that they wanted to know if the grand jurors had been read the indictment, and that was the purpose for them talking to the grand jurors. Here today, we find that there are some other reasons that they may want to speak to them, but the state's belief is that, it's not moving, as the court talked about deliberation, it is part of the grand jury's reading, whether or not it was read to them, whether or not they read it during deliberations. We're all trial lawyers here. We know that a copy of the indictment goes back with the jurors when it's a trial jury. They're reading over it to make sure that the evidence matches the evidence that's been presented. That's the same thing with the grand jury. They're given a copy of the indictment. They can do with it as they please. And if we start to get into questioning that, we are getting into what they were doing during their deliberations. As the court pointed out, did the foreperson read it to them? Did someone else read it? That's all part of their deliberation process, which has clearly been prohibited by anyone getting into their deliberation process. So the state's contention is that these questions about the grand jury and reading of the indictment summary is part of the deliberations, and they can't get into that.
But more prepared, like me.
Says, the current grand jury oath requires grand jury to keep the deliberations of the grand jury secret unless called upon to give evidence thereof in some court of law in the state. And it talks about extraneous prejudice information, which I think goes towards the Sigmund case, is kind of what they were talking about, as the court pointed out, whether or not the prosecutor was steering them to a particular decision. It talks about outside influences or mistake in entering the verdict. None of those things here exist, and I'll get to their solution as to how they want to handle that with the court. But I will also state that Federal Rule 606, as well as the 2406 here in Georgia, mirrors that, which basically says the same thing, that the validity of a verdict or an indictment, a jury shall not testify or an affidavit otherwise, nor shall a jury's statements be received as evidence in any such manner. And that gets into what is the purpose of this voir dire that they want to do of these grand jurors. How can it be used? According to the law, it can't be used as evidence at trial. They can't testify. They can't give affidavits. So how are they going to even use this information that they received?
We've got this, I think it was the Collin case where an entire indictment was dismissed when people were inside the deliberations. And so the question would be, how on earth is a defendant ever supposed to find out whether that happened without talking to the grand jurors?
Well, Your Honor, we're officers of the court. You can say no one was in there besides the grand jurors.
Yeah.
That's what they're asking for us to do for them. They can state as their place as officers of the court, this is what the grand jurors said to them. We then can state in our place as officers of the court, only the grand jurors was present during deliberation.
So, but in Collin, it says the defense presented the testimony of a grand jury witness to support his assertion. And I know it's not really undirected, or it's just kind of in passing a fact that's present there. But I certainly haven't found anything in Georgia law that says no one's allowed to talk to the grand jurors.
Well, and I think it's not that they're not allowed to talk to them, Judge, but I'm basing on what their motion states.
Sure. And I think we've arrived at the same place there, where it's going to, again, and I'm kind of seeing that this might all be futile, but I'm with you that deliberations are a hard stop, and I think the defense has conceded that. So really what it all is coming down to, it seems to me, is what are they allowed to be asked?
Right. Well, I'll kind of move on to that point, talking about 204, 403 about the relevance. And specifically OCGA 1512-773 especially states admissions and communications among grand jurors are excluded as evidence on grounds of public policy. So I just think the things that they are asking for gets into how are the jurors communicating with one another. I think it all goes towards how they deliberated. Mr. Grubman got up here and talked. How quickly could they have come to this decision? You know, it's a 98-page indictment. That all goes towards their deliberation. Asking questions about that is part of the deliberation process. It's prohibited. So I think if we're going to get to this point, which the state does not concede we should, we have to figure out then how is it going to be used? Because the case law is clear. Testimony of grand jury witnesses, they cannot use this to impeach their findings. And that's what they're asking to do. They're trying to ask these questions in order to impeach the true bill that the grand jurors set down. That's what they're essentially asking to do. And it's not allowed based on the case law and by statute. And I'll just cite to one case that I don't know if they mentioned, but United States versus Van Eagle, it says an indictment returned by a legally constituted grand jury is presumed to be valid on its face. Similarly, there's a strong presumption of regularity that attaches to all grand jury proceedings. The defendant seeking to challenge the presumption has a difficult burden because it's hard to override, and that site is 809 Federal Sup 1360. So, Judge, I think we have to get into Is it relevant? Is it admissible? The questions that they want to ask these jurors, and based on the case law, it is not, because what they're asking is, we want you to change your mind. We want you to answer a question in a way that is going to impeach your findings. None of the questions that all of those things are reaching towards that. Was there someone else in there? Did the prosecutor steer you a certain way? All of that is to impeach the finding of a true bill of the indictment.
Whoa.
And there's nothing here that says that it should be. I want to touch upon the public policy and the safety that the court talked about. And we've heard it. These grand jurors have already experienced doxing, threats. We've had to they've contacted our office because of safety concerns. We've had to contact law enforcement agencies all over Fulton County to then make sure that these grand jurors are safe. So I think one consideration the court also needs to make in allowing this is the safety of these grand juries and their concerns that have already been voiced. But I'll just say the Georgia Supreme Court observed the grand jury as a public institution serving the community might suffer if those testifying today knew that the secrecy of their testimony would be lifted tomorrow. The indispensable secrecy of grand jury proceedings must not be broken except where there's a compelling necessity. There hasn't been any compelling necessity that's been raised by this defense.
I like that better.
Pierce this veil of secrecy of the grand jury.
What was the site for that last one?
Judge.
Where's that coming from?
That would be nice. Kessler, Judge.
And can you spell that one for me?
You have that case, Judge.
The one, okay.
Yes.
In my stack. We just
Got
paused
that
one
shit
moment.
together a little bit better.
And then the state, we kind of talked about Douglas versus Oil, but I just want to point out again, Judge, just talking about deliberations and the fact that it should be when discussing the charges and votes of the indictment. And I think all of the questions that Mr. Grumman talked about, that's where it's going. So if we're going to do this, which the state, once again, does not believe we should, it's going to have to be crafted very carefully to make sure that we're in line with the statutes and the case law.
All right. Well, I think we've. I'm sorry.
And just one more thing, Judge, because we talked about the grand jurors and the safety, and I've just, all these cases are in there for the court, but I just want to. We have to make sure that we're keeping that paramount because they're asking to be able to call these jurors. These jurors have already said we're concerned. We've had to, and I'm handing them actually another copy of the written response that I gave to the court, but. Because of public policy and safety, Judge, I think that is another reason why we should not allow this. And then finally, the lack of authority. What they stated to the court was Sigma, which has been vacated. It's really improper to even bring that to the court to say, consider this, when it's not even law. They've vacated it, they've renounced it. So it's not even something that the court should even be considering or thinking about. There is no authority that allows what they're asking the court to allow them to do. The indictment, and I've said that to the court, the grand jury acted rather quickly is one of the things, as the court said, we don't get into deliberations with a jury. They can take as long as they like. They can take as short as they like. I understand it may raise Mr. Grubman's eyebrows, but a true indictment was returned by a grand jury, and they could have taken 5 minutes, 5 hours, or 5 days. There's no case law that puts a restriction on how long it should take them. And that's United States versus Van Agel at 808 F sub 1360. And as I stated before, Judge, there's just a lack of authority for what they're asking to do. And attached in the state's brief, you will find in 2010, Mr. Aurora did the same exact thing. They say they come to the court and they're asking for permission. That's because in 2010, Judge Burnick in DeKalb County admonished Mr. Aurora for the same thing, knocking on grand jurors' doors, asking them questions. She, in fact, had to issue a temporary protective order to stop that behavior. The state is in the process of trying to get a copy of that order. We were trying to do it before this morning, but we will supplement the record once we get that for the court's consideration as to those findings in that particular case.
Your Honor, I want Mr. Aurora to respond to the personal attack that counsel from the state speaking of what's inappropriate, you know, it's inappropriate.
Let me just pause right here, Ms. Young. Have you finished?
I was not, Judge.
Okay, let's let her finish her piece and then we'll wait. All right, Ms. Young.
Judge, I would say, I know you've kind of crafted out some ways that maybe we can do this. The state is not in agreement with that. If this does happen, the state believes that it should be something that's done with your honor, present, and with just the foreperson. They can get whatever information that is needed from that one person because they are the foreperson. But I would ask that that be something, if it's done. State doesn't believe it should be done, but with the court present, and if the foreperson asks for the state to be present, for the state to allow to be present, and there are some well crafted out questions that are given to the court and to the state prior to any of that happening. But we'd ask that it does not happen because it is not authorized by law.
Your Honor, I take very extreme exception for Ms. Young coming up here and trying to impugn the reputation of my colleague. If I had to list out the number of cases,
Mr. Groman, let's keep this on track. I'm not going to consider it. It's not part of the record.
Your Honor, my colleague was, and this is broadcast live.
And you can respond to it on your own. Mr. Grubman, please let me finish.
Okay.
It's not going to be part of the consideration right now. If you want to handle that outside of the courtroom, that's your business. But for now, to stay focused, I think we should just focus on the law.
Respectfully, Judge, though, it was said on the record, and I think I should have the opportunity, and Mr. Rohr should have the opportunity to respond, because that was completely inappropriate. There have been many times that the Fulton County District Attorney's Office, including some of the members that are sitting in the courtroom today, have been called out by courts by name with inappropriate things that they do in the grand jury and at trial. So no, I cannot take Ms. Young's word for it that it was done properly. Ms. Young's trying to send my client to prison, and we have the right to know if it was done properly. And she keeps saying there's no case law. As Your Honor said, there is case law. Instead of creating these wonderful PowerPoints that they're so fond of, read our briefs. The Collin case says we can talk to grand jurors. So the fact that she got up here and lied to the court.
Mr. Graham, I think we need to go down that road.
Your Honor, she lied to the court, and I apologize, and she defamed my...
Mr. Graham, I said it's over.
All right. Well, I wish you would stop there for defaming my foot.
Ooh!
So where we are...
That judge is too nice.
Let me just summarize. With motion number one, with the motion to speak to the grand jurors, I would ask defense counsel to supplement their motion. We can do this. I don't think it needs to be, since this is something that would be crafted and considered, we can just do this off the docket. We can do this through email, but just a proposal of the questions, the topics that would be gone into. And if we need to follow this up with another hearing to actually hone those, we'll do that. But I think for each question or subject matter you go into, I'm going to want to see a citation for how this is an actual relevant line of inquiry. All right. And then we can get into the logistics from there, because I think there's a way to accommodate the case law cited by the state about the general secrecy, but still allowing the defense their ability to make sure that the grand jury fulfilled its duty in a manner recognized by law. As for the motions to unseal the grand jury transcripts, I think we've mentioned that I'll be taking that under advisement, and I've been provided the case law for these first two motions. Ms. Young, if you could provide a copy of that PowerPoint to the defense and to me as well, and counsel for 1 and 2, were you desiring supplemental briefing on that to respond to what we just got?
I think the case law. If you read it, you'll.
All right, Mr. Rafferty, did you want to respond?
No, Your Honor, I just would echo what I said before. I would just ask respectfully if the court were on a case-by-case basis, perhaps the government intends on drafting something like they have today and they did last week in the form of PowerPoint, that it be in the form of a motion that we have an opportunity to read and be prepared so that we don't waste the court's time.
All right. And then finally 3 was mooted. So I think that takes us to just another kind of check-in of where we are. Just a few things on my end before I know we can start talking about some discovery issues and we wrap up. Obviously, I think it might have hit the docket by now. I think sometimes, like I said, sometimes there's a delay, but we filed an order on the severance issue. I realized I never actually asked the state at the last motions hearing about the redacted indictment issue that Mr. Aurora argued and that was filed on behalf of Mr. Chesbrough. If you recall, it's the motion to sever counts from the other defendants. The August 30th motion for severance of co-defendants, and it lists several of the counts. And essentially how Mr. Aurora clarified it was that he was asking for a redacted indictment at trial. I never actually got the state's position on that one.
Your Honor, John Floyd for the state. Mr. Wooten addressed this originally. He's not here at the moment, so I'll just step in and pinch hit for just a second. As I recall the nature of that motion, one part of it was to sever individual defendants from each other and from the larger case. The subsidiary question was whether specific counts would be severed from the indictment. I believe that's what
I think that's how it was phrased, but then when we discussed it, where these motion hearings can be useful, it evolved into more of just we'd like a quote unquote dummy indictment at the actual trial of the case. That's at least how I interpreted it. Mr. Rohr, is that fair?
Yes, Your Honor. I'm sorry if I didn't write it correctly, but just like I thought you graded it, just like we do in other cases when the defendants aren't there, you white out or redact, you make it a dummy head. That's what I'm asking for.
Right.
Separate motions with regards to the accounts subsequently.
So maybe this is something more we address as like a pretrial motion in limine, but it's not so much as I take it, and off that, a motion to tailor the evidence or what the state's allowed to present, or that those other counts aren't relevant. It's more just what is the document the jury should get.
I understand, and if I misunderstood it the last hearing, I apologize. I wasn't trying to add confusion to a complicated situation already. We don't. The state, just for the record, don't see any basis to sever out any individual counts as to any defendant. But that I think is not what Your Honor was addressing now. And I'd suggest this is an issue that we can talk about and get to later. We're still, I realize that we're not talking about a lot of days, but we're certainly not yet talking about what will go out to the jury, especially since you've been told you're going to be getting dispositive motions. And so it's somewhat hypothetical.
All right. Well, I just wanted to raise it that I hadn't entered an order on this one, and I hadn't heard the state's position. So
thank you.
Is it safe to assume it's sort of graded and we'll work out how to say it?
We'll get there. We'll get there. But it's still a lingering issue.
I'd like to see an order sort of granted.
We'll work on it.
I'd rather not see something like that because it's very difficult for us. But thank you.
All right. All right. So other housekeeping. I think we're going to I just wanted to flag this as well, just again, because we're on this compressed timeline. We'll get more into the mechanics of jury selection at the case management hearing later this month. Obviously, those are conversations we're starting to have with the court administration and flag that the state had filed a motion to use a jury questionnaire. I think that's absolutely appropriate here, and I think it's going. I don't think you need to. We'll do it, and so. We'll probably have the deadline to submit those questions several weeks beforehand. So, maybe go ahead and start crafting those now.
I had spoken with Mr. Wooten last time, and we didn't necessarily agree, but at least talked about the possibility of getting together and trying to craft questions that we all might agree on, and then maybe having two separate sections, assuming there's some that the state wants we don't want, and vice versa. We could submit all that maybe in the joint filing.
That sounds wonderful to me. I also want to flag that as I highlight more in the severance order, we're going to make an attempt because I think my initial review of the speedy trial case law is that it's somewhat uncertain of when a trial commences. And so we're going to be making the attempt to have this jury sworn by the deadline of November 5th. Maybe that means a weekend or two is involved. But regardless, I just want to warn you when it comes to the questions you submit on there, we're probably going to have to adopt the federal practice of clock and a timeline, and you have so much time per panel, and however you want to use it to see fit. And you can ask 100 questions, but you may not be able to follow up on all 100 of them. So I just want to lay that expectation out there.
A different topic, can I give you the court something to think about?
Sure.
So there's a trial going on right now, actually, the jury's deliberating now, federal court, several federal judges, and then I have a case up in New York, have done a modified trial schedule. Just if you can hear me out, it's just something the court might consider for a lengthy trial like this. And I could get you all the very specifics, but basically I think they go from like 8:30 to like 3 or something, like, 8:30 to 2:30, 8:33, something like that, with like, maybe 1 30-minute break, 2 15-minute breaks. And what the judge in that case told us through years of research, he's a senior judge, is he said if you look at the transcript pages, you actually wind up basically getting the same amount of words in that trial. But particularly for a lengthy case, the state said 4 months, not including jury selection. It just might make things more comfortable. So maybe if the court would entertain like an alternate schedule instead of just 9 to 5, that just might be something that makes everyone a little more comfortable, particularly the jurors. We're going to have to be here, for, I think the court said maybe 8 months. So, between 4 and 8 months. Something to think about, Your Honor. And I could.
When you say modified, you mean just a shorter day?
Shorter day. It starts a little earlier, ends earlier, fewer breaks in the middle. It tends to get things done quicker. And I was very skeptical of it when it was proposed to me in another case. And then actually another lawyer I know just finished a 2.5-month trial in federal court, and they went on that. I think it was Judge Patton went on that schedule, and the jurors apparently absolutely loved it. The court loved it. It just made things a lot easier. So something to consider if you would.
All right. Well, we'll see. Initially, the reaction was going to be 4 full days a week. We'd follow the APS precedent of taking likely Friday off to handle other business and let the jurors recover. And in terms of, a strict, we shall have a break at this point in the morning and that point in the morning. So far, I've found that jurors' personal needs don't really run on the clock like that. And so we kind of have to take the breaks where they come. And so we'll see. But the idea is going to be 4 full days, at least a week, when we start getting the evidence. But I just wanted to flag at this point that voir dire might be very different than what we've seen here in the courthouse before by necessity.
Well, yeah, we are aware of the case. I mean, I think the case law is pretty clear, Your Honor, when a trial starts. So we're aware of that issue. And we won't do anything to unnecessarily delay it. I do think it's important to pick up on. It's clearly going to be a challenge. I don't know that there's really anyone in Fulton County who hasn't heard of this case, and I don't know that there's anyone that doesn't have a strong opinion one way or the other about, the former president and the people who associated with him. So we recognize the challenges, and we will do everything possible to move as quickly as possible. Hope the state will join us in that.
All right, Mr. Wade, if you want to add anything, feel free, but otherwise, I'm just kind of going through some housekeeping issues here.
We have every confidence that the court is capable qualified to set trial schedule. We'll adhere to whatever the court is.
All right, I'm open to input anytime. All right, and then the last thing I would say is obviously seeing the new motions that have come in the door here that I will absolutely be hoping for some pre-hearing briefing on the supremacy clause. I don't think Ms. Powell joined on the immunity yet, but perhaps.
Not as of yet, Your Honor.
Yeah.
I do have that Brady concern I'd like to raise.
Right, well, that's what I'm aiming for. That's all I have. Mr. Rafferty.
Thank you. Your Honor, I've been in this case probably for a month. And on August 30th, shortly after I got into this case, I sent a very detailed Brady request to the government. Those Brady obligations, as Your Honor knows, are independent of their discovery obligations as it relates to this hard drive. They have a due process obligation to turn over to me favorable information. And I didn't send them some blanket request saying, give me everything under the sun. It was a very, and number two, that whatever happened in Coffee County, there's ample evidence out there that it was authorized. Okay, so I've asked for that very specific evidence. In response to my letter on August 30th, I heard nothing from the state. And so this week, I asked a copy of which I can provide to Your Honor, asking for very specific information, because I've spent the past evidence showing those two things, that Ms. Powell was not behind all of this and that it was authorized. I filed a motion last night that sets out all the evidence that I've been able to find on my own, which I hope the state has, okay? But the most important thing that I found, Your Honor, is a report by CN, a letter of invitation from Coffee County on January 1st of 2020. It was sent to another lawyer. What does that establish, Your Honor? Two things. One, what I've been saying since last week in my severance motion, what I said in my motion last night, what I'll keep banging the drum on, which is this was not Miss Powell. That's number one. But number two, that this was authorized. It was authorized, and I have asked for that. I have not asked for 8 terabytes versus discovery. This is a handful of documents. We got an email. But in August 30th, what I'm entitled to under the Constitution, due process, Brady versus information that establishes that Ms. Powell should not be in this case. They have it, Your Honor. I have a reason to believe they have it, and they don't even respond. I'm going to file. If this were in federal court, ordering that, they don't have a choice. Mostly in federal court with federal prosecutors who know that. I have concerns that
I don't know. Hold on, I'm here.
they're a Brady obligation. So I'm asking the court to order them to produce the two. That's my point, Your Honor. I'm concerned.
Yeah,
I raise
Brady
Your Honor.
material is
My motion.
story evidence, right? That will favor
everything have not funded us one page. That's correct.
You don't have to stand. I'll just point out, I think in terms of the timing of the motion and the way we try to keep things as on track as best we can, that we have the final drop dead date of when they're supposed to have gotten you. Everything that is supposed to be turned over And at that point, if you still don't have it, that motion becomes absolutely relevant.
I understand.
And the mean, things can be worked out among attorneys, but that's the idea. But note your concerns, and let's see what the state has to say, and then we might just have to leave it at that for now.
And my point is, Your Honor, this. There is discovery, which is covered in federal court, as you know, by Rule 16, by state procedures that are the equivalent. I understand Rule 16. I understand discovery. Independent of those discovery obligations are there constitutory information and to turn it over immediately.
Well, and there's no question. I think we're really just talking about timing.
And
right?
Your Honor, I understand. Even responded, acknowledging they have those obligations. They haven't turned over the information. I refined the request and specifically told them, these are the pieces of paper I want. I haven't even gotten a response to the email saying, okay, we understand. I haven't gotten a single piece of paper. I don't need 8 terabytes worth of discovery. I need the stuff that proves that she should not be in this case.
Respectfully, Judge, it appears as though Mr. Rafferty wants us not only to provide the information to him, but to spoon feed it to him. That information was provided this morning on the terabyte drive that he's been handed before schedule, ahead of time. The court sets a discovery or a pretrial motions order, a pretrial track for which the state has held true to. We have not violated any of the deadlines. What we're doing is trying the case is what we're doing. That's the attempt. They're putting in evidence and he's saying these things, trying to essentially try the case before it's time to do that. Discovery has been given to the other side to ahead of.
I could just point this out. Let me educate Mr. Wade for a second. As a former federal prosecutor and a state prosecutor, you do not satisfy your Brady obligations by turning over 8 terabytes worth of material and saying, go find it. That does not satisfy your obligations under Brady, the case law, and the Constitution. You are obligated to turn over specific information that has been requested. You can't just give me 8 terabytes and say, have at it and go find it. If you have it and I've told you what I'm looking for, you got to turn that over to me in that form.
All right. So I think we're spinning our wheels at this point. Mr. Rafferty, obviously on that specific point that they have to then kind of point to this and that and respond to discrete evidence requests, make that a part of your motion because I'd like to see the case law on it and we can take that up at the appropriate time. In the meantime, I think in order to, there's a lot that needs to be done between now and October 23rd. And I think the best use of our time isn't being in court here talking at each other. I think that acknowledging an email, replying back to it sometimes could prevent us from being here as often as we may have to. So to that end, I would encourage everyone to keep the lines of communication open and we'll take the motions up at the appropriate time. So anything else that we need to hear today? Okay. And this is something you already provided to the defense? Okay. All right. Well, when it comes to scheduling, I wanted to address this grand jury issue early on in the case since there'd have to be some follow-up investigative work. But I don't think we need to make this a weekly recurring thing for now. We could wait until the discovery deadline passes and the motions deadline passes and then start scheduling the rest of these hearings. So that's the plan. Yes, sir.
Scheduling. If it's possible, if we have to have a hearing next week, could we have it Monday, Tuesday, or Wednesday? That's my.
I know next week I'm presiding, and right now Wednesday looks mostly clear.
Thank you.
So that could be a date we could shoot for if there's some kind of emergency that has to be heard. Yeah, we could even try, Mr. Roy.
Oh, sorry, I was changing topics. Are you done?
That's fine. Yeah.
With regards to the scheduling order, I think there's a September 20th deadline. Traditionally, 1764 B1 says once we get to discovery, we have 10 days to respond. I guess if we got it today, could we have our 10 days starting now for me to respond? I don't know what the turnover is until I see what they have. Traditionally, how it works.
but I know we're on a compressed time schedule. Because if we all turned it over on the same day, it wouldn't really make any sense. I'm not sure what it is I need to, address as far as our case goes.
Well, I hadn't heard that one before. I think generally the intent of the scheduling order is that there is a mutual exchange by that date, and that if there is then supplemental discovery because it's newly discovered or newly becomes relevant in good faith, then it gets turned over within 5 days, I think is our general guideline there. So I think you, based on the indictment itself and the arguments we've had so far, have a pretty good idea what the state's case is against your client. And so I would think that you could turn over the bulk of your discovery by that deadline. If there's some follow-up things to be done and the state's unsatisfied with the timeline of when it's turned over, then they'll file a motion and we'll hear it.
I just don't want to be backdated. I don't want to pay experts if I don't need that based on what the discovery says. What witnesses they got it.
Well, experts will be classified differently. I think we also have a trial management order where we say experts are supposed to be identified and summaries of their reports. I believe it's 14 days. It might be 7. We'll take a look at that, but that's in a different category.
Traditionally the statute actually says once government gives you discovery, you have 10 days to do it or X number of days before trial. I just want to be able to go through however many terabytes there are. So I'm not sending the same thing they're sending me and wasting a bunch of time. There's only 3 of us on Mr. Chesbro's side. That's all I'm saying. There's no bad faith issues. I kind of sort of know what I need. But if they're going to call 150 witnesses, I need to figure out what the rebuttal is because I figure I'll sit through 140 of them and maybe cross-examine them in the trial. So I'll just watch movies or something. But, in the interim, I'm just trying to figure that out. So,
Understood. Well, obviously, like I think you've kind of already alluded to, if after this discovery deadline is passed, then you've got a smaller batch that you think now needs to get turned over, then do it. And it should be still I don't know about well in advance, but it should still be enough in advance.
It's just not new, and I didn't want you to say.
Sure. Well, and if the state has a problem with it, then we'll take it up, and then we'll just see what the arguments look like.
With regards to the more substantive motions, being the supremacy clause, the RICO, the justification, and there's First Amendment and the anti-SLAPP type motions coming as well. I think you've said that they will probably, you're right. I'm going to have witnesses for that, so if we could set that out, I can fly the people in. As it goes, that would be
Okay. So we'll, at the case management hearing, we're going to want to go into how many witnesses, how long you think each hearing is going to take, and then we'll start setting some dates.
And then the last thing is, depending on some of the rulings go, there may be some interlocutory requests or beyond what's through the jury selection of that because that stops the total speed from. Plenty of that may be an issue because some of these are somewhat case dispositive, at least RICO.
Understood. We'll take those up as they come.
Right.
Anything else?
Thank you, Judge.
Thank you all.
That's nice. That's nice for them to shake hands and act like a damn, act like he got some damn sense. You understand what I'm saying? That's crazy. That was off the chain right there. That was off the chain. Yes, honey. That was off the chain. I want to see. Okay. So okay, so that was a bit of a learning video. You learn a lot about the pre-trial preparations that go on, right? So yeah. Is it still up here? Now, what we got about another hour or so. Hold on, let me see. But so before I'm downloading all these videos, let me get back to this goddamn bozo with his lying ass. Right, and another thing, nigga, stop saying that you gave me some motherfucking goddamn chances and shit, and I backstabbed you, bitch. Every time you done something to me, what are you talking about? I ain't cross you or backstab you, your stupid ass. That was you, nigga. And then I forgot that I said, oh, the next I said when I came on here, because I hadn't been on here in a minute, prior to yesterday, you told that lie talking about. Now you heard me say if the issue about the defense fund was settled and you was clear, the people was clear, fine. Where is the indictment with saying that? What the indictment with the charges? Where's the paperwork saying that with your name on it? Now you come out here talking about, yeah, the defense fund got an indictment. Bitch, stop all that slick ass shit. And I can call you a bitch because I told you my shit is bigger than yours. So I don't know what's going on. I got some smaller bras I can let you borrow. And I got a few panties I can let you goddamn hold to steal in the package. Talking about the goddamn bozo. Stop fucking lying. Leave me out your shit. We don't refer to you as no motherfucking your name, nigga. Refer to you as the goddamn bozo because you like the striking shit and all that stupid shit. But when somebody take your ass out for playing they shit or fucking with their life, then you want to fucking cry. Stop fucking lying. Dumbass nigga. You don't have shit to do with no motherfucking R. Kelly no motherfucking more. All you do is lie. Just today, lied up the paperwork. Lied up the Officer A. Lied up the last lie. Lied up Trump. Lied up every goddamn thing. Stop lying. Your ass on some goddamn way. Nobody want to be fucked with nobody like that. You got a problem. A serious fucking problem. That's why nobody fucks with you. You ain't got no goddamn team. The only goddamn team you have is the one you motherfucking created. And let me tell you this, y'all ain't got the goddamn screenshot it, screen record this and all this shit. I'm doing it live. You ain't got to stir the motherfucking pot. Just a goddamn liar. Yeah, and that dirt gonna get on your motherfucking ass. Always goddamn lying. You ain't no indictment clearing on goddamn fucking defense fund. If it is, prove it. Crazy ass. Hold on, let me see. Okay, let me. Okay, we're gonna go to what happened with Nature Boy. We're gonna go to what happened with Nature Boy. Thank you, Kim. He's so sweet. Kim is so sweet. All right, I want to see Nature Boy. I never did see Nature Boy's sentence, so let me see that. Okay, this is the sentencing of Nature Boy.
Nothing during the trial. I would have been, I would have been inclined to exercise some discretion. Mr. Bishop shown any remorse, guilt, or regret throughout this process. And I saw nothing during the trial but for him laughing and coming up and looking shocked and surprised at all of the testimony. And Mr. Bishop, you're a master manipulator and probably the classic definition of a narcissist that I've ever seen. You took advantage of these folks who were essentially lost souls, looking for some guidance,
Oh, I'm sorry. Wait a minute. Hold on for a minute. Oh shit.
Testimony resumed today in the rape trial of an accused cult leader after a day and a half pause because someone tied to the case tested positive for COVID. But one person was trial from the DeKalb County Jail after he refused to appear in court beyond the first few minutes because of COVID. Fox 5's Tyler Fingert has been in the courtroom today. He is live at the DeKalb County Courthouse with the latest. Tyler.
Yeah, Christine, good afternoon to you. Eligio Bishop's concern about COVID was only one issue today. While his attorney presented his case, one of his witnesses was thrown out of the courtroom. Alleged cult leader Eligio Bishop's rape trial was briefly interrupted Thursday as testimony from a member of his group, Carbon Nation, went off the rails. DeKalb County Superior Court Judge Stacey Heydrich repeatedly told the witness to watch what he said, but as he wrapped up, he didn't hold back.
Also, Mr. Bishop,
You know what? He just lost his right to stay in the courtroom.
Prosecutors accused Bishop of raping a former group member nearly 2 years ago as she tried to escape and then posting revenge porn online. During the trial, the alleged victim talked about the group's online presence. Thursday, defense witnesses said it was an act for views.
They like drama, so we gave them drama so that we can slip the messages, so that we can slip the fights into.
One of the ways prosecutors say they did that is to slap each other. One member says that idea came from the Will Smith-Chris Rock incident, but prosecutors pointed out it happened after the alleged rape.
And you realize that Chris Rock slapped was March 27th, 2022, right?
I'm not aware of that.
So it was after this incident occurred.
Bishop wasn't in the courtroom for any testimony Thursday. Instead, he watched from jail after someone tied to the case tested positive for COVID earlier this week.
My client is standing on his objection as far as going forward with his trial. He is concerned for his health.
I want him here. Everybody else is here. Everybody else is fine.
And right now, closing arguments are underway. It's unclear if jury deliberations will begin today or tomorrow, but we'll keep you up to date every step of the way. We're live in DeKalb County this afternoon.
Day one in the DeKalb County trial of an alleged cult leader accused of rape. Eligio Bishop was arrested in April of 2022 after a former member of the Carbon Nation cult accused him of rape and false imprisonment and claims he posted sex videos of her online as revenge. 11 Alive's Tracy A. McPeer has been following this case for us. She just stepped out of the courtroom. And Tracy, you're joining us live now with an update.
That's right. It's been a very emotional day in court with opening arguments. Then we heard from the victim in court for the first time.
I wasn't able to go. I felt like I couldn't. I felt powerless. And he kept telling me that he wanted to do it one more time, just one more time.
On day one of Eligio Bishop's trial, the victim took the stand, explaining the power she says Bishop had over the members of his cult, Carbon Nation.
I was basically his disciple, and then he would make me his lover and take me and become his wife.
Bishop is facing a number of charges after the victim, a former member of Carbon Nation, accused him of rape and false imprisonment and says he posted sex videos of her online as revenge for leaving him.
What the defendant did with that time, the answer to that, the evidence will show, is that nobody said no to the king.
In opening arguments Thursday, DeKalb County prosecutors described Eligio Bishop as a power-hungry cult leader that abused his members.
And we'll hear that there was this atmosphere of fear and violence within the group, waiting for the other shoe to drop. Who was going to be next?
The defense claiming the sex and the videos were consensual and that she was able to leave.
She packed her bag. She was able to get her painting out of the storage.
The victim claims there were many rules in the cult and punishments for those who broke the rules.
When you disrespect Eligio, you would either go in the corner or do squats or be recommended or shunned.
Eventually, she says those punishments included violence and beatings from Bishop and the other members.
He used a belt, a leather belt, to whip her over 50 to 100 times.
The victim admits she was a member of the cult 3 different times. And as she was leaving for the final time, she told him no to sex repeatedly before finally saying, okay.
And how many times do you think he told you no before you said okay? You just had to.
I don't, so many times I couldn't count. He interrupts me and says, shut up. You're my property. You're not going anywhere.
Now, the prosecution also played clips of the sexually explicit videos that were posted on Bishop's site. It was one of the more disturbing parts of the trial so far. Now, this trial will resume tomorrow morning at 9. And
okay, so that's the one of the witnesses. Let me see who else. So I want to get the verdict. So let me get the verdict back up.
The video is on my laptop, it's not showing up on the desktop. Is IT still here? All right. All right, well, I can see Mr. Bishop. Do you have that link? I'm gonna, I think we need to log off and log back in. The connection on the screen that is displaying for everybody doesn't show all the, doesn't have everybody on video. Yeah. All right. You want me to end Zoom? Well, we're getting to see and try to figure out why people are, I can see them. I can see Kendra and Velvet and Solar and Aaron. Well, Aaron has a picture. I can see them on the laptop, but I don't see them on the main system. And the same with Mr. Bishop. Can you, if you can come in here, if you don't be able to see it. Yeah. All right, thanks, guys. Just hang tight for a minute. You see how I see here? You see what I'm saying? All right, yeah, I can see them. So are you guys okay going forward with just me being able to see them? Yeah.
You can the jail, the computer and screen that they're looking at, are they able to see the witnesses?
Are you able to see the witnesses in the jail?
I'm able to see 1, 2, 3 witnesses, and Aaron D is actually not visually seen.
Right.
But I can see the courtroom as well.
Okay, so you can see the 3 women and that like Velvet Marquez, Kendra, somebody's iPhone, and then Solar Ray. Can you see all that?
Yes.
Yes.
Okay. You can see the witnesses.
Just say that nobody feel going forward with this current situation.
All right. Mr. Booker, are you okay, or do you want to be able to see the witness? Okay. Restart. All right, we're just going to restart it. I'd rather have everybody. Yes. Okay. All right, we're gonna. The courtroom is going to disappear for a moment, I think. All right, and I'm still here. Let me turn on my video so y'all can see me. Okay, I'm still here, and we're just gonna reconnect the Zoom. I see now. Okay. So somebody, whoever's connected on iPhone, it looks like, are you driving? So I need to. This meeting is being recorded. I need you to pull over just so that everything is safe. I don't like folks zooming while they're driving. Okay. All right. Let's go ahead and get started. So, Mr. Ray. You can just find a place to sit. Okay, thank you. All right, go ahead, Mr. Kennedy.
Yes, Mayor, but we have evidence to state does have the testimony of at least 3 individuals who'd like to briefly address the court. I believe Mr. Morales still making that decision, but we'll go forward. Kendra, are you ready?
All right, you can unmute, please. There you go. And we swear in.
I will, Your Honor. Ms. Carter, please raise your right hand. Do you swear or affirm that the testimony you'll give the court today will be the truth, so help you God?
I do.
All right, you can put your hand down. Can you introduce yourself once again, please, for the record?
My name is Kendra Carter.
All right. Ms. Carter, what do you want to tell the judge if she considers what an appropriate sentence is for Mr. Bishop?
Well, I wrote something, but should I not read? You can read with if you want to read with. Okay. For the past 2 years, I woke up in the morning, relieved that it was just another night, and that I did not actually feel the call of carbonation under the control of Bishop. When I left home in 2017, 5 days after my 24th birthday, to join carbonation, I was excited to pursue a lifestyle focused on growth and community. Bishop said we have to be the change we want to see in the world. We are the ones that created this peace and harmony here on earth. And I believed him. At first, I felt empowered. I thought finally I found the answers to all of my life's questions. Finally, my prayers for a bright future have been answered. Never did I turn back to the trauma I was in some of the most beautiful locations in the world. But now I know he used the natural beauty of those places to attract young people who weren't fully aware of their own beauty and potential, so that he could exploit them. Under the guise of a spiritual journey, he inspired many of us to drop out of school, to stop pursuing our own passions, to cut off any ties to our identity, including our name, our family, and young children, and to trust only in what he provided for us. He knew exactly how to make every person he recruited feel special, like they had something great to contribute to the community. He love-bombed us, especially the women, so that he could slowly gain our trust. He waited until I trusted him and had to build a friendship with the woman he was with to lure me in to his tent with him, saying we would just watch a movie, while he came to take something that was so valuable to me, only so he could use it to hang over my head every single day. He said my soul belonged to him, and there was absolutely no saying no to him. I was trapped psychologically, emotionally, spiritually, financially, and physically, while Bishop went live regularly on social media to brag about his power and control over each and every one of us. He said he was God and we were his servants and slaves. As he continued to get more and more drunk off the attention and power, he saw himself as untouchable. No one was going to hold Bishop accountable, and so he would only drink bigger and more violence, while many of us under his control got sucked into the nightmare of his world. Slowly but surely, the lines became blurred, and he made changes to the rules and laws of everyone as he saw fit. Suddenly, we were bowing at his feet because he said it was for our own good. Then we were publicly shamed and humiliated as he made us relive our childhood traumas and traumatic memories, forcing us to talk about it on live streams for thousands of people to see. Finally, he controlled all of the relationships for his own sexual deviance. I'll never forget after me and my husband had a child, and he told us we couldn't be together. He made me move out of the room with my husband and child, and into the room across from him, against my will. And he told me because he broke my virginity that I belonged to him. I was his property, and I had to have sex with him. He would walk in as I was getting dressed and talk about me sexually. At that time, I was married and a mother to a 2-year-old and didn't care. He restricted me from seeing my husband and our child so that I couldn't, what he called, focus on him. That meant catering to his every need, whether that be helping him get dressed every morning, brushing his teeth, giving him massages, cooking his meals, doing sexual favors while he recorded video, and sending him nude photos of myself. What God wanted, we were required to give, no matter what. And we had to give it with a smile like we enjoyed it. I and so many other women there had no choice but to give up our own right to make decisions and disregard our authentic thoughts and feelings because he said that we didn't have our own mind and needed to replace our thoughts with his. There were consequences if we didn't listen and follow his instructions exactly At first, we were just instructed to do squats and push-ups, then it escalated to being isolated in the closet for days at a time, standing in the corner naked for at least 3 hours, and eventually he would introduce extreme verbal and physical punishment. After all these people coming to join his life since becoming the nature boy, and so members were forced to come, every single one of us was deceptively recruited. We trusted him and thought he had our best interest, and he knew this. No one volunteered to be taken advantage of emotionally, financially, physically, spiritually, or psychologically. I would have never joined Carbonation in 2017 if I knew that 2020 Bishop would order other women to beat me until I curled up in a fetal position in order to surrender. I would have never joined in 2017 if I knew that I would be forced to watch as he beat a woman in front of all of them on the 4th of July 2020 during a picnic in the park. I would have never joined if I knew that he would eventually separate us men from the women so that he could force every woman to have sex with him whether they wanted to or not. Or if I would have known he would be ordered to slap and jump others. Or if I knew that he would have the final say on every aspect of our lives, from food to clothes to where we could go or sleep or if we could take a walk or if we could leave the group, we would need permission. And that we wouldn't be able to go anywhere by ourselves. I never would have joined if I knew that. I would live in fear every day, not knowing who he would hurt that day, who he would order us to hurt, or if I would be hurt that day. All it took was for someone to have what he would call an attitude, or for them to slightly resist him. He often responded to any resistance from the women with whipping them with a leather belt over and over while he laughed and made the rest of us watch. He would make us lay flat on our stomachs while he walked around in a rage, taunting us, degrading us, kicking us, and stomping on us, beating us into submission. He said we were his property and that he could do anything he wanted to us. No one was coming to save us in these foreign countries. He said no one cared about black people, not anywhere else. If we told anyone, we would be disloyal, betraying Christ, society, we would be going against God. In fact, we should be grateful that we get to be in his body. He said no one else loves us like he did. He said he loved to dominate us and being able, the feeling of being able to hurt us. He said that if he killed us, no one would know. So I put myself every day to behavior in order to survive because my son is a mother. And I didn't know what to always needs to be another excuse to why we needed to be abused that he called discipline. He told us that we were doing it to ourselves, and if we ever questioned him, he made sure that we would never think to do that again, and he made me think, wow. Sometimes he would remind us all of the good times we spent together, all the beautiful prints we saw, like the waterfalls in Mexico and the beaches in Puerto Rico, all of the music we made and the celebrations and dances we had. He often guilt tripped us, even while he's in jail, he's trying to intimidate. For years, he gaslit us into thinking maybe he wasn't that. Maybe this wasn't so bad. It took months for me to stop blaming myself for the abuse and the sexual assault. With support from those in my life that truly love me, I was able to finally stop protecting my abusers and speak up about what happened to me and so many other young people. It's a shame even young children were involved as well, and not everyone made it out safely and alive. I never willingly joined a destructive sex cult, but in the end I learned that is exactly what it was. I, like so many others, wanted to make a positive impact in the world, not to be hurt, abused, and used, and exploited by a bishop. So many people have prayed for this day where justice is finally being served. And I thank everyone who heard us and who saw us, who fought for our freedom. Thank you. Thank you. Thank you so much. All right. Ms. Marquez, are you driving? Or are you a passenger? You have to unmute. Oh, sorry. Try it again. There you go. All right. You a passenger in the car?
No, I'm just sitting in the car. It's the quiet just for me.
Okay, no worries. As long as you're not driving.
No, you can raise your hand again. Do you swear or affirm the evidence of this the court today will be the truth, so help you God?
I do.
And put your hand down. Introduce yourself again.
I'm Velvet Marquez.
Velvet, did you want to address the judge that she considers the appropriate sentence for Mr. Bishop?
Sure, yes.
Please go ahead and let's start.
He's smiling.
First of all, I just want to thank you for your time, for your patience, because it was drawn out for a very long time. I'm counting years. And everything that Kendra just said, she put it in a nutshell. And moving forward from it all and trying to heal from it all and knowing that I was targeted from a spiritual standpoint, I literally had to get myself comforted so that I can understand what the Bible is, who God is, who Jesus is to me. I really had to unravel myself from thinking that an actual person was here as the second coming of Christ. And I know that may sound absurd to a lot of people because a lot of people have spiritual backgrounds, but I was searching for who God meant to me in my life at the time of Jordan. So now that everything is settling and I have 2 children of my own, it's an uphill battle every day because I've literally witnessed Ezekiel Bishop threatening to kill me and my child on multiple occasions. He said that my life is over if he had ever saw me again. So every day I wake up, especially with online social media calls from other people that follow him, they leave me deference as well. And one of the most recent ones I got was they couldn't that the person said that they would be sitting outside my home address just to take a picture of me and my newborn, just to put it on social media. So where I go, people know me because of this. They know the humiliation. Everybody saw the revenge report they put out of me and Kendra and myself. People have been public and it literally, I wouldn't even say destroy our lives, but at times it has literally felt like he was trying to destroy our lives, even through our own families. And what breaks my heart the most and that I have to be strong for and continue to be strong for is the children. Because the children were severely impacted by this. They will never know their fathers. Not only that, the men that talking about child, we now have to look at them and see them as another nation because, or illegal vision because they all carry some of the same behaviors. Courtney Thompson is the father of my child, and he has some of the same characteristics as illegal vision, and I have to now protect my family, my child, his child from himself. And these men around us, we don't know if we can trust them. I don't know if I can trust them. I can't trust the fathers of my children. And knowing that my child is going to have to grow up with me, and I'm going to have to explain to my child how, when, where.
No, still in there trying to be manipulative, talking to the officers.
And I'm glad that the verdict has come back to what it is what it's worth, because our lives will never be the same. My life will never be the same. My daughter's life will never be the same. My son's life will never be the same. I have to go file protection orders and do all of these things to make sure that I'm protected as a woman and child. That's not okay. You're targeting women and children at this point. And so the young men who follow Nature Boy, who follow Ezekiel Bishop, this is what happens to you when you harm people that's innocent. And I want to thank Kendra, and I want to tell you that I always thought she was a beautiful young woman, and so I have Brianna, and so have I and everybody else. It was the environment that kept me away because I said no. And I was being physically abused for it every single day. And the only reasons why I came back to combination so many times was because I was under the impression that we were gonna make it work for Eliana, our daughter, because that's what it was about. And it was about so much time that he had with Janae, and with Zoka. And it was about your child, Kendra, that you had with Aaron. And it was about your child, everybody's children should have been protected. And everybody should have been protected. And I'm just grateful for everybody who continues to support us and fought on our behalf to bring all of this to the light, which I'm really not surprised because Major Boy and Eagle Bishop have already put everything out for everybody to see. And so I thank everybody listening. And that's all I have to say.
Any questions? If you would unmute, and are you driving? I am driving right now. Would you be able to find somewhere to pull over? Yes, one second. Let's move on. Okay. Everybody's fine. I'm gonna mute you until you're, you find somewhere to park, okay? Okay. We'll call on somebody else. Yeah. Okay. Sure. Okay. You can stand.
Still trying to be manipulative.
Raise your right hand.
Let me see if I can get there.
I know how I am in my heart. You know how I am. I still love you. I still fuck with you. I still love you. I still don't hate you. Don't hate you.
Wait a minute. Let me see something. Hold on. Who was that?
Perpetuating generational curses, creating more situations for the children to have to recover from due to our current situations now. But I know there's a lot of power in something. I believe everything is best for everybody. I believe that everybody is going to find their way, find their life, however that looks. And I'm proud of you all. You are all very strong. Mr. Bishop, your life is in the dark. And you know, you already know your chart. You know, do your work, bro. Nobody's exempt. I'm not exempt, you're not exempt, nobody here is. Love wins, and you had me thinking that love was an loss. Love was something to do away with, and it was weakness. And it wasn't, bro. It wasn't. It's the only thing that's kept me here standing strong to this day. So regardless of how people view me to this day from what we've done, I'm on the road to my own soul redemption, and I'm willing to do the work that it takes for me to become the best version of myself, so that one day I can be the man for my children that I know I'm supposed to be, not the man that you were, and not trying to become a man like you or any man like me. And thank you for everything.
The witnesses and evidence.
And did your client want to be heard?
All right.
All right, Mr. Bishop. Okay. Mr. Bishop, do you want to be heard? Come on up to if you do, come on up to the podium. And we'll swear you in.
Each one of us is going to get the truth. For sure. At all times.
All right, what is it you'd like me to consider?
I just want to say something to all of them.
Well,
I just want to say.
Direct it to me, please, not to
I'll direct it to you. I'll direct it to you. Are you happy?
Any questions of yours, Mr.?
I forgive you. I forgive you, and I still love you. I forgive you, and I still love you. I know nothing in my heart. I'm not mad at you. I'm not upset with you. I forgive you.
Oh,
I want you to
Lord.
know I still love you and forgive you. And kiss my baby girl. Let her know I love you. And I love y'all. I would never, I know how I know. You know how I am in my heart. You know how I am. I still love you. I still fuck with you. I still love you. I still don't hate you. Don't hate you.
Is there anything
My
else?
heart, like it's a feeling. I promise you, I love you and I'm still with you.
Ooh.
I it's one way. I see what y'all doing, and I want you to know I forgive you. And I see y'all in the end.
Thank you.
I love you. I love you.
All right, I just needed the courtroom. We're done with that. All right, what is the recommendation of the state?
Just a brief.
Yes.
Yeah. I'm gonna have to speed through that because I'm losing time.
So with that, I am going to follow the recommendation of the state in this case. Rape, you'll be sentenced to life without the possibility of parole,
Whoa.
followed by 10 years consecutive for the false imprisonment. And on the internet porn, count 3, 12 months to serve, concurrent to the false imprisonment. The internet porn will run concurrent to the false imprisonment. Internet 5 years, that's 12 months on count 3, 5 years on count 4, and 5 years on count 5. All of that will run concurrent to the false imprisonment. But the false imprisonment is consecutive. So it's life without parole plus
10 years. Wow.
And hopefully you will never be able to take advantage of anybody else again.
So you be sure to go over his post-conviction rights within as well.
Yes.
And Judge, before, I know there were certain conditions, obviously, with the way the law currently exists in the court sentence.
Yeah, I'm gonna have to go because it's getting on the 12th hour. I sure appreciate y'all. I thank y'all for hanging out. Everybody's in the clouds. Everybody came on through, back to back. Honey, I appreciate y'all. Love y'all. But
All right,
we
Mr.
got
Bishop,
to
you're
go.
have absolutely no contact, direct or indirect. That means sending any of your followers to contact them, getting any messages to them, no posting,
Wow.
no internet posting about them, no contact, direct or indirect, no phone calls, emails, no nothing, no visits to their homes, nothing, zero. They don't exist anymore. And you are not to profit in any fashion from the crimes that you have committed. So no book deals for you, no movie rights, nothing. And also with respect to your appellate rights, you have 30 days, I believe, from today to file a motion for a new trial.
That's correct, and now I'm going to pay for trial
You have 30 days from the date of the sentencing, which is today, to file a notice of appeal or a motion for a new trial to preserve his direct appeal rights. He also has 4 years from the time that his conviction becomes final to apply for a petition for a writ of habeas corpus. Generally, a petition for a conviction is final when all direct appeal rights.
And they're just going over their timelines to file all the post-conviction relief, right? Because you have to file notifications by a certain time, 30 days, for the appeal. Notify them that you intend to appeal the decision, right? And you see they mentioned habeas corpus. Some actions in the post-conviction relief will toll the clock, right? Statute of limitations clock. Limitations clock, right? So they have a time frame to file all of that stuff, which this guy just went over
Okay.
for the judge.
What information and can you guys approach about that? I don't want to put this.
So with that, I am going to end it. I appreciate y'all. I will holler at y'all. And yeah, of course, this has been one of them combo lives, all over the place lives, but we do what we do. All right, peace, smooches. Bye, y'all.